Justice, where are you? Michael and Linda are here.
Love you, Linda.
The world is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and down, will I lead the way? Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
Well, good morning, everyone. I know you've been waiting here in a while. Just wanted to make sure everything was up and running properly. Let me just tell you that last night, if you have not watched Dr. Alain Gregoire, Alan as we call him, from England, who has the most amazing credentials, as you know, and has been doing women's perinatal mental health for I can't tell you how long, 40 years, because when he became an OBGYN doctor, he realized there was a need for it. Next week, as a matter of fact, he goes to Cape Town, Africa for a worldwide conference in it. And he also told me there are very qualified experts in the United States, one's particularly in New York, a Dutch expert she is right here in New York City right now, dealing with postnatal maternal health perinatal, I guess they call it maternal health. Let me make myself a little bit bigger while we're waiting for court to start here. Okay. And it was just amazing. Matter of fact, I posted some of the comments on Twitter. He didn't want to get into the specific case, but we got into the comments themselves about what the Commonwealth is trying to sell this jury. And I find it despicable, okay? Because it's so important to educate people about postpartum depression and postpartum psychosis with accurate information so that we can prevent this tragedy from these 3 young children dying again to happen some other time. And he talked about many cases that they have had before they started identifying what are the risk factors, who has the risk factors for it. And he says, if you are pregnant, he can go through your risk factors. He can tell you the actual time that you may have a psychotic event. And now it's that clear. What did he tell us? He said that the argument, these are my words, that the argument that the Lindsay Clancy experts are advancing at PPP, he didn't say related to her, but he just said the argument is completely false that you could only have PPP within 2 to 4 weeks or 6 to 8 weeks. It can be up to a year. And usually what happens is the symptoms of the psychosis have started within a very early time, but you don't notice them unless you know what you're looking for, unless you have the proper medical care and the proper doctors. So just because the psychotic event happens 7 or 8 months later does not mean that the psychosis hasn't started to creep in. And if you know what you're looking for and how to treat it and what medications to put the person on and how to watch the person, that's when you realize you have a woman who is in danger of having that psychotic break. And not every woman have it. One or two women in every 1,000, but that's a lot. I talked about a case in England where a police officer actually killed her child. And in England, they have what they don't have here is they have residential stays where the mother and the child can stay while they're treating the psychosis, so that you're not separating mother and baby. Whereas in the United States, we don't have that. And all. He says that in his conferences, what he's learned is that people in the United States say that's too expensive to deal with. Okay. Makes sense. PPP is recognized worldwide up to a year after giving birth that you can start. Why? Even though if you can start the symptoms earlier, may not know it, or it can happen. It's unusual, but it can happen up to a year that you start the PPP and all and have that break. The break, by the way, does not just last for a minute. Just because you're doing sequential things or things that you have to think about, such as the experts here are saying, well, you walk into the basement, you bring either child into the basement, they're trying to paint that gruesome picture. That does not mean you're not in psychosis. The psychosis can actually last for hours or days or weeks, okay? It doesn't just last for a minute that you kill your children. It's still there. The psychosis is still there, which is why telling different facts, all right, and having different facts from other people or different facts from yourself at different times is a hallmark, he said, of postpartum psychosis. It's a hallmark of it. So just because, for instance, my words, Lindsay Clancy says she did this, she made a phone call, or she was drinking lemonade and somebody else said she's drinking wine, doesn't mean that you are lying, because the different telling of the stories and the different stories are a hallmark of the psychosis, specifically in postpartum psychosis. Okay, dealing with, and he says doctors are always dealing with psychosis, but postpartum psychosis is a specific type of psychosis that you have to be available to treat. And that PPP is not bipolar. It can have components. They both can have components, and they both can exist together. And maybe people can assume that bipolar is PPP, but PPP is a separate, and as they view it in England under the World Health Organization, as how they treated it, it's a separate disease from bipolar. And it can have bipolar, and they can exist together. And people who have bipolar are at a greater risk for getting PPP. So you can have this coexistence, but they're separate diseases and have to have separate treatments, and you have to know what you are looking for. So he was very informative. He didn't want to get into the specific facts of Lindsay Clancy, and we did not, because he did not know, it's not following it. So we asked him the questions that clearly the Commonwealth experts, including this Dr. Satoff, who is an FBI behavioral analysis unit, and what has he seen women who've killed their children in prison. I mean, it's interesting that the two doctors that were brought on by not Dr. Mack particularly, but the last two doctors have, well, I could say Mack too, but have dealt with women in prison. Okay, so they're dealing with a different population. All right, so as we wait for this, I would tell you to go look at this, and I have put it in our X account completely. Let me see if I can quickly bring up. Let me see if I can quickly bring up the link to Dr. Gregoire's visit with us last night. Yes, I can. Fortunately, it was in my ear. Let me bring up that link. All right. And if you get a chance and there's a break, we're going to actually play that link starting from, and I'm telling Joy, as we're having a production meeting on air, as we bring up Dr. Gregoire from that link so you can listen to it, because it is so informative. And I think the fact that the prosecution, the Commonwealth, is advancing these concepts before this jury that are absolutely medically untrue is setting back what in the world we've been trying to deal with, was understand postpartum psychosis, postpartum depression, what the treatment is, et cetera, et cetera, et cetera. And it's just unbelievable when we listen to him about the concepts that the prosecution is trying to say show that Lindsay Clancy is a liar and did not suffer from postpartum psychosis. And by the way, the idea that you have to have the suicide, that you decide you're going to kill yourself, unalive yourself, and then you bring the kids along with you as being something that means that it's not postpartum psychosis is ridiculous. That's another thing we learned. That's ridiculous. It's simply just not the case. The point is that you're in psychosis for what your thinking is and what you're planning to do. All right. So yes, can you have different motives, but that does not make you out of the psychosis that occurs postpartum. Okay. Let's face it. And we've learned that, she yesterday we learned a different fact, that she had some mental health issues beforehand when she was going to nursing school. Now, what the prosecution with Dr. Satoff wants to make sure she lied to her husband. She didn't tell her husband she was given drug prescriptions before. Well, he wasn't her husband then. She was dating him. And quite frankly, I find it offensive that you have to, okay, here I'm going to date you. Let me lay out all my history until we become, husband and wife. I'm laying out all my history to you. What kind of nonsense is that? I mean, unless you're a robot, all right? You're not living in the real world, right? Okay, I'm gonna date somebody and I'm gonna lay out all my medical history or my mental health history to the person I'm dating. Are you kidding me? Are you kidding me? But what it does tell you that she's at greater risk because she has had issues in the past. The more issues you have in the past, the more children you have, the greater risk it is that you could have a postpartum psychotic break. I would love to have had Dr. Gregoire evaluate her beforehand and see what it is. And remember DeAndre Yates' case, the fifth child, she had been hospitalized and she was having mental issues beforehand and depression. And the fifth child set her over the edge and caused the postpartum psychosis. And then she killed all children. Well, the fact that you may have some mental disease in the past, the fact that you may have had some depression in the past of having children and feeling overwhelmed, that can contribute to the factors that they may look for to see if you are at risk. But he said, They can evaluate a patient now, and they can tell you exactly if they are in risk of for getting postpartum psychosis, and if they are, the actual time that it will happen. Can you imagine that? And here we have these experts who are not experts in postpartum psychosis. They're not experts in perinatal mental health. Okay, they're just not. These are not experts in perinatal mental health that the Commonwealth is giving you. It's pablum, in my opinion. All right. So we went and found the expert in the world. And sometimes members of his team have been on here afterwards, Dr. Gregoire. Now, unless you're looking for that and you're looking for an objective opinion, you're not going to find that. But if you're looking for someone who's going to say that Lindsay Clancy knew right from wrong when what she was doing, this is what you're going to get. You're going to get somebody who's going to, that are going to say, and they're going to use things that they may use to try to see whether there's a terrorist. Oh, did the terrorists lie about this? Did the terrorists give a different story about this, and therefore they're lying? Well, this is not a terrorist. This is a woman who was in great psychological need. This is a woman whose psychosis probably was inching up and starting along the way after she gave birth, but didn't come to the fruition of the full psychotic break, which doctors said could happen like that. Okay. She could be perfectly fine. She could be happy, building a snowman, cooking dinner, everything. This is my words. But the person can be terribly happy, terrific, doing all sorts of normal things. And then because she does have that psychosis in there and she does have those issues in there, the break comes like that. And it can happen within the first year, okay, at any time, even if you didn't have the psychosis beforehand, which she probably did, and it was probably not being recognized properly and not being treated properly. And with regard to taking medicines and not taking medicines, again, that's a hallmark of the mental disease or defect. That you have to monitor the person. They have to be strictly monitored to make sure they are taking the medicines, and that the medicines are good for them, because you can have effects of the medicines that happen right away, and then you have to change off the medicines. So what we're seeing here is a complete breakdown. Number one, we know of the mental health medical system dealing with women with perinatal mental disease. All right. And now we're seeing this, in my opinion, exacerbated in court, quite frankly, by bringing to the jury and bringing to the public, with all the trolls out there, information from these doctors that is simply not true. Everything that they're saying is a hallmark of postpartum psychosis. It's not a hallmark of somebody lying about why they killed her 3 children. Remember, she killed her 3 children and then took a swan dive on her head out the window. Is that normal behavior? Absolutely not. And you know it, and I know it, and you know it, and I know it. How many times she was trying to get mental health, and she was trying to get someone to recognize it, and they weren't giving her either the right prescription, they weren't monitoring her properly, and they should have been. She should have been under incredible monitoring, because we knew, or Dr. Gregoire, if he had seen her, probably would have figured out she was under great risk for having a psychotic break. All right. And he wanted to make sure everyone understands it's perfectly treatable. It's perfectly curable. You can cure it for this time. That doesn't mean that it's not going to happen again if you decide to get pregnant again, all right, which is an issue. But it's perfectly treatable and curable if you're getting the right help. So women should not be fearful of getting help. And he said, yes, women are fearful, because apparently in this country, they, you call and the baby gets maybe taken away. In other countries, such as England, the mother and baby are, if there's a real danger that the psychotic break is going to happen, and they kind of know when it's going to happen, if it's going to happen, you end up in this residential facility with your child together. You're there, and they treat you, and they monitor you. So you don't have to have what women are afraid of. So I beg you to go look at that episode. We have 2 of them with Dr. Gregoire. The first time he was on was a week ago, last Monday, from England, when we first got to know him, and he gave us a whole history of postpartum psychosis and perinatal mental health, and all of the doctors. There are doctors all over the world that are experts in this and treat this, and yet the Commonwealth can't bring you one in this this trial. Not one. And this is what I am so annoyed about, because I think if you are dealing with an issue as important as this is, you shouldn't just want to win. And that's what's going on here. They want to win. And they're playing on what they think is the public and any juror. And there could be a juror in there that says, well, I don't care, she's got to pay. I don't care, she's got to pay. Or they may start parsing out, was death 1 in postpartum psychosis but not 2 and 3, or is death 1 and 2 in postpartum psychosis but not 3? That's garbage too. If you're having the event, okay, it's lasting. It happens until something tragic happens. And usually what happens if you're not treated properly is the mother ends up taking her own life. All right. And it's exactly what's going on here. It's exactly what happened here. Anyhow, please, if you want to educate yourself, please go listen to this episode. And he did give us the name of someone in New York, but I beg to call on a lot of these experts free here, because we're not paying them to come on. We're paying them to try to educate, and Dr. Gregoire has done nothing but try to educate and develop procedures and protocols for dealing with women who are in danger of postpartum psychosis. All right. He also treats, obviously, postpartum depression. His whole umbrella is perinatal mental health, perinatal mental health. Okay. And so that's what we're talking about here. So when we go listen to Dr. Sadoff, who I hear some people, oh, what a great expert, well, I don't find him so, because he shouldn't be there. And Mr. Reddington was absolutely right that this expert should have had a Daubert hearing. I see Daubert hearings on experts all the time that are much more qualified in their positions about whether or not their methodology is appropriate. And the methodology here is one, what he's going to say. Is he going to say? He can't say, by the way, he can't say that the methodology of telling different stories is a hallmark of a diagnosis of PPP. Well, he can say that, but he won't. He's going to say it's just a hallmark of somebody lying. That's what he's going to say. We see it coming. We know what's happening here. All right. And I think it's also outrageous for him to decide to take this case. He knows he's not an expert in postpartum psychosis. What he's going to do is give you the classic, well, they lied. They told different stories. If their recollection wasn't good, it's because I believe they were purposely had a different recollection. And what did he use about recollection not being good? If Lindsay Clancy said one thing, and then he went to Patrick, the man, and he said another thing, well, the man is obviously right. And the man is the person we believe. Talk about gender bias, right? He may be the best expert in the world for dealing with mass murderers, terrorists, and all. But this is simply not appropriate, FBI. It is not appropriate to put him there, okay? This is simply not appropriate. And quite frankly, I think if we're really talking about, if anyone cares about women's health, there should be a backlash about this, all right? At least the psychologist was trying to work off tests, although he went out of his arena too, because he was not a perinatal mental health expert. Google perinatal mental health psychiatrist. You're going to find them. And the doctor, as I said, talked about one right here in New York, a leading expert. She's Dutch. She's here in New York right now working in perinatal mental health, and will tell you exactly what Dr. Gregoire would tell you. They have this whole maternal alliance worldwide for mental health. This whole maternal alliance where people are joined and doctors are joined. I will guarantee you that the prosecutor's office never went to them to say, please, do you have an expert in postpartum psychosis and perinatal mental health who can look at this case objectively and tell us whether she was having a psychotic event? No, they didn't do that, because you hear again, oh, it could only happen in the first 4 weeks because that's what the DSM is. And what Dr. Gregoire explained, if you do check marks, if your diagnosis of diseases is by check marks like the DSM, let's check this box, let's check this box, let's check this box, let's check this box, then you miss everything with regarding to postpartum psychosis, because while there's certain hallmarks, you're not going to put it in unless you demand it meets every single checkbox. You're not going to have a separate category for it, because that's why they don't use the DSM, because it's a check mark situation. It's by the American Psychiatric Association. Check mark, check mark, check mark, check mark, check mark. Oh, by the way, but if you want to talk about the hallmarks of postpartum psychosis, what we have heard in that courtroom, exactly from what Dr. Satoff is going to be using to say she's not in, is exactly the hallmark of postpartum psychosis. Now, I feel that I know more about postpartum psychosis than Dr. Satoff at this point. Researching it and listening to Dr. Gregoire and reading some of the many materials. I know people were posting articles from Harvard Medical School last night that again talked about postpartum psychosis can happen within a year. And the way Dr. Gregoire explains it, if it's 8 months, usually that's when the psychotic event happens. But that doesn't mean that you don't have a postpartum psychosis that's there brewing, okay, under the surface, and you may have been in and out of it, and people don't know, and because they don't know what they're looking for. Maybe maybe those psychotic thoughts, or you wanted to kill your kids, was a psychotic event, and all. And with regard to the command voice happening on one day, easily, that's again something he debunked. That can happen. Just on one time, because it depends how strong the voice is, and it depends how susceptible the person is. If they've been having diseases, and they've been having effects, and they've been having all sorts of issues for 8 months with it, then when the command voice comes, boom, you listen to it. And if it's a strong command voice, you listen to it, because you had all these issues that built up. So everything that the DA is advancing to you is false. And I'm going to say that is false. And if the jury falls for it, quite frankly, it would be an outrage. And I think they have to look at themselves. All right. And if you're listening to me, look at yourselves, because you should be wanting to tell the truth here and not wanting to just put somebody in jail because you want to have another check mark on your bow. All right, let's go into court and let's listen. I would hate to have this start because I don't hear any beeps. So, Joy, do you hear any beeps for the sidebar? Because I don't hear any. Let's see. Nothing here. Let me go. If I listen to Law and Crime, I also have their sound up separately and apart, and I don't hear any sound from them. So I guess I could say that is good. I guess I could say that is good. Pulling in the streaming here, the sharing tab here, but I'm not hearing anything. So let's see. Michael Bryant, by the way, I don't know how long the line was, or today he was going to court. Let's see. He hasn't posted on X yet, on Twitter yet. He has not posted on Twitter yet. I'm have it up there. I have it in my lap. All right, now I'm concerned. There we go. I'm gonna remove.
All right, brothers and sisters.
Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court now sitting in Plymouth, within and before the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
All right. Well, thank you, Madam Clerk. Good morning, members of the jury. All right. It's nice to see everybody once more unto the breach, as they say. We're going to continue with this trial. So I appreciate everybody being here. I'm going to ask those questions, and I'll go a little bit into today's schedule and kind of where we're going to go on this. So first question, has any member of the jury read, seen, heard, or overheard anything from any source about any aspect about this case that would affect your ability to be fair and impartial? All right. Second, is there any other serious matter or concern bearing on your service as a juror in this case that anybody needs to address at this time? Again, thank you so much for following those instructions. And so what we're going to do, as I said yesterday, we're going to continue with the testimony of the doctor who was on the stand yesterday. And it's anticipated that that is the last witness in the trial. And then we will then take a break, because before we go to the next portion of the trial, which is the closing arguments and the legal instructions, the court has to make some arrangements. They've got to speak to counsel. So it takes a little while. So I'm going to excuse you at that point and have you come back tomorrow. All right. So we're going to finish the evidence today. We're going to excuse you. I'm going to then deal with counsel. And then we will do, hopefully, arguments in charge tomorrow. All right. So again, I can't tell you how much I appreciate everybody's dedication and commitment and following those instructions and being here every day. So that's kind of where we are at this point. All right. And so with that, I'm going to ask the Commonwealth if you could have the doctor retake the stand, please.
Yes, Your Honor.
Stop right there with your right hand to the front, please.
Your Honor, do solemnly swear that the testimony and the evidence you shall testify before the jury and that now coming between the Commonwealth and the defendant shall be the truth, the whole truth, and nothing but the truth. Thank you, sir. You may be seated.
Watch your step, please.
All right. Good morning, doctor. Good morning. All right. Attorney Sprague.
Thank you, Your Honor. Good morning.
Good morning.
Yesterday, when we left off, you were testifying about the decision-making process of the defendant and what she told you about that. Going to what she told you about the voice and what it said to her, did the defendant tell you if the voice told her where to kill the children?
No.
Did the voice tell her how to kill the children?
No.
Did the voice tell her what to use to kill the children?
No.
Did the voice tell her in what order to kill the children?
No.
Did the voice tell her where to try to kill herself?
No.
Did the voice tell her in what way to kill herself?
No.
The fact that the voice, according to the defendant, the voice didn't tell her any of those things, but instead just said, kill the kids so you can kill yourself. Is that significant in your evaluation in any way?
Yes.
How so?
Well, in the small amount of time that Ms. Clancy had in the home without her husband, it was important in order to carry this out, as well as her suicide, to do this quickly, methodically, and the like. And so this is having no instructions as to how to do it, but being able to execute those decisions, including being able to get a phone call and then return it to her husband in the process of all of this. Certainly the phone call was not expected. That is surprising that she was able to accomplish all of this without any other kind of direction or plan.
Does that indicate to you that she was making decisions about those things, about where and how and when?
Your Honor, this is, again, for the record, direct examination is leading by objector that have a standing objection.
Yeah, if you could just rephrase that.
What does the fact that she was able to do all of that indicate to you, if anything?
Well, it indicated that she had control of the sequence of what she was doing throughout.
Doctor, you talk in your report about interpersonal psychological theory of suicide. What is that?
Well, that has to do with the decision-making process or the capability for someone who attempts suicide.
And are there 3 parts to that theory?
Yes.
And what are they?
Well, one would be called aloneness, or the sense of isolation, people not understanding. So that is a real difficult challenge for people to face. They feel that they can't fully share with others. Another is burdensomeness. If someone feels that they are a burden to others, that is also something that we find is a component to those who make serious suicide attempts and completions. And third is what I would call capability. So you can have that sense of aloneness. You can have that sense of burdensomeness. But if you don't have the capability of taking your life, you can be very suicidal, but not ultimately accomplish the suicide. It does not mean that you're not suicidal. But that issue of capability is one that's very difficult, because we have a natural will to live. And that is the most difficult thing for people to overcome.
The thing that's the most difficult thing to overcome, that's the capability of actually committing suicide. Is that what you're saying?
Correct.
And this theory in the 3 parts, did you compare what Ms. Clancy told you and what you saw in the records to this theory, and have any conclusions about that?
Yes.
And what were they?
Well, certainly, the documentation from the medical and mental health records demonstrates that sense of isolation she felt, even in the company of others. That sense that she was just having a problem that was difficult for her to understand, difficult for others to understand. And of course, the suicidal feelings that came about, and then ultimately those feelings about harming her children. This is not something that she could share. The sense of burdensomeness, she had planned to go back to work, as she had for her first 2 children, Cora and Dawson. And the time that she was expecting to go to work kept extending, because she just did not feel mentally healthy enough to be able to return to work and to function. And so in some of the documentation where she filled out concerns and was asked about the kind of stressors in her life, she indicated that financial was one of the stressors that she was encountering. So to believe that her brain had been damaged, that she was not able to do what she loved, which was labor and delivery nursing, but also not in a position to help support the family, really was would be a burden for anyone. And certainly that sense of burdensomeness was something that I believe she was experiencing. And then the last component, capability, I truly believe that her suicide attempt was very, very serious, which is why she employed 3 different methods. The fact that the use of the knife and the lacerations were not deep doesn't mean that she wasn't intending to kill herself with a knife. But oftentimes that, as I mentioned, is the most difficult thing. I think the employment of the 3 different avenues, locking the door, and also not being dressed for the cold, indicate to me that this attempt was very, very serious, despite the fact that the use of the knife was not successful in cutting her arms, cutting her neck.
And so, doctor, in terms of the cutting on the arms and the neck not being sufficient to cause death, is that what you're referring to? Is that as someone faces difficulty or an inability to be capable of actually following through to commit suicide?
Correct.
So in this case, it's your opinion that she was trying to commit suicide but struggling with that 3rd capability issue?
Correct.
Now, you testified yesterday about the intrusive thoughts that Ms. Clancy was having about harming herself in the fall leading up through December into January. And those thoughts at times, would it be accurate to state that Ms. Clancy reported at times that taking Ativan helped with those thoughts?
Yes.
And was there anything significant in your review of the case in terms of her reporting that Ativan helped her with those thoughts?
Yes.
How so?
So Ativan is lorazepam, a benzodiazepine. This is a medication that is very helpful for treating anxiety. It also can help relax people, help them sleep, which was very helpful to Ms. Clancy. And she stated that when she had the intrusive thoughts, taking the Ativan resolved those thoughts. And I think that's significant because it's not a medication. Ativan, lorazepam is not an antipsychotic medication. So it's not meant to treat psychosis, make people feel more calm. And sometimes it's used for people who are having significant symptoms. But in terms of actually treating psychosis, making a voice go away, it's just not designed to do that.
And doctor, did the fact that the intrusive thoughts went away when taking the Ativan, according to Ms. Clancy, give you further evidence that it was in fact internal thoughts and not an external voice?
Yes.
Now, if someone is experiencing psychosis and is experiencing command hallucinations, can that person still know the difference between right and wrong?
Yes.
How so?
Well, hallucinations, even command hallucinations, when they occur, do not propel an individual to automatically obey them. And in fact, many people will engage in behaviors to stop the actions that the voice is claiming. That's something that makes sense, particularly when the command is just so serious and so against someone's values. So it's possible and common for people to engage in behaviors to avoid doing what a command hallucination is saying.
And doctor, is it possible for someone who is experiencing psychosis and command hallucinations to conform their behavior to the law?
Yes.
And how so? Is it basically what you were just telling us?
Yes. If someone is having a command hallucination to do something out in public, but there is a police officer nearby, it certainly is possible for that person to choose not to engage in that behavior because of the consequences. Even though a voice might be saying this, there's other decision-making going on based upon the environment.
Now, doctor, in your evaluation of Lindsay Clancy, did you come to an opinion to a reasonable degree of medical certainty as to whether or not she was suffering from a mental disease or defect on January 24th, 2023?
Yes.
And what was that opinion?
I believe that Ms. Clancy was suffering from a mental disease or defect, and I felt that based upon the presentation, a bipolar II diagnosis seemed to make the most sense given the symptoms of insomnia that she had that were precipitated by the Zoloft. And this was just very, very significant. And while it didn't fulfill all the criteria or many of the criteria, if she were a patient of mine, I would diagnose her as bipolar II, because I would want to make sure that any doctor who saw her afterwards would be very wary of using an SSRI antidepressant in treating her.
And doctor, you mentioned the drug effects, Zoloft had an effect, and SSRIs might have an effect. Is there a difference when you're treating someone and they're taking medications between being over-medicated and having an adverse reaction to medication?
Yes.
And what is the difference?
Well, when we think about side effects, that is an example of a medication having a response. Now, sometimes we have side effects when we're not necessarily over-medicated, but we put up with those side effects. When there is too much medication, certainly we can experience those side effects. For example, over-sedation, or there are some medications that can cause stimulation, so people are not able to sleep. An adverse reaction is much more serious. An adverse reaction could be, for example, an allergic reaction that could cause death, or some type of reaction that you don't see in most people, but has been reported. So there is a difference between side effects, no matter how difficult they are, and what we would call adverse effects, which can be extremely serious.
And in your review of the records of the medications that the defendant was prescribed from September through December, did you see any evidence of her having adverse effects from the medication?
Well, the insomnia secondary to the Zoloft was very concerning to me. And it would mean not just cutting the Zoloft back, but stopping it. I would say that the Zoloft was in precipitating insomnia. I mean, she reported 48 hours straight of not being able to sleep, that was an adverse effect. And an adverse effect really requires one to stop the medication.
And that is what Dr. Jennifer Tufts did with Ms. Clancy, correct? She had her stop the medication?
Correct.
And in reviewing those records again from September through December of 2022, did you see any evidence that Ms. Clancy was over-medicated?
She experienced some significant side effects from some of her medications. She was given, I think, nurse practitioner Paul gave her clonazepam, which is also a benzodiazepine, and she really had an uncomfortable reaction to that. Just woke up and felt quite confused. So she stopped that medication, understandably. Seroquel is a medication, quetiapine, that at high doses can cause some significant side effects. At lower doses, it generally helps treat insomnia. At higher doses, it can have more significant effects. And in terms of just ability to think and organize one's thoughts. However, Ms. Clancy, in December of 2022, chose at that time to continue on Seroquel, a combination of Seroquel and Valium. Nurse practitioner Gelada had suggested another medication, olanzapine, Zyprexa, which she's taking now. And Ms. Clancy asked that she continue on the Seroquel at that point and the Valium. So, it's a challenge. One has side effects, but one also sees benefit in the medication. And certainly that combination at that time, I think it was around December 7th, December 9th, that was really helping her sleep. And so she asked to continue on those two medications.
So I guess when I ask about over-medication and you talk about the side effects of the medication, there seems to be a disconnect between maybe what a layperson calls over-medicated versus what the medical definition of that is. So is what you're saying that being over-medicated medically means having side effects to the medication?
Well, no, not necessarily.
So what does over-medicated mean to you in your profession?
Well, if someone were to prescribe a medication that was beyond the limit that safely can be prescribed, for example, it's possible to be toxic on, say, lithium, which is a medication that she took for a while she was at Tewksbury. And if I were prescribing, say, 1,200 milligrams of lithium twice a day, and her lithium level was toxic, as it would likely be, that would clearly be an example of over-medication.
And did you see any evidence of that scenario in the defendant's records that she was prescribed too high a dose to make her be at a toxic level of any medication?
I think those who were prescribing for her were responding to the symptoms that she was bringing. There was a kind of a rapid increase in the dose of Seroquel, and that higher dose of Seroquel was she didn't. I believe she was ultimately prescribed at 400 milligrams, and she ever ended up taking that, but. As a clinician, we do our best to try and treat symptoms.
So, doctor, did you see?
question.
Doctor, did you see, other than the Seroquel, any medications that the amount that was prescribed you would think would be over medication?
No.
And then the Seroquel itself, you said she was prescribed up to 400 milligrams, but she reported that she never took that amount, correct?
Correct.
And after her stay at McLean Hospital, she had been weaned off of the Seroquel, correct?
That's right.
And the only medications immediately after leaving McLean Hospital were trazodone and Valium, correct?
Correct.
Dr. Tufts added a medication as a result of her appointments with the defendant in January. Is that correct?
That's right.
And what was that medication?
That was amitriptyline, also known as Elavil.
And you saw that what the initial dose of that was, correct?
Correct.
What was that?
The initial dose from Dr. Tufts was 10 milligrams.
Is that a high dose for an adult?
No, it's the very smallest dose possible.
And then did Dr. Tufts increase that dose?
Yes.
And when was that?
After a week, she increased the dose from 10 milligrams to 20 milligrams.
And is that a significant increase in the dose?
No.
Is 20 milligrams a significant or large dose for an adult?
Not at all.
10 milligrams or 20 milligrams of amitriptyline, is that something you could even prescribe to a child?
Yes.
Now, doctor, based on your review of all of the records and your meetings with Ms. Clancy and your collateral interviews, did you form an opinion to a reasonable degree of medical certainty as to whether or not Lindsay Clancy on January 24th, 2023 could appreciate the difference between right and wrong?
Yes.
And what was that opinion?
My opinion is that she did have the capacity to appreciate right from wrong.
And what do you base that on?
Well, on a number of things. Ms. Clancy had just met with her psychiatrist, Dr. Tufts, the day before. And in that discussion with Dr. Tufts, as documented, she denied suicidal ideation, and she also denied thoughts of harm to others. And also there was an ongoing conversation regarding future possible treatments, esketamine or TMS, which I spoke about yesterday, that could be employed to help her. Also, with regard to the appreciation between right and wrong, the planning involved prior to the strangling of her children, I thought was significant. The searches for distance of 3V, the searches of CVS, all done prior to her sending fairly late in the afternoon a text asking her husband if he didn't mind takeout from 3B and then adding on. So that planning, that preparatory planning, I thought was significant. The avoidance of witnesses. You know, a witness during a time when one is committing a crime can intervene, not just report, but also intervene. And so the fact that this was done without any witness present during a time where she had asked the potential witness to go on a longer errand, also I thought was significant. Concealment is another thing that I think indicated an understanding of right and wrong. I mean, the children were strangled all in the basement. And according to Mr. Clancy, the door to his office had been closed when he arrived to the basement. Timing was really, really significant in this. There was a window of time that Ms. Clancy was aware of in which she would need to kill her 3 children as well as to kill herself, which she expected would happen. She was conscious of time and told me that she had mapped out the distance, et cetera, because she didn't want her husband to be gone too long. But in this case, I think the issue of time and her husband returning, rather than being a solution for her, was a problem. And so to accomplish all of this in the course of that amount of time that Mr. Clancy was gone, I thought was significant, really showed an awareness of time. In terms of the weapons used, now these were exercise bands, but they were all near where the children were strangled. They were placed there. That's where they kept those exercise bands. And the exercise bands were nearly identical. I mean, very similar in terms of what they could do as ligatures. And so that use of weapons that were readily available and nearby also was significant to me in terms of her understanding of and planning. I did not see any evidence that she had delusions about her children, delusions as to something wrong with them or something that required them, because of a delusion, that they needed to die. I don't recall that she ever spoke about her children in a delusional way. Now,
Look, we have a question.
Sure. Next question.
Were there other factors that influenced your opinion that she knew the difference between right and wrong?
yes.
And what were they?
Well, the phone call at 5:34 in the afternoon, I thought was significant. So Mr. Clancy was at CVS and he called his wife, and she did not pick up. She did not answer, but she called him back and had that ability to deviate from what she was doing to be able to respond, and so had the presence of mind to do that, but also to conceal from him what was going on. Locking the door is another example. I mean, certainly Ms. Clancy was aware of time and the limited amount of time to accomplish this, but by locking the door, it kept her husband from being able to enter the bedroom and therefore being able to see what had happened. So delayed that time. On arrival, her husband asked her what happened, and she did not confess. She did not tell him what had happened other than, I tried to kill myself. She also did not report auditory hallucinations, but rather said that the children were in the basement. It's my belief that she expected to die, and that by the time Mr. Clancy arrived, she would have successfully been able to take her life.
And sir, did you form an opinion to a reasonable degree of medical certainty as to whether or not Lindsay Clancy on January 24th, 2023 had the ability to conform her behavior to the requirements of the law?
Yes.
And what is that opinion?
Well, if we look at that day, we know that in the morning she took Cora to a pediatrician's appointment. And all physicians receive training in psychiatry, no matter what specialty they go in. That's part of medical school. And so, like other doctors who had seen her who were not psychiatrists at appointments and whatever, the pediatrician also did not notice any unusual things about her. She did not, she was able to conform, right, to the type of behavior that a concerned mother would engage in. She was able to drive to the pediatrician's office and then back. And the day was really one of significant control. The activities that she engaged in that day, spending time with her children with Play-Doh, taking them outside to build a snowman, sending photographs of the children to her mother, to her husband on Instagram, fixing lunch, and also fixing dinner for the children. So the activities of that day were controlled, as were the activities in terms of the planning that we already mentioned. So throughout the day, I mean, she was methodical and quite controlled and organized, even in that space of time that was short. There was a lot to do in terms of killing her children and also killing herself. And I would say that the last point with regard to conforming to the law is that when she received the phone call from her husband, she did not report to him that she was in distress, that she was having hallucinations, that she needed help. So with that phone, by calling her husband back and reassuring him by the fact that, yes, she knew the medication, whatever, that helped guarantee that he would continue on the errands. Had she not called him back, it would likely, or it certainly was possible that he would be concerned enough that he would return home. And so I think the phone figures in just in terms of her awareness and conforming her behavior such that the strangling of her children could be concealed.
And doctor, did you form an opinion to a reasonable degree of medical certainty as to whether Lindsay Clancy on January 24th, 2023, when she strangled her children, was criminally responsible?
Yes.
And what is that opinion?
Yes. It is my opinion within a reasonable degree of medical certainty that Ms. Clancy was criminally responsible.
Move to submit Dr. Satoff's CV as the next exhibit.
Any objection, counsel? All right, that may be admitted.
I have no further questions. Thank you.
Hold on a second, Mr. Remington. If it- Thank you. All right, Council.
Morning.
Good morning.
So, Doctor, as I understand it, you conducted your investigation or examination of Lindsay by Zoom, correct?
Did you say by June?
Sorry, Zoom. You know,
By Zoom, okay.
Television.
I thought you said because it was the 4th of June. Yes, sir.
Okay. And can you tell us when you were first engaged by the district attorney's office to assist them in this case?
I first was informed about the case, I think in January or early February of 2026 of this year. The final contract with the university was not completed, as I recall, until April.
And is that a matter of significant import when you're engaged in evaluating a young woman that's charged with triple homicide and you're hired by the government? The fact that there's a contract that wasn't signed by your school?
Well, sometimes it's a long process that I don't have any control over.
Sure, I understand.
I've seen those kinds of things take a while, take longer than one would necessarily want.
So the contract with your school that you're talking about would be the contract for your compensation, for your opinion?
Well, I would never be contracted for an opinion.
Okay.
But
You're getting paid, right?
No, I'm getting paid a salary.
Yes.
The university is getting paid.
And the university is deriving a benefit monetarily from your testimony or working on this case for the DA, right?
That's right.
All right. And how much did the university get as a result of your involvement in this case?
I don't know what the hourly rate is that they charge.
So you don't know what the hourly rate for your time is, right?
Correct.
You don't know how much money was paid by the district attorney's office to the university, right?
Correct.
You don't know how much money will be paid for perhaps yesterday, today, whatever, balance billing. You don't know that either, right?
That's right.
You were retained or engaged in January of 26, right?
Yes.
This is an incident that occurred on January of 23, right?
Yes.
In January of 23 to January of 26, 3 years
That's right.
to being engaged on the case, right?
Correct.
And when you were engaged on the case, at some point, the university must have been out of the picture and you must have started to communicate with the DA's office, the police, or whoever.
That's right.
And you knew about this case. It had a significant amount of publicity, right?
Yes.
Did you know that other doctors on behalf of the district attorney's office were being hired to also evaluate Lindsay?
I didn't specifically know that, but that's usually the case.
Is it important to see someone, to evaluate them as close in time as the incident is alleged to have occurred to your evaluation, or does it matter? In other words, is it better to see someone like, you know, within a month or two after an incident, or 3.5 years later?
Well, what's most important is the collateral information that was gathered at the time to understand what was going on at the time. Ms. Clancy's behavior during her hospitalization and the like, there are records, but certainly there are benefits to an examination closer to the event.
And you would agree with me, sir, that you actually saw and questioned or interrogated Lindsay, what, 2 months ago?
May 29th and June 4th.
Okay. And when you went to interview her in purposes of your evaluation, you had already accessed the collateral information, sir?
Yes.
Before I go there, let me just review a few things here on your CV, which the jurors will have to examine. You indicated to us your present employment. You have a private practice as a psychiatrist?
No.
Okay. So where do you see patients?
Well, I see patients in the prison system.
They're your patients?
Yes.
What do you do for those people that are in jail?
In prison, within the Virginia Department of Corrections, we have inmates within the prison system who suffer from mental illness and require assessment and treatment.
I see. So you don't have, when you said to the jury a little while ago, if I'm treating my patient and I would prescribe a particular prescription for my patient and I wouldn't tell my patient to do whatever it is you said, it's not people that go to an office or see you or even on the television to be treated. These are people that are in jail, right?
Prison. Yes.
So there's a difference between jail and prison, right?
Yes.
And this would be in Virginia, is it?
Correct.
So you're dealing with people that are serving hard time in the Iron Mansion, as they say. It's not a house of correction down the street, right?
I see patients who have different varying sentences. Some have life sentences. Some are scheduled for release, in the coming months. So that really varies.
And you work on behalf of the state to evaluate prisoners to determine whether or not they are fit, if you will, to be released into society, right?
Once someone's sentence is over, the only way that they could be continued within a prison system would be to be committed to a psychiatric hospital. And I would say that in the 34 years that I've been treating inmates who are patients, I can only recall 2 times where when discharge came up, their condition was such that they required to be civilly committed because of mental illness.
And when you are talking as a forensic psychiatrist evaluator, would that be on behalf of the BOP, Bureau of Prisons?
I have consulted with the Bureau of Prisons on just a few occasions, but
Okay.
Bureau of Prisons is federal, and
Yeah, I know that.
most of my work has been with state.
Okay, but on your resume, sir, you indicate from 2019 through the present, that's a number of years, that you have been employed or engaged as a forensic psychiatrist evaluator on behalf of the United States Bureau of Prisons as it relates to probation or parole. Is that in your resume?
Yes.
And that means, sir, that you evaluate inmates that are trying to get out of jail, and you would evaluate them to determine if they're appropriate for parole, right?
No.
Okay. So when you indicate on your resume from 2019 through the present, you're employed as a forensic psychiatrist evaluator for the United States Bureau of Prisons. How many of these evaluations did you do in the years from 2019 through 2026? 7 years.
I think I've done 2 or 3.
2 or 3.
Yes.
Okay. 2016 through 2022, you're engaged as a consultant psychiatrist for the Elson Student Health Center. What is that?
That's the Student Health Center at the University of Virginia. So that serves students who are at the university.
like what? I mean, do you evaluate them? Do you treat them? Do you analyze them? What do you do for college students?
My work with the university and the health center really had to do with students who were having difficulty and had left the university and were interested in getting back. And so I was part of a 3-person panel to evaluate the students to see whether or not it would be appropriate to bring them back to the university.
And what, were they like thrown out of the university, or they were disciplined or something? Why would you bring them back? What does that mean?
Well, if there was an event that caused concern, potentially was a threat, for example, then just for the student safety and the safety of all, they would leave the university in order to get the type of care that they needed. And then if they want to come back, then I was part of a panel that would evaluate these students and make a determination about whether it was safe
So these
for
are
them
the
to come
students.
back.
I'm sorry, I cut you off. Go ahead.
Yeah. No, that's all right.
Okay, these are students, right?
Correct.
In college, right?
That's right.
That have been thrown out or disciplined or suspended or something, and they're trying to get back into school, right?
That's right.
And when the parents of the students come, they retain you to advocate on their behalf?
No,
No, you work for the school, right?
correct.
You evaluate them and then back the school up so that these kids can't get back into the school, right?
Can you ask that question again?
No, that's all right. 1999 through the present, you work for the United States Department of Justice, the United States Department of State, right?
Yes.
Okay. And that would be the United States Attorney's Office, the prosecutors, like they're the state prosecutors, you get federal prosecutors, right?
Well, federal prosecutors and defenders. I've worked with both.
Well, the defenders certainly don't work for the United States Department of Justice or the United States Department of State, do they?
I was under the impression that federal public defenders were under the umbrella of the Department of Justice.
No, that's called the CJAC. That would be a totally different group of people. Those are people that defend people to try to have them not be abused by the system, if you will.
Yeah, that question be stricken.
2015, you're a psychiatric consultant for the Virginia Office of the Attorney General. Another prosecuting arm, right?
Yes.
2013, Virginia Department of the Virginia Department of Corrections, least restrictive measures for segregation. You evaluate people to determine if they should be in max or disciplinary unit as opposed to general population. Is that what you do?
Yes, I've been asked to do that.
Okay. And you certainly don't advocate on behalf of the prisoners that are being placed in seg or being placed in those closed units with higher security, right?
No, that's not true at all.
The National Security Expert 2007 to the present, Oak Ridge United Associated Universities. What is that?
Yes, that is a group that does research with the Behavioral Analysis Unit and the National Center for Analysis of Violent Crime, and I have done work with them.
Okay. Critical Incident Analysis Group, CIAG, University of Virginia.
Yes.
Okay. Behavioral Analysis Unit, as you told us yesterday, for the FBI at Quantico, right?
That's right.
Psychiatric consultant to the Virginia Department of Corrections, medium, maximum, and supermax facilities, right?
Yes.
Continuing on with your experience, sir, as a witness in this case, you'd agree with me that you were involved as a psychiatric consultant with the Macro Task Force on-site consultation for the Australian Police Service.
Yes.
Former Soviet Union project, Republic of Georgia, TBILISI, Georgia. You're involved with that, sir?
Tbilisi.
Tbilisi, yeah. Critical Incident Response Group for the U.S. Air Force. You're in the assessment unit.
Yes.
Crisis Management Unit, investigative support for Operation Gray Sunset, Jordan.
Correct.
Crisis Management Unit, investigative support unit, critical incident response in Montreal, Quebec.
Yes.
FBI, National Center for Analysis of Violent Crime, Operation New Hope.
Yes.
Bureau of Criminal Investigation, that's BCI, for the Department of the State Police. Would that be Virginia?
Yes.
You also have an interest in and have studied or written about various topics in your career, correct?
Yes.
Okay. Hostage negotiations course, crisis management unit. You were involved with that, is that correct?
Correct.
That was a number of years ago, though. I guess that was like 1996.
That's right.
But you've been involved with the FBI for a long time, right?
Yes.
Fair to say that you're a government man?
Objection. No, sustained.
Hostage negotiation course. How about Virginia Department of State Police? You involved with them as well, sir? Yes?
Yes.
Advisory positions. You deal with Islam in prison is one of your interests, right? That was a TV program or something?
Correct.
Talk about National Institute for Justice, Standing Committee to advise the Department of State on unexplained health effects on U.S. government employees and their families overseas, right?
Yes.
Analysis of pre-attack behaviors of the Las Vegas shooter behavioral analysis unit for the FBI.
Yes.
Skipping ahead, papers published. Now, when a doctor or a psychiatrist, or any doctor really, I guess, publishes a paper that's of interest to other doctors or people, that's called a learned treatise, right? Peer review?
Yes.
Okay. Can you tell me, what is peer review? What does that mean when you're dealing with a person's focus and interest in writing about what they're focused on?
So a peer review journal is one in which once an article is submitted, a paper for publication, that goes to qualified people within the same field who review it and make determinations about the quality and whether or not it should be published. Oftentimes, there will be some edits or suggested edits from those who have expertise. It's a blind process. So if I submit a paper and it's peer reviewed, I don't know necessarily at all who is reviewing it, but it's a way to ensure quality of articles that are published. And that's just an important standard.
So it's kind of a rigorous standard to make sure that what you're writing about is reliable and would be helpful to others that are interested in it, right?
Correct.
Okay. So for example, also it depends on where you're publishing it. You can put something in the National Enquirer, or you could put it in International Psychiatric something or other, right? Which would be a better
I don't think the
publication.
Enquirer is peer reviewed, but.
So you certainly would agree with me that the International Journal of Law and Psychiatry is a respected source for learned treatises, right?
Yes.
And you would agree with me, sir, that you've been in here telling this jury all about Lindsay and how she didn't hear voices or did hear voices or exaggerated and lied. Have you written any articles at all on the concept of auditory hallucinations?
No.
Have you read any of them?
Read any articles? Yes.
Yeah, okay. You certainly have heard of Dr. Philip Resnick, yes?
Yes.
And it's fair to say, and tell me if I'm wrong, is he literally a world-known authority in your field for filicide or the killing of children by their parents?
Yes, he's well known.
And is he also well-written as far as auditory hallucinations same stuff you've been testifying about?
Yes,
And he published an article in the International Journal of Law and Psychiatry, which is considered to be, if you know, a landmark article about, and I captioned, listening to voices, the use of phenomenology to differentiate malingered from genuine auditory verbal hallucinations. Now, did you read that article?
yes,
So it is a peer-reviewed article published in a recognized journal, correct?
correct.
Your Honor, I would offer this under Commonwealth versus Sneed for the jury, if they wish.
Objection.
Counsel Garcia, sidebar.
Hi. Okay, I've been listening with bated breath as you have. I think this has to do with the morning break, whether they're going to take it now or whether or not we want to wait. I mean, if I am Reddington, I think I want to wait. It's very interesting how he can change his style because he has somebody who is an expert who has serious qualifications, but not in postpartum psychosis. Okay, has never written, has never published, and I can't wait to hear about the questions about how many patients in postpartum psychosis are you treating now? How about in 2025? How about in 2024? In 2023? Okay, and then he got Dr. Sadoff to recognize Dr. Resnick's qualifications. Okay, so this is very, very interesting. Now, the article may not be able to be submitted, but he can cross-examine on the article if he believes that he read it. What he has to say is that he used the article or some of it in forming his opinions before the article can actually come in or even be cross-examined on it. So we'll wait to hear about this. But you see, Reddington is doing the appropriate thing. I've never seen anybody use a CV so effectively because he's buttressing the qualifications of this man in what he does. A government man dealing with keeping people in prison, violent criminals, Islamic terrorists, and all. He's buttressing that and showing how learned he is in that. But when it comes to postpartum psychosis, what is he going to say? Well, I can use the same principles I use otherwise to determine whether somebody is made a decision. And I wrote down his 13 different reasons. He put them in 3 different questions. But I thought what was interesting, at one point he said she didn't want the husband to be gone too long. To me, that's something I would eventually then jump on because she's scared to being alone. Remember how she talked about her mother? She's scared of being alone. I thought that was an incredible segue when he gets to his opinions in that. And that would indicate that Lindsay was in the throes of a psychosis and then has a psychotic snap. Okay, let's go back into court. I'm going to remove myself. Bo Buckingham and not Bo Buckingham.
Your Honor, while that copy is being made for the district attorney, could I continue?
Sure.
Thank you. Leaving aside the peer review article and the article written by Dr. Philip Resnick, sir, for a minute, papers that you published and you have in your resume, it says peer reviewed. So that's just what we were talking about, right?
That's right.
All right. Using the moral situational action model of extremist violence to assess fluctuating levels of risk in women, the relevance of risk promotive and protective factors. What does that mean, levels of risk in women with extremist violence?
We're looking at risk assessment in terms of violence and what may be mitigating factors. In other words, decreasing the risk or the threat, or increasing, that would be enhancing factors. But this is looking at a group in terms of research.
And it's research about women that are involved with extremist violence?
Yes.
Okay. Assessing, strike that. Using the moral situational action violence risk model for assessing women involved in extremist violence, an empirical study. Is that similar article?
Yes,
Operationalizing theory, a moral situational action model for extremist violence. That would include guys plus women, I guess, right?
I'm sorry.
That would include men plus women, I guess, right? Because it doesn't
Yes.
say doesn't say women. Suicide, terrorism, performance, violence as a public plunge. You wrote that, right?
Correct.
It's another interest. Crisis leadership and military community resilience. You wrote that, right?
Correct.
Painting by numbers, capturing the pathology of socio-political conflict, dealing with depression amongst Palestinians. You wrote that, right?
Correct.
Psychological challenges of bioterror. You wrote that, right?
Correct.
Trauma and intergenerations transmissions in Kuwait. You wrote that, right?
Yes.
Recognizing borderline personality disorder in the family practice setting. You wrote that, right?
That's right.
Mortality among elderly patients discharged from a state hospital. It's one of your interests, right?
That's right.
Postpartum psychosis induced by bromocriptine. That's the one that you told the jury about originally that you published 40 years ago, right?
Yes.
Okay. Morality and the radicalization of women. What is that? What was that all about?
Could I be refreshed with that? I'm
Sure. It's just, I mean, you can look at your resume if you wish. I'm just going through it. It's under B, books and chapters. This one is the first one, and it deals with radicalization of women. A handbook, I guess, for terrorism studies. You remember that? It's only 4 years ago.
Yes.
Okay. Application of big data for national security, a practitioner's guide. You wrote that, right?
Correct. I was one of 4 editors.
Crisis guide of psychoactive drugs and poisons for the crisis negotiation unit. You wrote that, right?
That's right.
International handbook of threat assessment, right? Yes. Protection of children during armed political conflicts, a multidisciplinary perspective, right?
Yes.
The negotiator's guide, like when somebody's locked in a building and they're threatening to kill people or something, the negotiator's guide to psychoactive drugs, 2nd edition. You wrote a chapter on that, right?
That's right.
The negotiator's guide. And it goes on and on with the negotiators and things like that. Terrorism negotiators, right? It's fair to say that's your focus.
Correct. Well,
Okay. Well, I know you can talk about postpartum, but I mean, I'm asking you if your resume that you prepared, I imagine, well before you were hired by this DA's office, sets forth your interest, right?
yes.
Okay.
The characterization of negotiation as trying to stop killers is not
I'm
accurate.
I'm probably wrong.
Comprehensive.
I apologize. You see it on TV, the negotiators, and they're, trying to help people that are being kidnapped.
On a bridge,
On
in
a bridge,
crisis,
yeah,
something like
okay.
that. So
Just a few more, Dr. Panels and symposia. You'd agree with, let's see, national security implicate. I just want to run through a quick attachment theory, mental wellness as it relates to threat management, threat assessments, corrections, psychiatry presentations, substance abuse and misuse in prisons, perspective on providing medical support during conflict and chaos, targeted violence in the media, lessons from history, the profile of poisons, understanding the female extremist, crisis operations, leadership, how to fool doctors by injecting chemicals into muscle to obtain opioids, a prison inmate comes clean. Did I read all those topics correctly, sir?
correct.
Invited lectures, talk about extremism, terrorism, the future of policing, children and long-term abductions, how to prevent terrorism, mass shooters, U.S. prisoners, religious rights, religious radicalization, terrorism and the unknown enemy. Basically, that's what your focus is, sir, correct?
No.
And that's coupled with your experience of the 2 people or so that you recall dealing with in your, it's not a practice, but working for the Bureau of Prisons or the state for Virginia, the people that are in jail. That is the sum total, to be respected, of Dr. Sadoff, correct? I mean, you treated 2 people. You've written a lot about terrorism and other issues that we went through.
That's not at all a correct characterization.
Oh, I'm sorry, because I read your resume, right?
Yes.
Okay, and I related what you indicated to the jury, your experience when I asked you about patients or treating people. I said that right?
I've been treating patients, and I continue to for the last 40 years.
Now, in all of your experience, sir, have you ever treated a woman suffering from postpartum psychosis?
Yes.
When?
In the late 1980s and also during the 1990s when I ran a unit in a state hospital.
So this would be women, 1980s, about 30 years ago or 20 years ago, depending on which one, in a prison that you were.
No.
Oh, it wasn't.
In a state hospital.
State hospital. Were they
Correct.
committed? Were they there because they wanted to be there, or were they committed by order of the court?
Yes.
Yes, what?
Usually committed.
Okay. So other than that, sir, do you have any interest, writing, knowledge about postpartum depression, postpartum psychosis?
Well, it really is a requirement when you assess and treat women to be aware of their histories and making determinations. So that has continued really throughout my career, men and women.
What did you just say? Can you repeat that again? You're treating women with what?
Treating women with psychiatric problems, serious illness, psychosis.
So when you defined for the district attorney the concept of, let's say, psychosis yesterday, were you referring in any degree to a woman who has had a baby and is in a period of postpartum depression, shall we say?
Yes.
Okay. And when and how were you treating those people?
That was during the period of 15 years when I ran a unit of men and women who came in with serious psychiatric symptoms.
So what would you do? Would you analyze them? Would you talk to them, counsel them? What would you do while they're in the hospital?
Well, do a full assessment with a multidisciplinary team and make determinations about proper treatment, proper therapy, medications and the like to treat the symptoms.
And generally, what would the symptoms be, sir, in your experience?
Symptoms of postpartum depression? Okay. Well, certainly within that period of time around birth or after birth, the DSM has a 4-week period. Others expand that to as much as a year. But certainly depressive symptoms postpartum are similar to the symptoms that you see in a regular depression. You can have suicidality, you can have guilt, changes in appetite, changes in weight, changes in concentration, changes in physical activity. You can also have significant problems with sleep. either sleeping too much or not enough. So these are depressive symptoms that come in the postpartum period and require assessment and treatment.
Are you aware, sir, in your practice or studies of the number of women that commit suicide during the postpartum period? Are you aware of that?
I can't quote you a figure.
Do you have any clue at all?
No.
Would you agree with me, sir, that one of the unfortunate components of a woman who has had a baby and is suffering from postpartum depression and living with it, that can, on a dime, turn into postpartum psychosis very quick, right?
It can be rapid.
And you indicated, sir, that there, according to the DSM, is a 4-week cutoff for symptomology. And then you mentioned that there are others. Is it the World Health Organization that you said that talks about a year?
Correct.
There are some other psychiatric organizations that talk about different periods of time, 6 weeks, 8 weeks, right?
Correct.
So when a woman is dealing with these symptoms and goes to a doctor, or even you, when you're treating, as you indicated 15, 20 years ago, you were treating, is it important to take a blood test?
I'm sorry, can you repeat that?
I'm sorry, my bad. Is it important to take a blood test?
Is it important to take a blood test?
Yeah, you just went through the whole thing about we're going to have the team and they're going to evaluate and we're going to prescribe. I'm just asking, is it important to take a blood test of the patient?
It can be.
Based on what?
Based on the presenting symptoms, based on the history, based on medical history. For example, if someone has recently been in a hospital and been treated, there may not be a necessity for drawing blood again, depending on the types of symptoms that you encounter. It's not a standard that everyone who presents to a psychiatrist requires blood tests.
So if you're a psychiatrist who's been practicing private practice for about, I don't know, a month, maybe 2, and is prescribing antipsychotic medications, selective serotonin reuptake inhibitor medications, benzodiazepine medications to a young woman who is complaining of what the young woman perceives to be difficulties postpartum. Is it important to take a blood test to find out what, if any, prescription drugs they have on board in their system?
To check and find out, did you say what drugs are on board?
Yeah, I mean, you're treating this patient, right? And they're coming off the, hypothetically with you, but they're coming off the street to see a psychiatrist for help, right?
Yes.
And if they're already been prescribed drug after drug after drug by a particular doctor with her 2 months of robust experience, is it a fair statement that you should take a blood test of that person?
Well, it really depends on the medication. There are some medications that really require blood tests because of levels and the like. Many psychotropic medications are not easily, there's not an easy test for the amount of medication in the system. So it depends on the circumstances, and it depends on the medication. I mean, for example, lithium or carbamazepine or valproic acid, those are all mood stabilizers. Certainly taking a blood test would be very important. So it depends.
Depends. Can I just ask you to spell those 2 drugs that you just pronounced for the stenographer, please?
Carbamazepine.
Yeah.
Carbamazepine.
Okay.
Valproic acid, Valproic acid, also known as valproate, Valproate. TE. And did I mention lithium?
That's not a hard one. The record has to be accurate, that's all.
Understood.
Okay. Now, doctor, are there other tests in your experience that are or can be or should be administered to a young woman or a woman who's had a baby and is coming to a doctor, like Dr. Tufts, for example? Are there other tests that can be administered to determine if, in fact, that person is suffering from postpartum depression?
I'm not aware of any specific test that specifically diagnoses depression. Years and years ago.
Oh, postpartum depression, sir.
Pardon me?
Postpartum depression is my question.
Correct.
Depression. I know you want to say it's the same thing, but postpartum depression is my question.
And you're asking if there's a blood test for postpartum
I'm
depression?
asking if there's any tests at all that a psychiatrist can or should administer to the patient coming to them for help.
Well, there's the Edinburgh scale, which is a self-report that patients fill out for who are postpartum.
You looked that up last night?
No.
Well, you knew about the Edinburgh scale?
Yes.
You administered the Edinburgh scale?
Pardon me?
Have you administered the Edinburgh scale?
No. It's a self-report, usually given by nurses.
Nurses, okay. In any event, it's a scale that is a useful tool to determine the level or degree of depression that a person may be expressing that is suffering from postpartum depression, correct?
That's right.
And do you know what the numbers are on the scale? Like, is it 1 to 23 or is it 1 to 50, or do you know what it is?
It's a 30-point scale.
And when you say
So 1 to 30, as I understand it.
And when you say a self-report, the patient would then advise what symptomology they're suffering at that particular point in time, right?
Correct.
And then the doctor would then determine whether or not there is a risk or an extreme risk or a deadly risk of this person committing suicide, harming someone else, whether it's a baby or anybody else, and determine what the level of their postpartum depression is, right?
Yes, it can help.
And did Dr. Tufts administer Edinburgh test to this young woman?
I know that Ms. Clancy, there were a number of Edinburgh tests that were given to her, so that there are some scores in her record. I can't recall which practitioner gave her the Edinburgh test, but I do recall that there are a number of scores within her medical record.
Right. And what was her highest score?
The highest score that I recall was 23.
23 out of 30, right?
Correct.
And over 15, the patient is in pretty serious trouble, right?
Over 15 is concerning, definitely.
Right. And she was 23. Right?
Yes, I believe so. I think they ranged from 19 to 23, just
Right,
from my
they
memory.
increase as time went by, right? She was getting worse,
Correct.
right? Yeah. All right. And in addition to the regular blood test, which costs like, I don't know, about $100 to administer a blood test to see what somebody's got in their system. It's not a lot of money, right, for the insurance company.
I just didn't hear you.
Blood test. It's not a lot of money for an insurance company to pay, right? To cover.
Correct.
Okay. So do you feel that it is reasonable medical procedure for a psychiatrist dealing with a woman who is expressing under the Edinburgh scale off the charts or serious trouble, who is on medication, as we went through? The antipsychotic drugs, the SSRI drugs, the amitriptylines are at the end of the period of treatment with these people, the benzodiazepines. It's helpful to take a blood test, right?
It can be.
And is that, in your opinion, sir, to a reasonable degree of medical certainty, a step that should be taken by a competent doctor?
That taking blood tests can be appropriate, yes.
And then there's an additional blood test that you can use when you're dealing with a woman who's suffering from postpartum depression or coming to the doctor for help and they have significant narcotics or prescription drugs in their system, and that would be an enzyme test, right?
I'm not aware of an enzyme test being typically available or used.
Well, it costs a lot of money, doesn't it? Like it costs a couple of grand?
I don't know.
All right. In any event, sir, are there any other concerns that one would have if they're competent and they're treating somebody that's come to them for help in addition to a blood test and perhaps enzyme test to determine the metabolizing aspect of the person's system, metabolizing or processing these drugs that are in their system, the enzyme test? Are there any other tests or concerns that you have with a woman whose postpartum depression complaints come to your doorstep?
Well, depending on the presentation, sometimes it's helpful to check thyroid function. That can certainly be a cause of psychiatric symptoms.
Did they do a thyroid test on Lindsay?
No,
That's not a lot of money that the insurance company would complain about, right?
correct.
One of the things that I just don't want to forget, sir, is that the district attorney asked you, while we're talking about the drugs, about the Lamictal, otherwise known as lamotrigine. Did I pronounce that right?
Lamotrigine, yes.
Lamotrigine. And she said that Lamictal, it has a side effect of a rash, right? You recall that, sir?
I think I said serious rash.
No, I think she said rash. You may, it's up to the jury what their recollection is, but you may have said serious rash, but we both agree it's a serious rash, right?
Yes,
In fact, it can be fatal, right?
in very rare occasions, yes.
It can be fatal, right?
Yes, in very rare occasions.
Well, if one person out of 1,000 gets Stevens-Johnson syndrome or prurigo nodularis as a result of taking that medication, that's something that we should not tolerate as doctors, right?
Risks and benefits are something that every physician, every prescriber needs to think about.
So you've heard of, as it relates to Lamictal as a prescription drug, what's called 10. You've heard of that, right? As a side effect?
Yes.
And that means what?
It is a pretty severe reaction of the skin, as I recall, causing blistering. I mean, it's very significant.
So if you have a young woman who is a nurse, an RN, who worked for 7 years in a very prestigious hospital's labor and delivery unit, who was so nervous about drugs that were being prescribed to her that she would at night sit in her kitchen on her phone and Google all sorts of side effects of narcotics, the drugs, the Seroquel, lamotrigine, all of these drugs. Is it an unreasonable decision for her to say, I don't want to take that drug, in your opinion?
It seems like you're asking, is it reasonable to decide not to take the drug?
Yeah, that's what she did. That's what you told us yesterday. That's what the DA asked you yesterday, right?
It was a decision that she made.
And in your opinion, sir, after we just went through all of this with the 10s, with the toxic epidural necrolysis and all the rest of that. And she's a nurse, and she's looking up these drugs that she's being prescribed and says, I don't wish to take that drug, in your opinion, to a reasonable degree of psychiatric certainty based on your experience. Is that a reasonable decision for her to say, I don't want to take it?
The benefits of that drug are profound, and millions of Americans take that medication and find it to be very important for them.
Doctor, you're an intelligent man, you're a doctor, you've got a lot of experience dealing with the prison system. We've already gone over all of that. You understand my question, don't you? Just
Yes.
asking, is that a reasonable decision for Lindsay to make, to say, I don't wish to take that drug? Based on all the side effects, whether or not it's rare that people die, whether or not it's rare that they break out on their skin with these permanent lesions and bleeding pustules, is it reasonable for her to say, I don't want to take it?
In her mind, it was.
Yeah. And certainly, we don't want to leave it with the jury that she's so vain that she just didn't want to take something that she might get a little rash. In any event. Now, have in mind, there's no blood test, there's no enzyme test for metabolite test, there's no thyroid test, but we still have the pill factory through Dr. Tufts and then into Dr. Gelada for that period of time. You're telling this jury that that is, in your opinion, reasonable little drug doses that she was prescribed? Is that what you're telling this jury, sir?
That it was reasonable to prescribe?
Yeah, the drugs, one right after the other, and then stopping the SSRI, not weaning off, stopping it flat out. Is that reasonable?
Objection.
Sustained, just as to form.
Is it reasonable, sir, in your opinion, to tell someone who's on an SSRI, such as Zoloft or Prozac, just stop it and we'll put you on something else, or should you wean it off?
In the case of the Zoloft and the severe insomnia, in my view, it was reasonable to stop it.
And then prescribe new drugs?
Well, insomnia was a significant problem, so as I recall, Ativan and Benadryl were prescribed to assist her with those symptoms.
Now, if somebody, is nervous because they have an exam coming up, or they just can't sleep because maybe they're worried about their job, there's a big difference between that and serious insomnia. Is that true?
Yes.
And Lindsay was suffering very serious insomnia, according to the medical records and her statements to her providers, right?
That's right.
And in fact, when Tufts increased the SSRI 25 to 50, she went 48 hours straight without being able to sleep, right?
That's in the record, yes.
And she went pretty much immediately to Tufts and complained about that and said, I can't sleep. It's 48 hours. I just can't sleep, right?
Yes, I think that was around the 21st of October.
And in your experience with dealing with terrorism and terrorist threats and things like that, would you agree with me that sleep deprivation is used as a torture?
It can be, yes.
And in fact, the side effects, if you will, of a person who's suffering from serious insomnia can actually lead to psychosis, can it not?
Yes, it's possible.
You're aware that while she's living in her house with her husband, Pat, and their 3 kids, that by all accounts, she was a happy mother, wife, friend, daughter, all of the above, right?
No.
So as the summer progressed, is it your understanding from Dr. Sadoff's investigation in this case that Lindsay Clancy and her husband, Pat, and their kids during the summer of 22 were not living their best life, enjoying life?
The summer was very good from Callan's birth really through much of August. Through the time that Patrick Clancy was at home, that first 12 weeks was really quite good.
And then it went sideways, right? She started having some concern about anxiety, right?
She did.
That brought her to Dr. Tufts' office. Oh, brought her to talk to Dr. Tufts on the telemedicine, right?
Correct.
And then she started getting her prescriptions, such as the SSRI at 25, SSRI increased to 50, 48 hours without sleep, went back to Dr. Tufts, more medications prescribed, right?
Yes.
Was she in rough shape in October of 2022 after dealing with Tufts for about 3 weeks?
She was certainly having difficulty, although the Benadryl and the Ativan were very helpful for sleep.
Okay. I'm just going to grab this item here. I'm just going to kind of hold it. In your investigation, and look, you did look at the text messages and all the stuff that was on Lindsay's phone. Right?
Yes.
Her life was pretty much turned inside out, right? I mean, government got access to every text message she sent, right?
Yes.
Every email that she sent, right?
Yes.
Every memo that she wrote on her phone or on her computer or whatever, right?
Yes.
Every journal entry that she ever wrote during this period of time, we have it all, don't we?
Yes.
And in October 20th, sir, did you see this text where she texted her mother and said, "Mom, will you please come up and stay with me a bit? I'm really sick. Something's wrong. I had horrible insomnia all night. I just don't know how I'm going to get through the day. I started to take medicine the doctor prescribed for anxiety, and I think it's made things worse. It's just really scary. And I don't." Did you see that?
Yes.
So she wasn't doing well in October, was she?
Correct.
And continued to see Tufts, right?
Yes.
Gelada, right?
Nurse practitioner Paul and then Gelada. Yes.
Okay. Now, in your investigation of the medical records, would you agree with me that Lindsay was not running around from doctor to doctor to try to physician shop, to try to get drugs so that she could get high or use the drugs? That's not what she was doing, was it?
Ms. Clancy expressed concerns that she was not following a plan and that it would have been better for her had she tried to stick with a plan.
Is that one sentence in all of the medical records where it makes reference to the fact that she said something like, I should have stuck with the plan? Is that what you're referring to?
Yes.
Okay. My question, sir, was Dr. Tufts, Dr. Paul, Dr. Gelada.
Nurse practitioner Paul and Gelada.
I apologize again. That's
all right.
My bad. Nurse practitioner Gelada. Up to that point, bringing us into November, these people and other emergency room visits that she had. She was not going out looking to score drugs off of drug prescriptions. Is that fair?
Correct.
And she, in fact, looked up Tufts, but she didn't even know who Tufts was. She went online and Googled postpartum depression and found an expert. Isn't that right?
That's my understanding.
But she was only practicing for like a month or two. Was she, in your opinion, to a reasonable degree, a psychiatric certainty, an expert?
Objection.
Overruled.
it depends on the amount of training that she received, not just as a physician and a resident, but also in the area of women's health.
So the young lady goes online, Googles, trying to get help, goes to see the expert, Dr. Tufts, ultimately deals with nurse practitioner, Gelada, and counselor that worked in that medical field business, Letitia Dukes, I believe is her name.
Right.
And then she had the need to go to an emergency room and went to Mass General Hospital, right?
That's right.
And she was with her husband, Pat, right?
Correct.
And she had been complaining about lack of sleep, insomnia, right?
Yes, as I understand.
She had been complaining about inability to emote, feeling hollow, not myself, right?
Correct.
And a number of other complaints that were brought to the fore. And the hospital made a recommendation that she go to McLean Hospital, which is a locked ward mental institution in Massachusetts. And she chose not to do that, correct?
That's right.
So then what she did is went back to her home and immediately hooked up again, if you will, with Tufts, right?
That's right.
In December, one of the people at the South Shore perinatal unit advised her to go to a hospital that specializes in postpartum women. That would be Women and Infants Hospital in Rhode Island, right?
That's right.
And she went there like the next day, right after they called, right?
Yes, I think they fit her in pretty quickly. Was it maybe the 20th of December?
And her husband dropped her off for that day program, right?
That's right.
And she participated with the coloring, with the conferences or with the discussions, and evaluations with the doctor, right?
Yes.
For about 8 hours. It was about an 8-hour day, right?
Something like that.
And on that day, in December 20th, she was turned away, basically, right?
I don't know that I would term it turned away.
Did they help her?
By Dr. Diaz's notes, but
Did they help her?
pardon me?
Did they help her?
They felt that another program might be more appropriate, either inpatient or partial hospitalization or outpatient, just based upon her concerns about medication.
And her concerns about the symptomology of postpartum depression, right? That's why she was there.
She was having depressive symptoms, yes.
Right. And that's in addition to, everybody wants to say GAD, 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 general anxiety, depression. This woman was there for treatment of postpartum depression, right?
She was there for treatment of depression. I was under the impression that most of the women who were in that program were much closer to had given birth to their children. And so in that respect, it was not the group that they served were much closer to that postpartum period, as I understand.
You're not going to say to this jury that because Lindsay was outside of the, let's say, 4-month cutoff, that she was not a good candidate for postpartum depression treatment? Is that what you told us, Jerry?
No.
Oh, okay. I'm sorry. I thought you said because of the time frame from giving birth to the time that she went to see them.
I was just speaking about my understanding from the note from Women and Infants in terms of their decision making.
Okay. And Women and Infants basically discharged her after about 8 hours, right?
Yes.
And her husband was up skiing, and then she contacted him and he had to come down and pick her up and bring her home, right?
That's right.
And the reason that she was discharged from Infants Hospital in Rhode Island included a statement, RO, rule out issues regarding prescription medications, correct?
Yes, that's my recollection.
And she indicated that she was going to go right back to TOPS, right?
Yes,
And she did, didn't she?
yes, as I understand.
And would you agree, sir, that every time a doctor said to Lindsay to do something, whether it was to make an appointment somewhere, whether it was to take another drug, any advice, that she was on it immediately? Is that fair?
She attended her appointments, yes.
Well, not just that, she attended them right away. She was told, for example, at McLean, you read those records, that she should hook up with her provider, and she did the very next day, right?
Yes,
Okay. So she wasn't avoiding seeing healthcare professionals, was she?
no,
And she was continuing to express concern about her state of mind. She felt that her mind, her brain was being damaged. Isn't that right?
that's right,
Those are in the records, right?
correct.
And she felt that her brain being damaged was permanent and she was never going to get better, right?
Yes,
She was complaining not just to her physicians, but she was complaining to people in her community that she was having intrusive thoughts, dark thoughts, suicidal thoughts, and homicidal ideation. She said that, correct?
the homicidal ideation, as I understand, was just voiced to her husband and her mother.
Just voiced? Is that what you just said? Just voiced? Is that like talking about the Red Sox? She's talking about homicidal ideation of her children.
Sustained. Next question.
I asked you about her complaints of intrusive thoughts, complaining to doctors, complaining to friends, complaining to neighbors, family about dark, intrusive thoughts of suicide and homicidal ideation. Didn't she?
I just don't recall that she complained of homicidal ideation to
Okay, so-
healthcare providers.
Finish answering.
I think, Doc, you finished? Did you finish the answer? Doctor, did you finish that last answer?
Sure.
Okay. All right. Next question.
So we'll put homicidal ideation aside for a minute. Would you agree that for that period of time, short as it may have been in her life, November into December, that she was reaching out to people that would listen to her for help?
Yes,
Would you agree, sir, that she would tell, for example, neighbors or friends with the Learning Sprout School, her family, her doctors, that she was having these dark, intrusive thoughts of suicide? Yes or no?
did you ask whether or not she was telling her children's teachers at Learning Sprouts?
Anyone that she would come in contact with at Learning Sprouts, whether it's another mother, whether it's a friend, whether it's a teacher, whether it's an administrator, whether it's somebody that just watches the kids in the playground, did she tell anyone that she had dark, intrusive thoughts to your investigation?
Those people that you named, I wasn't aware that she informed them about that.
When someone says, with her history up to this point in December, that they're having dark, intrusive thoughts to a professional, in your opinion, sir, to a reasonable degree of medical certainty, does it make sense that the professional should ask the person whether or not these are voices that they're hearing in their head, or whether or not they are just thoughts that they're having?
certainly exploring that is important.
And would you agree with me, sir, that when you have a young woman that, again, by all accounts, done nothing wrong in her life, exemplary citizen, has these issues and sees the doctors that, to a reasonable degree of medical certainty, a physician should do a little bit more than asking, do you have a plan? I mean, is that accepted practice, just to say, do you have a plan? And if they say no, you're okay.
I wasn't aware that that was the only question.
Okay. She was also told that counsel had asked you yesterday about other recommendations that were given to her by women and infants, and that you said that she did not follow through on that, but she did see Dr. Tufts pretty much the next day, right?
That's my understanding, yes.
Okay, and she said that she was going to go see Dr. Tufts the next day, right?
Yes.
And just to mention, before I forget it, the Lamictal, I think you mentioned to the jury that she had a prescription for Lamictal that she was able to fill, right?
Correct.
But she didn't take it, right?
That's right.
And then Tufts told her that she was going to, she meaning Tufts, was going to give her a script for Lamictal. And she said, no, I already have one, right?
It was Nurse Gelada.
Okay, sorry.
She had gotten the prescription and filled it from Dr. Tufts. And Nurse Gelada, when asked about the Lamictal, was very favorable about it and said, yes, that's great. That would be great.
Sir, I know. You want to tell me that it's a wonderful drug. Did she tell nurse practitioner Gelada, I already have a script. I don't need it?
Yes.
Among other things, when people are in trouble and they're having dark suicidal thoughts, whether or not it's voices in their head, whether or not it's thoughts that they can't go on anymore, they can't live life, they have to kill themselves, many times they're told to call suicide hotlines, right?
Yes, Aspire.
Aspire. What is Aspire?
I don't know what it stands for, but it is a hotline that Ms. Clancy called twice because of her suicidal ideation.
When did she call Aspire saying that she had thoughts of killing herself?
I can't recall specifically.
But she did call them not once but twice and told them. So she complained and told them that she was going to kill herself, right? Twice. Right?
She spoke to them about suicidality.
So here's a young woman with all of what she's been through who now is to the verge of killing herself and reaches out to people that her health care providers told her to call for help, said that she was going to kill herself, and what did Aspire do?
As I understand, they redirected her to her provider. They did not make a decision to hospitalize or to recommend hospitalization.
They didn't make a decision to do anything.
Objection.
Yeah, so you could form that as a question, please.
Did you read the records dealing with Aspire? Did they do anything other than tell her, no, you're not someone that we can help?
I know that they were not responsive to her suicidality because she did not indicate that she had a plan.
And did you read a transcript or listen to a tape, or how do you know that?
I recall it someplace in the documents, it being referred to, but I can't tell you exactly where.
So this, sir, obviously is a murder trial, and you are a witness for the government, and you've indicated that you've read the records. You just told this jury that in the conversation that she had with the people from Aspire that she expressed suicidal ideation and was asked if she had a plan. Where are you getting that from?
I can't tell you exactly within the records.
How about the second time she called Aspire? Why would she call Aspire again if they wouldn't help her the first time? In your opinion, as a psychiatrist, looking for help?
Continuing to seek help.
And yet again, she didn't get any, did she?
That's my understanding.
To a reasonable degree of psychiatric certainty with treating the patients to the extent that you've told this jury that you have, what kind of a devastating effect would that have on a person who's ready to kill themselves that's called Aspire hotline twice and has been turned away?
Objection.
Overruled.
It could have a very serious effect.
And after being discharged from Women and Infants Hospital and reaching out to Aspire, you'd agree with me that one of the concerns that the doctor at Women's Hospital in Rhode Island had is the medication that she had been prescribed by Thompson nurse practitioner Gelada, right?
Correct.
And that's one of the reasons that they could not treat her. It wasn't just that, no, we don't think that you're postpartum depressed. We just think that there's a complicated overlay involving the medications that you've been prescribed, right?
Yes.
And these medications obviously included selective serotonin reuptake inhibitors, right?
Yes. Prozac and Zoloft.
Right. And one of the things that a doctor would be concerned about, especially with a woman who's had a baby and has stopped breastfeeding the baby, is the effect that that may have on the woman, physically, mentally, emotionally, when they stop breastfeeding a baby, right?
Yes.
And you've heard of gamma aminobutyric acid, otherwise known as GABA, right?
Yes.
And can you tell us, please, what that is, sir?
I'm sorry.
Can you tell us, please, what that is, sir? What is GABA?
I believe that you're referring to Lyrica.
No, I'm asking about the actual acid in the person's system, their blood, that is gamma amina bulyc acid. It's got nothing to do with lamictal. It's got nothing to do with Seroquel. It's got nothing to do with the drug industry. This is in the body. When a woman stops lactating, a woman stops breastfeeding.
Yes.
There is a physical effect on the person, the body, right?
Yes.
What is that effect?
It depends on the individual. There's variable responses postpartum, and as I understand, she stopped breastfeeding around October, by October 21st or so, when the Ativan was started.
Would you agree with me, sir, that the GABA, make it easier to type, is basically affects, its primary effect is on the neurotransmitters in the brain, right?
Yes.
Okay. That sounds pretty complicated. Neurotransmitters, I mean, is that like where you have a spark plug on a motorcycle and you can actually gap it and get it to kick over? It's a neurotransmitter in the brain. That sounds like it.
Well, yeah, it's more complicated than that.
I figured.
Obviously.
But nevertheless, it's still basically, you're talking about the actual organic matter of the brain, right?
Yes.
And would you agree, sir, that when a woman is pregnant, that there are progesterone hormone surges during that pregnancy?
Yes, there are hormonal changes.
Their hormone doesn't just change, it can actually surge, and it can be quite impactful to the person, right?
Yes.
And would you agree with me, sir, that one of the metabolites of progesterone, which has been unleashed when a woman is pregnant with the progesterone hormone surging through their body, that you have a metabolite that actually enhances or increases the GABA activity of the neurons in the brain, right?
It can, yes.
And what is that metabolite, sir, that increases that activity in the very organ of the brain?
I can't tell you.
Is it a allopregnanolone? If you know?
No,
No, it's not, or no, you don't know?
I don't know.
Immediately after a woman has a baby, would you agree, sir, that the progesterone that we just talked about and the allopregnanolone that you don't know about drops precipitously according to the medical treatises, right?
If he knows, he can answer that.
Yes.
And what does that mean, sir? Tell me, when it says that the progesterone and the allopregnanolone in the body drops precipitously. What does that mean, precipitously?
That means rapidly.
And a sudden drop, sir, you would agree has a significant potential of causing serious GABA dysfunction, right?
That certainly would be possible.
Do you know that, or are you just agreeing with me?
I'm agreeing with you.
Okay. Do you want me to keep going?
Want to take a short break?
I don't care. I'm just saying that.
Yeah, why don't we take the morning recess at this point? All right.
Court, all rise, please. Jurors, kindly close your notebooks. Take on the chairs. This way, please.
We'll just keep our eyes on there to see where the camera possibly scans. I have some very interesting notes.
Jurors have exited the courtroom.
All right, Counsel, can I see you at sidebar just briefly?
Okay. All right. So we're going to sidebar and we're going on scheduling, obviously, as to whether Kevin Reddington will be finished. And I know he'll be finished before lunch or soon thereafter. And then the prosecutor will try to go forward. I thought this was very, very interesting tack. Again, experienced trial attorney.
To qualify for appointment,
Whoops.
an oath of office must be signed in the presence of a commission notary.
Okay.
and
I don't
submitted
know
to
why this is happening.
the Department of State with your
Okay.
complete
All right.
application and
My
$60
phone
fee.
has gone rogue.
This form must be completed prior to applying for
I'm just going to turn off my phone. It's gone rogue. It's talking about notaries. All right. You can't make this up. Thank you, iPhone. All right. So, laughing here. Good thing I wasn't shopping or something. Anyhow, he actually changed his format and how he was going to deal with the witness, because he knows he has a witness that the jury will like based on his qualifications, not for postpartum depression, but just generally because of his CV. And I have never seen a lawyer use a CV in cross so well. Basically going through buttressing all the things he does as a government man, as you heard, and there was objection, but the jury understood it all. That he testifies for the government, and he testifies about terrorists, and he testifies for people in prison, and it really was quite remarkable. And then he warmed him up, and I think you heard him get some admissions, okay, from him. And then we turned, as I think earlier in the chat I said, and then he will turn to postpartum depression and psychosis. So before we talk about it, let me just turn to some of our stars here. Let's see. By the way, thank you very much. We are reaching out to Professor Bergink. That's who is in New York. And one of the leading experts that Dr. Gregor said is in the United States on postpartum psychosis, women's postnatal maternal health and all. She's right over here at Mount Sinai, a couple blocks away from where I'm sitting right now. So we'll see what she says. I'm trying to get her on tonight. Thank you, Loving Lacey, for the flower, 30 jewels. Thank you, the duckling. Thank you, Melissa Boyles, for the duckling. That's very nice of you. And Roosevelt Media, thank you very much. This may not be a positive trend, but I'm swayed by this expert's testimonies. But the question is, swayed now in what way? Because we're now hearing he is becoming a defense expert. So let's talk about that. There were some amazing admissions there. The first one that I wrote down, and I had written down a bunch earlier, okay, and I talked to you about it in the chat. She didn't want the husband gone too long. That's because she didn't want to be alone. And maybe she was starting into that psychosis. She was in that psychosis, hadn't stopped yet, but she was in that psychosis. That's why he didn't want. And that was an incredible admission that I know Kevin Reddington will use and must have picked up on. All right. That was an incredible admission. But then he admitted, this doctor who is not, I mean, would you go to him? Let's face it, you're picking up the phone and you're going to somebody for PPD or PPP, right? Are you going to him? Okay. Are you going to him? Absolutely not, because he's talking about Islamic terrorism. And Kevin Reddington used that, his ability to understand how you interrogate Islamic terrorists or other terrorists by sleep deprivation is used as torture. Yes. And could it bring on psychosis? Yes. Bingo. Okay. So he's got him there as an expert there. It could bring on psychosis. Yes. He can't say differently because he's an expert, obviously. We'll go full screen, by the way, when the court leaves in it. And then he also got him to admit, by going through systematically her records, and we're hearing the history systematically, how she was a compliant patient, did everything the doctor said, not looking to score drug prescriptions, which is what the prosecutors had said. Again, another lie by the prosecutors, right? And then he also was able to go through the fact that the rash that Lindsay was concerned about is a serious rash and it could be life-threatening. And that's what she's trying to avoid. She's trying to avoid killing herself. So why is she going to take a drug that has a side effect of life-threatening? That's why they give you the side effects. That's why the doctor said that's her, basically, he agreed that's her choice, because that's the choice. He said the medicine's good, but it has a big side effect. It could kill you. All right. Hello. All right. So he got that admission from him. Then he got a big admission over here. That PPP can come on like that. Like, Joy, I can't open the chat right now. I'm in the middle of discussion. So sorry. If you have anything, text it to me or put it in the comment. That it could go just like that. Okay. All right. And that's exactly what Dr. Gregor says. You can have that psychotic break. You have psychosis and you may have had it intermittently and you're having this psychosis and you have a lot of the indicia of the psychosis, but the break can come just like that. You're playing in the snow, you're cooking dinner, you're discussing where your husband's going to pick up 4 miles or 6 miles away dinner. You don't want to be gone too long. You don't want it to be gone too long. You don't want that. That was a clue that she was upset, that she was feeling things. That was an absolute clue. And the break can happen just like that. That's an admission. That's what Dr. Greg Gore told us about. So he used this to get all of these great admissions, because you're never going to change the ultimate conclusions that these doctors give. They're hired, they're there because they're giving the ultimate conclusions. You're not going to change that. What you can do is either undermine their testimony, undermine their experience, or get incredible admissions that supports what you have been saying. He also got him to admit that Dr. Resnick is a recognized expert in the area, probably the world recognized expert in the area of filicide, a parent killing a child. He got that admission from him, okay? All. It was amazing. And then on his CV, this was not an admission, but when he's talking about he works for the Federal Bureau of Prisons for, I think it was like almost 10 years, he's done 3 cases to keep somebody in prison. Okay. 3 cases to keep somebody in prison. All right. So yeah, I just thought that kind of was a little bit, it made his resume seem a little bit tacky there. And that, he talked about what peer review is. All right. And then, talked about auditory hallucinations. Anyhow, Reddington got all these admissions, and the last time he really saw a patient with PPP who's been incarcerated or was in a mental institution, which Reddington had to love that. She was in a mental institution, was in the 1990s, okay? In the 1990s. He had 1 patient in the 1980s and at least 1 in the 1990s. But where did he see her? She was in a mental institution, which is one of the options for Lindsay if she's found not guilty by reason of insanity. So I think that was a little tidbit that he didn't expect to get, okay, which he got, okay? It was, and I'm writing that down right now, mental institution. So there were all these, and then we ended with the homicidal ideation. He says, first he said, well, it was just voiced. So what? That she voiced it to somebody. She told people that she had homicidal ideation. And who did she told? The people that you would trust most in the world. And that is your mom and your husband. Your mom and your husband. And for some reason, this doctor was like, said just voiced. And you heard Reddington say, did you just say just voiced? All right. And so I think he realized that didn't sound so good. And then she also sought help. Twice she sought help from this hotline who turned her away because she didn't have a plan, and he got the admission from that. But that was a wrong thing to do. That really, if you have a suicidal ideation, the impression is left that they should have dealt with her. They should have done something more besides turning her away. It was not appropriate to turn her away. So he gets that admission. So remember, we all know that they never changed their viewpoint, but you can undermine it. And we haven't even gone how he's going to undermine it there yet. And we all know from Dr. Gregoire, from the last 2 times we had him on, that first of all, the psychosis can last more than 18 minutes, which is what the prosecution keeps hard on. It can last hours. It can last days. The psychosis can go on. The break can happen like that, but the psychosis can go on. That you can make intentional decision making when you're in psychosis. Right, you're making intentional decision making. Your intentional is that you're drinking something that may be wine, but you think it's lemonade. All right, yeah, but you're making a decision to drink. So that's an intentional decision. You can make all of these decisions while you're in a psychotic break. Making decisions does not prevent a doctor from saying there's a psychotic break. So we may get into that because we know that from Dr. Gregoire. We know a lot of things that the prosecution has been positing before this jury is not true. And then, as I said, the jury just heard one of them. Now, this is a pretty long sidebar that's going on right now. So I think it has to be more than what is happening with this doctor. Maybe jury charges, maybe they're discussing, tomorrow and all, but I think it has to be longer than what they're discussing with this doctor. Okay, let me go to another question we have here. Tangerine 6. Linda, do you think that the records do not have the suicide hotline back and forth, and that's why he hammered on that? Wonder if he'll circle back. Yes, there must be, and we haven't heard it. It must not be somehow in a record back and forth, in a physical record. Maybe they don't have the records from the suicide hotline because it didn't keep any, but they have the calls maybe from her phone and what she told people had happened, that they had rejected her. But because he wants to know. What was interesting, Kevin Reddington wanted to know. I don't know him. I just calling him Kevin because us defense attorneys were all on a first name basis. Mr. Reddington wanted to know where he got that information. So it must not have been from a specific record from the organization, because he wanted to know. And we don't know the significance of it, but the doctor on the stand, Sadoff, did eventually say, I can't tell you where, but I read it somewhere in the record. I read it somewhere in the record. And no one has disputed that she tried with this hotline, that they may want to rethink their procedures. And again, I had a thought yesterday that maybe it's possible now, with all these hotlines and these doctors saying, well, unless you have a plan, you're not considered suicidal, that we can help you. I think that may be something posited by some medical association in some way, on the basis that people would go to their doctors or go into even a hospital facility and say they have ideation, then they'd be released, and then they would jump out the window a few blocks down, or purposely unalive themselves. And then the person who let them go, or the organization who let them go, would be sued for malpractice, and that'd be absolute winners, right? Somewhere along the line, I think that has changed. And it's not changed from people that are concerned about mental health and what a suicidal ideation is. Because if you're having a suicidal ideation, you better have help, right? I mean, I'm suicidal, but I'm just going to sit here and no one's going to help me. I'm telling everybody and no one's going to help me. I think it has to do with some kind of decision that if the standard of care is that you don't admit them or get them immediate help, that you can't be sued for malpractice. That's my view. I'd like to have some type of student, graduate student, do a research paper on when did that change and why. Because, if it changed for the worse of the patient and to limit rights, that it wasn't done for the benefit of mental health of the patient, and to make sure that if they unalive themselves, the family would have an alternative means of trying to get some type of financial benefit. So we'll see. Reddington has reasons to ask. Now, it's interesting because usually, as you know, when we cross-examine, it's only cross-examining with we don't ask open-ended questions. Okay, you're testifying basically, and you heard the prosecutors doing it. They were even doing it on direct and all. But he has taken the tack that this witness, he knows the answer that this witness must give. So he's not doing what he was doing with the other two doctors in cross-examining, which was testifying, cross-examining them. By the way, you also notice that if he gets an answer that is not the answer he wants, he ignores it. He just continues on, which is what you do. You get the answer you don't want. You've made your point by answering the question. Okay. It made your point by asking the question. So when he goes to that and he gets an answer he doesn't want, he's already made his point because he's testified. But on the other cases, he's asking, isn't it true? Is not, do you know? Isn't it true this could happen? He's giving him an open-ended question, not saying, doctor, that postpartum depression can turn into psychosis like that, or something like that. Postpartum psychosis can turn into the triggering event that the person actually breaks with reality and performs the unthinkable, just like that. He's asking, isn't it true? Or are you aware? It's definitely true. So he's asking questions a little bit more open-ended with this witness than we normally teach you should do. And in a way, he knows the jury is eating up probably what he's saying. He's seeing that the jury is writing down. So he wants the jury to write things down. And also notice that he is going slower and asking these questions, that the postpartum can be rapid. The postpartum can happen just like that. That isn't sleep deprivation used in questioning extremists in for torture? Isn't sleep deprivation used as a torture? And the answer was yes. And this doctor had to give it because he's written papers on it, and probably Kevin has read all those papers where he's made statements like this. All right. So then he went, and I love the fact he went through her whole history every single day and got him to admit that she wasn't going to doctors to score prescriptions. She was going to get help. She was trying to get help. And whenever one doctor said, well, call this doctor or do this, she did it right immediately the next day. Or when she finished, she was the most compliant. And when she didn't want to take a drug, it wasn't because she refused to take a drug. It's because she had read about the serious side effects. That's something, by the way, the medical profession has made, that your doctor doesn't have to go over that with you anymore. It's the pharmacist that has to go over the side effects. And how do they do that? They don't sit and talk to you about them. They give you, and we've all opened our prescriptions, right? This whole leaflet thing that you roll out 7 times, and you better have a magnifying glass to read it. And in there somewhere is all the side effects. And then sometimes there'll be a black box warning, which is like, warning, 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 danger, Will Robinson. If anyone watches old movies, danger, Will Robinson, right? That the rash, that the drug that she didn't want to take, and when she told Dr. Tufts that she'd already gotten a prescription for it, it was serious. And I also thought that the fact he brought in, look, she is a nurse. The prosecution's using, she's a nurse, so she knows these things. She's a nurse, so she knows how bad drug reactions can be. And remember, she's having bad reactions. She had, in October, she had a terrible reaction that she called her mother, that heartbreaking text. He also got through this witness that the government has had everything Lindsay wrote, thought, from all of her devices and her life, has everything, and that this doctor has it all, right? That this doctor has it all. So I thought that was another thing, that he's basically trying to turn this witness, who of all the witnesses, even though he has really, he's not a postpartum expert. He's not a psychosis expert. He's not a maternal mental health expert, but he has all these other credentials that people love because they watch, TV movies, and all of you love these type of credentials. Oh, he's from the FBI Behavioral Science Unit. Well, let me put it this way. If I'm in a mental crisis, I'm not picking up and calling them, right? I'm just not. If I have postpartum depression, I'm not picking up and calling him. If I have postpartum psychosis, I'm not picking up and calling him. He was chosen for a specific reason, because he's basically a government man. He's basically doesn't like anybody who's got a mental health excuse. As a matter of fact, he uses sleep deprivation as a tool to torture people, and recognizes, not maybe him, but the government, and recognizes it. And he's written about it. And he's absolutely written about it. Okay. So, there we go with regard to that. Okay. Let me put myself a little bit. Well, I'm going to keep myself though. Did they leave? Did the court leave on the sidebar? I'll put myself on full screen for the moment, or at least a bigger screen, since if they've left, usually we see them exiting. Let me just make myself on a bigger screen. I'm going to put the court there, so you see the court's on a short break right now, just because I'm surprised we're not seeing them leaving, which normally we see the camera pan to, not that I like that, but we see the camera pan to the well. Not waiting for that. Michael Bryant, believe is in the courtroom. I don't, normally he tries to get out for these breaks, but it's very difficult to get out for these breaks. It's extremely difficult to get out for these breaks and get back in. I'm sure it's completely packed and full in there and all. So let's see, what are you all interested? Okay. All right. So Michael's, yeah, he's good. He's done this, by the way. He's absolutely done this. So we are completely on the morning break, I gather. He doesn't usually take too long though. And part of the reason is, remember, you have to deal with Lindsay Clancy, that they may have to, I'm not sure what their position is or whether they're emptying her catheter during these breaks or not. We don't know. That's really none of our business, but the judge is aware of what has to be done, because it's not your normal defendant sitting there. Okay. It's just not your normal defendant sitting there. But what I object to is that, well, actually, I shouldn't object to this witness right now in cross. I do object in his, oh yeah, she knew what she was doing. And I know one of you said you were swayed by him. She knew what she was doing because, let's see, she had planning by the distance she sent her husband, which is 4 or 6 miles. But then he says she didn't want him. The planning is because she didn't want him too far away. I guess in his mind, she didn't want him too far away so he could go back and find her out the window. I don't know. So that's why he says there's planning. She said because there was no witnesses, that there was concealment, that she had audible hearing, but he didn't think it was enough. That she was, let's see, what else did he say? There was no evidence that she was delusional about her children, he says, and that she had a really good day beforehand. She was sending photos and she was playing in the snow. Well, all that we know from the real expert in postnatal maternal care is irrelevant to anything, because the real expert would agree with what this doctor is trying to avoid. I have his little bio right there, is trying to avoid. The real expert is trying to avoid that the postpartum psychosis can happen just like that. And if she is clearly being treated for what is postpartum depression, and Dr. Gregor would probably say she has the indicia of postpartum psychosis all the way through. I mean, it may have started early on, and also with her auditory hearing, it doesn't matter if it only happens once. If it only happens once, if it's forceful enough and she's in a position that she's in that psychotic state, it doesn't matter whether it's once. He believes her auditory hearing is internal. He has no evidence of that because she said she heard it from outside. And some of the other doctors, remember, we have a disagreement that she heard it outside, this command voice telling her, And quite frankly, you look at everything that she did from September through October. I mean, and then that text with her mother, and then she continued on, and then she calls the suicide hotline. They don't help 2 times. Then she checks herself in. They don't help. It was interesting that he qualified his discussion about Dr. Tufts. Now, he clearly didn't want to say she was unqualified, but what he said is, even if you have, you basically have that certification and you've been practicing for a few months, it kind of depends on your experience and your other things that you were doing, and not just that you have an interest and then you hang up your shingle and say, I'm doing postnatal maternal health without being under the guise of some type of additional training and discussion. By the way, the issue of money, Reddington doesn't normally bring it up. I think it's a stupid issue to bring up for experts. Everybody gets paid for their time. And quite frankly, if you're an expert, you deserve to be paid for your time, and they're hiring you for your years of expertise. But this gentleman has a relationship with the University of Virginia. Now, he's on salary, but I'll guarantee you that they look to see what he brings in expert testimony to see whether or not he should remain on salary at the University of Virginia. It was an old game where people say, well, I have a foundation that does forensic work and I don't get the money, the foundation gets it. But the foundation then gives you a salary. And if you're not getting the money from different places, you're not going to be long for being employed if they don't think that he is valuable in some way. All right. And let's go through again his forensic psychiatrist that he talks about in his bio. He has worked extensively in behavioral threat assessment, especially the study of including extremists, and mass casualty violence. And that's what he was talking about. Like if a school district has somebody they want to evaluate who may have had a gun threat, he will discuss whether or not with the school district that person should put back in class. That's basically what he was talking about. That's the threat he was talking about. All right. And then he's in, this is what gives him credibility because everyone loves this. You know, he's in the behavioral analysis unit of the FBI, discuss serious crimes. But I'll guarantee you they're not, how many cases have they just done with postpartum psychosis and the killing of children? All right. All right. Let's put that aside. Then he's something called BAU3, specifically focuses on crimes against children and supports investigations involving child abuse, exploitation, and violent crimes against minors. All right. But he's not dealing with the postpartum psychosis. This is a niche area. And it's a niche area. Number one, it involves women's health. And we all know that women's health and every woman, and that's why this case is taken on the life of his own, believes they get shortchanged in terms of women's regular health care. And when you get to psychiatric health care, especially dealing with postnatal because you've had a baby, that is in the tank, certainly in this country, which doesn't even recognize postpartum psychosis, according to the psychiatrists. They don't recognize it. All right. And yet, again, we are reaching out, Joy. I know, I assume that you've already done it. I need you to reach out now, if you haven't, to the doctor at Mount Sinai that I sent you, only because we want to see if she can come on the show tonight, if we can get her on the show tonight, because tomorrow they are going to sum up and charge. And you never know whether a jury has a verdict tomorrow. I mean, you know, we're coming into the Friday, which that would be more likely, but you never know. They've been sitting on this case for a long time, and they're going to want to discuss it because they haven't been able to discuss it. All right. But you never know. We don't know how long they're going to be allowed to deliberate, whether they, you know, have a cutoff at 5 or 4 also. So we have no idea. But the juries can come in and come right out, especially when it's very clear in their mind what the decision should be made. Now, the question is, are you going to have people on the jury that aren't swayed by anything with postpartum psychosis and say she killed 3 kids, she has to go to prison? Are you, because they know. I mean, whether you tell them or not, they know. Or are they going to separate the kids out? That hasn't been a discussion. You know, and then interesting that we all know that there is a hormonal imbalance when women have babies. The hormones are raging and flying and all. And there's a lot written on that in terms of postpartum psychosis. But Dr. Gregoire said they could actually take a person who is going to have a child and try to evaluate them. They know exactly if they were at risk for postpartum psychosis. They know. They can know under the tools they have now. You know, so it's just really, really interesting. And I don't know if we're going to go here on him because he's going to insist that well, interestingly enough, he does talk about postpartum psychosis. Remember, Dr. Mack? Not coming out of my mouth because there's not such a thing. Not coming out of my mouth, postpartum psychosis, because there's not such a thing, postpartum psychosis, because it's not in the DSM-5. You know, even this doctor recognized that there's various sources for when postpartum psychosis could have. And while it may be unusual to happen later, it doesn't mean that the symptoms of postpartum psychosis weren't going on from the time she had the baby, that there'd be symptoms that maybe they didn't recognize, that no one recognized. Maybe they were small, they were little and all. But there's usually also the woman is very successful in killing herself. That's the unfortunate situation. We had a discussion last week when we had Dr. Peter Dean on from England with Dr. Gregoire. He had one as a coroner where the woman, you know, kissed them, wrote little notes to them, everything, and ended up killing the 4 kids and herself. And then we discussed last night with Dr. Gregoire a sad case of a woman police officer who had a baby who ended up killing herself and the baby, right? Just unbelievable. Oh, my earrings. Okay, every once in a while we do a fashion. We just do it. we intersperse fashion because this is such a difficult subject. So these earrings are on Amazon. You know that I love my Amazon with all my other stuff. So there you can get them in all different colors. If I have a link later on, I'll try to post it for you, Katie. Okay. So now let's go back. I'd be shocked if there's a verdict on Friday. Tangle Charlie, do you think that they're going to wait over the weekend? Could be, because they want to discuss these earrings. Yeah, you want to discuss these earrings. They want to discuss the case. I don't think they want to discuss my earrings at all. But when we go back into Tim Curry passed, Tim Curry died. Oh my goodness, not Tim Curry and Dolly Parton in the space of 2 days. Oh my God, I'm sorry. I got waylaid here because this is becoming too much to bear. Okay, this is becoming just too much to bear. In our own little way of too much to bear. Think about being poor, Lindsay Clancy, and what she was doing. Okay, we're coming back into court, so I'm going to pod myself, and we'll talk later.
All right, counsel, we ready for the jury?
Yes, Your Honor.
Yes.
All right.
Order. All right. Jurors entering. This court's now in session. Please be seated.
All right, counsel.
Thank you, Judge. Sir, when we left off, I believe the question was that, and you agreed, the sudden drop can cause significant GABA dysfunction. Recall that question where we broke off talking about the gamma? And you're familiar with the concept of, in that regard, talking about the gamma aminal butyric acid and its effect on the progesterone and its effect on the brain synapses, is referred to as breaks, B-R-E-A-K-S. You've heard of that term, right?
No.
You aware, sir, that when you get to the point where you have that precipitous drop in the progesterone and the allopregnanolone dropping precipitously, that in fact it constitutes and causes significant neurotransmitter malfunction, referred to as broken brakes.
I'm not familiar with that term.
Can you tell me what a neurotransmitter in the brain is?
You're asking what is a neurotransmitter?
Sure. I don't know.
Neurotransmitters function in the brain and have responsibility for not only aspects of mood, but also psychosis. Dopamine is a neurotransmitter that is significant in terms of psychosis. When it's too high, we need it. But the neurotransmitters function in a number of different ways, number of different pathways. When we think about psychiatry, we really think about the mesolimbic pathway and not just dopamine, but also serotonin, norepinephrine. And so depending on the disorder, there are different medications that can be helpful in treating those disorders. So really, from the standpoint of psychiatric illness and brain dysfunction, medication can be very helpful in regulating the neurotransmitters and difficulties.
Have you heard of the broken brakes hypothesis as it relates to the impact of the precipitous drop of progesterone in the enhancement of the GABA activity? Have you heard of that concept?
No.
Would you agree, sir, that when a woman is in that position of the precipitous drop of the progesterone after ceasing the breastfeeding activity, the enhancement with the GABA?
You mean prolactin?
Prolactin, the enhancement of the GABA activity, that that would be a dysfunction in the brain, right?
Certainly, mood symptoms
Okay.
can be significant.
Would you agree, sir, that the dysfunction in the brain caused by those two items is consistent with intrusive and hard to control thoughts and highly impulsive, uncontrollable behavior? Would you agree with that?
I would say it's possible.
And that would relate to the capacity of a person to conform their conduct. If, in fact, because of the GABA and the progesterone and all that we just talked about, the intrusive, hard to control thoughts and highly impulsive, uncontrollable behavior would address itself to the issue of capacity to conform one's conduct, right?
No, I mean, it depends on the timing. If you're talking
Is the answer no?
at 8 months,
Yeah, hold on. You gotta let doctor finish. Did you finish that answer?
yes.
Okay. All right, go ahead. Next question.
So, did I hear you say that Patrick is the source, the third-party collateral source of Lindsay saying, I tried to kill myself? Is that what you said? Let me rephrase it for you. I mean, did you tell the jury about an hour ago or so that?
When her husband found her on the ground?
Yeah,
Yes, or something to that effect.
something to that effect, okay. And did you listen to the 911 tape when Patrick was actually speaking with Lindsay as she's laying prostrate in the snow on the ground with a broken neck and slashes and slits?
Yes, I did.
Did you hear her response to Patrick's comment? What did you do?
No.
Did you hear her respond to anything other than what would be described as guttural grunts?
Not on that call.
So when this conversation occurred, and this is the conversation that you're talking about, where she said, I tried to kill myself, kids are in the basement, he then goes into the house, right?
Correct.
All right. So now we have the EMTs and people are helping her out. You've seen the medical records. You know what the injuries were. You know the damage to her throat. You know the damage to her thyroid, right?
Yes.
And is it your testimony to a reasonable degree of doctor certainty that a person with those injuries, with the prescription drugs that were crushed up that she consumed, with a broken neck, would be able to have a conversation?
Based on the witness testimony from her husband, yes.
Okay. So let's put the witness testimony from Patrick aside for a minute. And you listen to the 911 call. Are you telling this jury that she had a conversation that you could discern what she was saying?
Not on the 911 call.
No. Would you agree that they were all grunts?
Yes, from what I heard.
So Patrick goes in the house, relates the fact that he found the children, and you told the jury that his office door was closed, is what he said. Is that right?
Yes.
Where did you get that from?
I believe Patrick told me that.
Is that in your report?
Yes.
And when he told you
It's-
that, when was that conversation that you had with Patrick?
When I interviewed Patrick Clancy.
Okay. So you read the grand jury minutes, right?
Yes.
You read the police report, right?
Yes.
You know that Patrick went up the stairs, and when he went up the stairs, the door was locked, right? Meaning the bedroom door, not the office door.
Correct.
And then he was able to open the door, right?
Yes. With
And
a
there
key.
there was blood on the doorknob, right?
there was blood in the room on the
Describe the room.
on the
blood.
floor.
Certainly, you already talked, we'll talk about that, but there's blood on the doorknob, right? Was there blood on the doorknob, if you know?
I don't recall.
Do you recall there being blood drops in the area of the door itself, like, where you have the threshold? But what appeared to be blood, because nobody tested it, we don't know what it is, but it appeared to be blood.
I don't recall the specific. I know that there was blood that was observed.
Okay. And you would agree that there was a lot of blood drops, drips on the mirror, drops on the floor, drops on the nightstand, right?
That's my recollection.
And you looked at the photographs in your investigation and looked at the testimony, third-party collaterals, as you testified yesterday, right?
Yes.
And you told the jurors that one of the things that was of interest to you is the fact that there was a glass or a wine mug or something that had crushed narcotics or I think he used the word antipsychotic drugs, crushed up inside that cup. Do you remember that?
Yes.
Okay.
Wine tumbler.
Thank you. How do you know they were antipsychotic drugs?
I don't recall saying that they were antipsychotic drugs.
Oh, did you say they were drugs?
I thought I said medications.
Medications. All right, so drugs, medications, and they were crushed up?
There was evidence of powder on the tumbler that Patrick told me about, and I went back and looked more closely at the photographs and saw that.
Did you look more closely at the NMS laboratory or the state police crime laboratory or any testing that was done on the powder?
Yes.
And was there a report that said that indeed it was crushed up medication?
They wouldn't.
I mean, there is.
They didn't indicate whether or not they were pills or.
Did they ever? I'm not asking about pills or powder. Did they ever test the residue?
Not that I'm aware of.
So how do we know that that's even drugs or medications or whatever word you want to use?
It was Patrick Clancy's observation.
So basically, when you're testifying, sir, and you're waxing on about all of the facts of the case that you took into consideration prior to your opinion for the DA in this case, you're getting a lot of it from Patrick, is that right?
That aspect he brought up to me, yes.
Okay. So the crushing of the pills, was there a pill crusher found in the bedroom?
Not that I'm aware of.
Was there any residue found anywhere in the bedroom?
Not that I'm aware of.
So if someone's in a psychotic state and they're going to kill themselves and they're taking the pills, yesterday you said the fistful of pills, and then the DA said after painful questioning that they were crushed, you agreed that they were crushed. Wouldn't there be a residue?
A residue?
Yeah, you know what a residue is, right?
Yes.
Was there a residue on the table, on the nightstand, anywhere?
Not that I saw.
So there's no pill crusher, right?
Not that I saw.
There's no investigation by the police to determine what was in that powder, right?
Not that I'm aware of.
There's no indication that there's any residue on or in the actual nightstand next to the bed, right?
Not that I'm aware of.
Does it seem appropriate, sir, that a person would be in a psychotic state after slashing their wrist and slicing their throat and ready to propel themselves out a window would neatly put the bottles into the drawer of the nightstand? Or would they just scatter them around the bedroom floor, not caring?
I'm not aware of the exact sequence of the events in terms
Well,
of.
if I tell you, sir, that a couple of days after this incident, I went into the home with Patrick and I was able to locate in the bedroom, right next to the bed, with all the blood all over the place, this drawer, and inside this drawer would be a lot of medication bottles. Does that refresh your memory on your investigation as to what happened to the bottles? They're all empty.
Yes.
Okay, so how'd they get in the drawer?
How did they get in the drawer? I don't know.
You can fingerprint them, right? Did did anybody do any testing at all in this investigation? If you know, you told the jury yesterday you read all this stuff, grand jury minutes, police reports, lots of witnesses.
Yeah, I did not read that.
Is it your understanding, sir, that a person can be in a state of psychosis and I guess misremember something?
Yes,
Or have a false memory?
it's possible.
Did Lindsay tell you that she slashed the screen with the big turkey knife?
I'm sorry, can you repeat that?
Yeah, did she tell you that she slashed the screen with the knife before she went out the window?
Yes, that's what she told me.
But the screen wasn't slashed, was it? Do you think she was malingering and lying to you at that point, sir, when she told you that?
No.
Because one of the things you told this jury is that what stood out to you is I think you made reference to the fact that Lindsay betrayed her family by misleading her family. Remember saying that to this jury yesterday, sir?
Portrayed?
Betrayed is what you said.
No, I said portrayed.
So Lindsay portrayed and misled her family, is what you said to the jury?
Yes.
How did she mislead her family?
Well, in text messages, for example, in the days prior to the event, her parents had visited over that weekend, and the communications that she was providing did not give a sense of her state of mind regarding suicidality.
You kidding me? They stayed up in their house to help them.
Sustained. Next.
They stayed at the house, didn't they?
Yes.
Why did they stay at the house?
I'm sorry.
Why did they stay at the house?
They were visiting.
They were staying at the house. They weren't just visiting.
Objection.
Overall.
Sleep over?
As I understand.
Okay, as you understand. How long did they stay at the house and sleep over?
I think they came up for that weekend. They weren't there constantly.
No,
They came back and forth.
back and forth. Well, they stayed about 4 days, 3 nights. They stayed continuously and stayed at the Clancy home. You knew that from your investigation, right?
Yes, that's my
yes?
recollection.
Answer's yes, right?
Yes.
Okay. So they're staying at the same time. You're telling this jury that she's sending text messages basically saying, I'm okay, I guess. Is that right?
Following their departure, there were the photographs that Lindsay Clancy sent to her mother.
She didn't send her mother photographs showing that she was smiling or happy with her family, did she?
I think there was a photograph of her and the children by the snowman.
No. Is that a bad thing to do that and send a picture of you with your kids making a snowman to your parents?
No.
Is that something, in your opinion, Dr. Sidoff's opinion for the district attorney, that a person who is involved with postpartum psychosis, postpartum depression, wouldn't take a picture of the snowman and their kids, send it to their mother?
Given the prior text that you showed to her mother in terms of being in terrible distress, that she was able to do that, that was not what happened when she sent the picture with her children and the snowman, and so did not raise concerns from the mother, as I understand.
Did you talk to the mother?
Pardon me?
Did you talk to the mother?
No, I tried to.
Did you review police reports or statements? You tried to? How'd you do that? What'd you do? Call her up and say, I want to talk to you?
No.
Did the district attorney call him up?
I asked Ms. Clancy who would be good for me to speak with, and she said her husband and her family.
Okay. So based on that, what did you do?
I contacted the district attorney, and I,
Which one? Which one of these two?
Ms. Sprague.
Ms. Sprague. Okay. You spoke to Jen Sprague, and what did you say to her? Was it?
Attorney Sprague.
You spoke to Jen Sprague, and what did she tell you?
Attorney Sprague.
She told me that she would reach out and attempt to see if I could interview Mr. Clancy and Ms. Clancy's family.
Okay. So did you do that? Did you reach out to her mother?
Did I reach out?
Yeah.
No.
Okay. Did someone tell you that she wouldn't speak to you?
Yes.
And when was this, sir? About 2 months ago?
It would have been probably June 5th.
This is August, right?
Pardon
This
me.
is August. We're in August right now, right?
Yes.
You called to speak to the mother in June, right? Yes? Come on.
Yes.
Okay. And when you called the mother, did she say,
I did not call the mother.
Okay, so the
I did
answer
not
is you
call
did
the
not
mother.
call the mother. Who told you that you couldn't talk to the mother?
Ms. Sprague.
Attorney Sprague, please.
Right. Attorney Sprague.
Now, when Attorney Sprague called you and said you cannot talk to the mother, did it ever occur to you to reach out to me? You're being objective and all.
No.
Did you know, sir, that Lindsay had signed repeatedly every and any HIPAA form that was needed by the DA or other cops to get access to every single medical record that she had? Probably going back to when she was in grammar school. Did you know that?
I know she's been open to it, and she told me that she would like for me to speak with them.
Right. And she's been open to pretty much anything and everything that was asked of her as far as signing documents, getting medical records, doing interviews, videotaping, making appointments to talk to guys like Mac in Helbrunn and you in Tewksbury Hospital, right?
I'm sorry, can you repeat the question?
All of your investigations, sir, led up to the fact that you were going to meet with Lindsay 2 months ago, 2 months prior to our beginning this 5-week triple murder trial. Is that fair?
That's true.
And you told this jury that you wanted to establish a rapport with this kid?
Yes.
Do you think for 1 minute, when you're trying to put her in jail for her life, that she wants to talk to you and have a rapport?
Sustained. Next question.
Did you establish a rapport?
I believe so.
She was cooperative?
Yes.
She was polite?
Yes.
She was pleasant?
Yes. And I asked her at the end if there was any question that I had asked that made her feel uncomfortable, and she responded in a positive way.
Okay. One of the things that you told the jury is that you felt that she was malingering, or basically lying. I guess you were telling the jury, in your opinion, that she was making stuff up to make herself look like she's crazy when she killed the children. Is that what you told the jury?
I didn't use those words.
No, you're a little more finesse than I was. But nevertheless, sir, you're talking about malingering, right?
Yes, the statements about the auditory
Answer is yes.
hallucination.
Excuse me.
Yes.
The answer is yes. You were talking about malingering is my question. Yes or no, right? That's all.
Yes.
Okay. And when you're talking about malingering, sir, basically that would be when a person finds it in their interest to basically exaggerate or lie to an investigating psychiatrist, right?
Correct.
And that would be because it's in their interest, like I want to pretend that I'm crazy so a jury thinks I'm crazy and I don't have to pay for a crime. That would be in a criminal sense, right?
Yes.
Workman's comp cases, you know, a guy gets hurt in the truck and then they end up having interviews by guys like you to make sure to see if in fact they're legitimately hurt for a workman's comp claim, right?
Yes.
Or a civil case, like an auto accident, right?
Yes.
And there are tests that can be administered to people to see, from a psychiatrist standpoint, whether or not there is objective indicia of the fact that the person is indeed malingering.
Yes.
And what are those tests?
Well, I'm not a neuropsychologist, but there's a test called the SIRS, also the TOMS test of memory. So there are certain tests that can be given by neuropsychologists to assess malingering about certain aspects, certain issues.
You've also heard, I imagine, of the MMPI, which is the Minnesota Multiphasic Personality Inventory Test, right?
Yes.
And that's one that has different scales that you can examine to determine if somebody is lying or malingering or exaggerating or anything like that, right?
Correct.
And you know that Dr. Helbrun administered that very test to Lindsay about, I don't know, 2 months before you got there, right?
Yes.
Which would be about 4 months from now, where we stand now, right?
Something like that.
And would you agree, sir, that even though it would have been perhaps better to actually meet with Lindsay within the first 6 months after the incident, or a year even, or maybe even 2 years, but nevertheless, it still has reliability and validity, does it not, when it's administered to her?
The MMPI does, yes.
Okay. And you know, sir, that she, in fact, had no impact on the scales at all, with the exception of likelihood of suicide.
Yes, that's my understanding.
Indicating that as far as that test that was administered to her by Dr. Helbrun did not have any evidence at all. This kid was lying, exaggerating, suppressing anything. She was being truthful, right?
Objection.
Overruled.
About the questions that were on the MMPI, yes.
And those questions, sir, pertain to personality traits, they pertain to her recollection, they pertain to all of the investigation that Helbrun was conducting, right?
No.
Okay. So when the tests were administered and the results were provided, would you agree with me, yes or no, that specifically the test indicated that she was not malingering?
Yes.
Okay. You mentioned one of the other things that you were concerned. Oh, by the way, would you agree with me that Dr. Philip Resnick, as you indicated, is like a world-renowned person on filicide, or the killing of your children? He's also a person that is in the forefront pretty much worldwide on malingering, right?
Yes, he has written about that.
He's done more than write about it. He's basically given hundreds of lectures and many, many, many learned treatises, all about people that lie to psychiatrists to try to get away with something, right? Right?
Yes.
Okay. And you know, sir, that Dr. Resnick examined Lindsay, and one of the first things that he did was determine whether or not, in his opinion, she was malingering, lying, suppressing, exaggerating, or doing anything like that, right?
Yes.
In his opinion, sir, when you read his report after all the testing of his examination, is that she was not lying to him at all. Isn't that right?
Yes.
One of the things that you referenced, sir, was you felt that Lindsay was lying about standing at the refrigerator and making chicken McNuggets or whatever, and carrots or peas or something. And you felt that that wasn't right because the child had already had a bowl and was eating, I think you told the jury, chicken nuggets and vegetables or something like that, right?
Green beans.
Green beans. Have you looked at the photograph, sir, that's in evidence in this case about that bowl?
quite some time ago.
Does that show any residue of chicken nuggets or green beans in the bowl?
Not that I recall.
No, it shows like sliced up residue of a cucumber, possibly a carrot, like vegetables, right?
Not that I recall.
So there are 3 kids, one of which is an infant who obviously pretty recently got finished breastfeeding, is on the bottle, so he's not going to eat chicken McNuggets, right?
Right.
So we have 2 young children that have to be fed, correct?
Yes.
You have 2 young children that Lindsay indicated that she was at the refrigerator getting the chicken and the vegetables so that she could feed the kids, correct?
Yes.
Told you that she would not give the kids chicken McNuggets and vegetables in a bowl, that she would have a plate, right?
Not necessarily.
So when she was at the refrigerator, sir, it's your understanding that she was not being truthful? Telling you that? Is that what you're telling the jury?
I think what I said was very inconsistent with what she had told Dr. Spinelli.
So when she's at the refrigerator and telling you, your interview, I know you imported Dr. Spinelli's report, you imported Dr. Resnick's report, you imported Dr. Zeisel's report. When you were talking to Lindsay, did she tell you she was getting food for the kids out of the fridge?
That's my recollection.
Now, with all of the understanding in your testimony, sir, about the voices, correct me if I'm wrong, you're telling this jury and Dr. Satoff's opinion, based on your experience and all of your writings and everything, that when one hears voices, they would be internal or external? To be legit.
They can be either.
Really? I'm sorry, I thought you said that they had to be a particular type, like not internal. If they're internal, they're probably lying. But that's not true, I'm wrong?
The voice that Ms. Clancy told me about during the time of this event, she said was external.
Okay. And is that consistent with your understanding, sir, of the research on auditory hallucinations?
Well, some auditory hallucinations can be internal.
So,
for people who are psychotic.
and you were aware, sir, that Philip Resnick, Dr. Resnick, did publish the article in the International Journal of Law and Psychiatry in 2014 in conjunction with Simon McCarthy-Jones. You're aware of that learned
Yes.
treatise? Yes. And would you agree with me, sir, that in fact, just if some doctors might feel that hallucinations auditory must originate from the exterior as opposed to interior? Would you agree, sir, that in this article, claim number 1, doctors may say, voices are typically heard as coming from inside the head, with the corollary that voices heard as coming from outside the head are atypical? Would you agree with that?
That was not my recollection of the research. That
Okay.
I understood that it was a minority of.
No, excuse me. It doesn't matter what you.
Oh, hold on. Good. Next question.
I'm going to approach you with the article. We've already established. Who authored it, read it, all that.
It was quite some time ago.
Okay? Sure. So, if we can share that?
Do you want me to say it?
No, I want you to share it. Put it right here so I can look at it. Okay. Would you agree, sir, that it says voices are typically heard? This is a claim number 1. In other words, doctors feel voices are typically heard as coming from inside the head, with the corollary that voices heard as coming from outside the head are atypical. Did I read that right?
Yes.
Okay. And what does atypical mean?
Atypical means unusual.
And this article is saying that there are psychiatrists that feel that voices heard outside of the head, auditory hallucinations, are indeed not legitimate. Is that fair?
That was the old original way of thinking. That was the way it was taught at one time, that they had to be external for someone to actually be experiencing psychosis.
Okay, so we agree then, as Dr. Resnick indicates, that the research evidence does not support the claim that internal located voices are emblematic of genuine AVH,
Auditory verbal hallucinations.
and externally located voices are atypical. We cite to a particular work, correct?
Yes.
For example, he then says, the largest study on this question, Kathy Jones, was in 2012. That's what you're referring to as the old research, right? Oh, whenever you were in med school, we talked about that too.
Yeah, I was speaking about very old.
Okay. Basically found that of 199 psychiatric patients, 81% who have been diagnosed with schizophrenia, 38% heard both voices coming from inside and outside their head. Did I read that right?
You did.
So when Lindsay indicated to you that she indeed heard a loud auditory hallucination, voice, deep male, commanding her to do what she told you, that was external, correct?
Yes.
And you don't have any issues with that. In other words, that is very likely could be legitimate.
Yes.
Okay. Now, if you take a young woman who, as the evidence has shown, is suffering with her medical condition and psychiatric condition and seeing doctors and being prescribed medications and reaching out to people for help and suicide hotlines and people down in Rhode Island and McLean Locked Wards Institute. If I hold an opening statement, sir, would you agree that in her efforts to maintain control, she, meaning Lindsay, withheld?
Form of the question?
Yeah, if we could approach.
Sure.
Okay. All right. Here we are again. All right. We have an objection. I don't know what the objection is. He's already gotten in. A lot of judges wouldn't allow you to read, to cross-examine from an article unless the treatise was considered learned. But apparently, you see, by allowing this gentleman witness to say that Dr. Resnick was the world-leading expert in malingering and in postpartum psychosis, basically dealing with filicide, and probably has to do that because Resnick testifies for both sides. He's testified for the government. He's testified for the defense. So so he's not going to badmouth Resnick for whatever reason. And then Reddington was able to cross on the article. Not only cross, but remember, one of the other doctors had claimed that because the hallucinations, he said Lindsay's hallucinations were internal. One of the other doctors, when she said they're external, but it doesn't matter because even though generally the theory was that external hallucinations would be compatible with postpartum psychosis, so are internal, as it turns out. And that Lindsay was also
Based on
not
your
malingering.
investigation,
Let's go back.
police reports, statements of witnesses, grand jury, photographs, videos, interviews of Lindsay, review of witness statements, all of that you told us yesterday that you reviewed. That in fact, on January 24th of 2023, Lindsay made a calculated decision. She was a woman who no longer liked the life she thought she wanted. It was getting harder and harder for her to control. And when she saw the opportunity to escape, she made the selfish choice to take it and to take Cora, Dawson, and Callan first before attempting to take her own life. Continuing on, sir, she chose to manipulate her providers, seek out a quick and easy fix when she was feeling depressed and anxious, and when she didn't get what she expected, she chose the alternate route. She would seek a different doctor. She would change medications after days. She disengaged from treatment that she didn't like the plan, and after only 4 months in treatment, she made a choice, a deliberate and intentional decision that she did not want to try anymore. And because no one could take care of her kids the way she wanted them to, she had to take them with her too. Would you agree that the evidence, in your opinion, supports that contention, sir?
Well, there's a lot in that.
Yeah, it is. Do you agree that it would support your contention, sir, or it would not?
I think that statement that you read really minimizes what she was going through.
Okay. All right, thank you.
Attorney Sprague?
Thank you, Your Honor. Sir, you were asked during cross-examination about your work as a forensic psychiatrist for the Bureau of Prisons and for the prisons in Virginia. And about that work and kind of minimizing what your experience was there. What was your work there? What did that entail?
Well, I continued to work there, and I continued to teach students in that system. Seeing patients who are inmates in a number of different facilities, men's and women's facilities over the years, and doing assessments, evaluations, making determinations about treatment, and the like, gathering information. So really, treating these inmate patients as patients who have significant mental illness and really require the best treatment that we can provide in the system.
And during the course of your many, many years working in that system and treating these patients, have you treated patients with psychosis?
Yes.
And does that include treating women with psychosis?
Yes.
And how often have you done that?
I'm going to object. I didn't ask about who. He said two already. He's already said once.
Overall, she may have that. Go ahead.
Since 1992,
Yes.
so 34 years.
How many patients have you treated in the prison system, women patients dealing with psychosis, approximately?
Several hundred.
And are there certain common signs or symptoms that these women display who have psychosis?
Yes.
And what are those?
Well, some have delusions, fixed false beliefs about certain things. So they can present as being psychotic that way. Also, they can present with hallucinations, what we call perceptual disturbances. And generally, they are, in most cases, auditory hallucinations, auditory verbal hallucinations. And they also can present with disorganized thinking, having words, making up words that have special meaning, really having a great difficulty communicating.
And you also mentioned that you all worked for a state hospital for, I think you said 15 years, is that correct?
Correct.
And did you treat patients with psychosis during those 15 years?
Yes.
And did those include women with psychosis?
Yes.
And in terms of your treatment of women with psychosis, were you responsible for diagnosing them with their underlying mental condition?
Yes.
Diagnosing psychosis as being one of their symptoms?
Correct.
And then treating the underlying condition and the symptom of psychosis for those women?
Yes.
And you did that for approximately 15 years, correct?
Yes.
And you mentioned two specific patients, females that you dealt with postpartum depression or postpartum psychosis. Do you recall that?
Yes.
And what did you learn from treating those two patients?
So those are the two patients that are mentioned in the case reports.
Which case reports?
The case report about postpartum psychosis that was written.
On the medication interaction?
Yes. Are you asking how those patients presented?
Yes.
Okay. There were, as I recall, it's been a while since I looked at the paper, but one was an 18-year-old woman who had delivered her child and had decided not to take, or that she did not want to breastfeed. And so in those days, this medication, bromocriptine, also called Parladel, was given. And we found that within, I think, just a couple of days of the time that she was given this medication, she became convinced that she had to kill her child. And I believe that she was experiencing auditory hallucinations, and she was so distressed about that she wanted to kill herself and was suicidal. And that was how she was brought to our attention. In evaluating her, we removed the Parladel, the bromocriptine, and she responded and resolved her symptoms, her psychotic symptoms, and we were able to discharge her back to her family. The other case, I believe, was another female, a bit older, maybe mid-20s, and she was also given this medication and also became psychotic. For her, it was more a manifestation of mania. She was hypersexual with her husband. She, I think, was quite hyper-religious, and she was...
Doctor,
sorry.
in terms of her delusions, those were more of religious delusions?
Pardon me?
Her delusions regarding her child were religious delusions?
Yes, I believe so.
Okay. And once that medication was removed from that woman, did her symptoms subside?
Yes. I think in that case, she was also given, she was so disruptive on the ward, taking her clothes off, et cetera, that she was also given antipsychotic medication for a period of time, and her symptoms resolved.
And going back to the first patient that you described, you said that she had voices instructing her to harm her child. And was it as a result of her feelings of guilt for about those thoughts and voices that she was suicidal?
Yes.
So she wanted to kill herself instead of killing her children, correct?
Yes.
Now, you were asked by Attorney Reddington about your curriculum vitae and focusing in on terrorism, and is that your sole focus? And you said no. What has been your focus over your career?
Well, from the time that I finished my residency, I've been very interested in public psychiatry. And so upon realizing the seriousness of mental illness within the prison system and the value of teaching psychiatry to students within the system, I began doing that while I was also doing work with the state hospitals, seeing patients, whatever. I would say that of all the things that I do and consider myself, what is most important to me is working with patients. And it's the value of also being with students and having them learn from these patients is going to make them better doctors, even if they don't choose to go into psychiatry. So I see my identity actually as a clinician, and I have patients I'm scheduled to see. I was supposed to see some yesterday, and also I'm going to see patients on Friday.
And Doctor, defense counsel asked you about the onset of postpartum depression and postpartum psychosis. And you had said that the DSM-5 lists postpartum onset within 4 weeks, correct?
Correct.
And he asked you about other organizations going up to approximately a year, correct?
That's right.
Are you aware that the World Health Organization has a clinical descriptions and diagnostic requirements for behavioral and neurodevelopmental disorders that has a section on mental and behavioral disorders associated with pregnancy, childbirth, or the puerium, P-U-E-R-P-E-R-I-M, which does that mean during or after birth?
Yes.
And that in that section by the World Health Organization, they state that mental and
Objection. She's not going to read that to him, and then he's going to agree with it. She can ask him if he's read
Well,
it.
let's hear the question first, and then I'll assume there'll be an objection.
Are you aware that in that section it states that mental and behavioral disorders associated with pregnancy, childbirth, or the puerperium are syndromes associated with pregnancy or the puerperium commencing within about 6 weeks after delivery?
Objection overruled. I'll allow that if you know that, Doctor.
Yes.
And are you also aware that there's a section talking about mental and behavioral disorders associated with pregnancy, childbirth, or the puerperium with psychotic symptoms that says onset of a syndrome involving significant mental and behavioral features occurring during pregnancy or the puerperium, i.e. up to about 6 weeks following delivery, is required for diagnosis?
That's my understanding.
And that's from the World Health Organization, correct?
Yes.
Now, you were asked about whether blood testing would be appropriate for a patient, and you said that it would depend on the history of the patient, the symptoms, the medication. Do you recall that?
Yes.
Okay. Did you see anything in the records about Lindsay Clancy that would have required blood testing?
No.
You were also asked about thyroid function and how sometimes you might want to test thyroid function in a postpartum woman. Do you recall that?
Yes.
Do you, are you aware that, reading from Exhibit 222, I believe, that Ms. Clancy's thyroid levels were checked when she visited the South Shore Hospital emergency room on November 16th, 2022, and her levels were within normal limits?
Yes.
I just moved to submit this page from Exhibit 222, showing the thyroid levels.
All right, so that's in. It's just a follow-up of a sheet that's in. I'll allow that.
And doctor, just for the jury to know, in that page that's just been marked in as exhibit, the thyroid levels would be marked by TSH, correct?
Correct.
You were asked about Lamictal and the serious rash that could occur. You said that the serious rash is rare. How rare is it?
Approximately 1 in 1,000.
And you mentioned that millions of people take Lamictal with no problem at all, correct?
That's right.
And is there anything that providers do to be aware of the potential for the rash and to explain that to patients and to try to just basically keep an eye out to see if the patient's developing that symptom?
Yes.
And what is that?
It's a medication that needs to be started at a low dose, 25 milligrams, and only gradually moving up. Finally, after a number of weeks, to a dose as much as 200 milligrams, perhaps even more. When the medication is given in a what we call titrated, slow process, the potential for this serious rash is greatly decreased. So it really is a medication that requires a slow titration. So the patient needs to be patient with that process, but it's now one of the most used mood stabilizers for bipolar disorder. That it really is a very, very important, valuable medicine for bipolar disorder.
And you said that it's important to start at a low dose. Did you say 25 milligrams?
Correct.
And do you recall what dose Dr. Tufts wrote the prescription for Ms. Clancy?
Yes,
And what was that?
25 milligrams.
And do you recall from the records whether the plan was, if she were to take it, to titrate in the manner you described?
Correct.
And putting aside whether or not someone chooses to take the medication because of a rash, is there any significance to the person, to a patient being prescribed a medication and then not telling that provider that they chose not to take it?
Yes.
And what is that?
Well, it really limits the provider in making other decisions. If a decision is made that a patient is not going to take a certain category of medication, it's helpful to let that provider know. Say, I've decided against it. What are some other alternatives?
Doctor, you were asked about lack of sleep potentially causing psychosis, correct?
Correct.
And sleep was definitely an issue for Ms. Clancy in the fall leading into December of 2022, correct?
Yes.
And looking back to the McLean records, would it be accurate to state that her sleep got progressively better while at McLean?
Yes.
And then directing your memory to the text messages that Ms. Clancy had with her mother from January 7th through January 22nd of 2023, would it be accurate to state that she told her mother she was sleeping better during that time?
Yes.
Defense counsel asked you if by all the evidence and witnesses that the defendant was a happy wife, mother, daughter, all of that, and you said no. What were you referring to when you said no?
Well, I was thinking about the paper that she filled out on September 12th of 2022, in which she expressed some of the concerns that she had, significant anxiety, but also, as I recall, insomnia was a concern of hers. And it was followed up with Jennifer McAllister, who worked with Dr. Tufts. And I think in Ms. McAllister's note, Ms. Clancy mentioned that she had waning confidence in being able to take care of her children as they were growing up. And that, I think, in a note of Dr. Tufts noted that she said that she found that Callan needed more attention, and that as the kids were growing older, that she was finding them more challenging.
Did she give any information did Ms. Clancy give any information about why it was more challenging as the kids got older?
I'm going to object, this is pretty far afield.
Yeah, sustained. It goes beyond cross.
So, Doctor, defense counsel asked you about Dr. Tufts and her treatment of the defendant, and mentioned repeatedly how she'd only been in the practice on her own for a few months. Do you remember that?
Yes.
In reviewing Dr. Tufts' treatment of the defendant and the medications she prescribed and the methods she used in prescribing those medications, did you have any issues or concerns about the approach she took or what she prescribed?
No.
And what were your thoughts about her approach to treating this defendant?
Well, possibly because Dr. Tufts was new and had just come into practice, she was more available. And so I think she was able to see Ms. Clancy over video 14 times. And for example, when Ms. Clancy was discharged from McLean, the request from McLean was that she needed immediate outpatient follow-up. And so Dr. Tufts arranged it the following day. And so there were some weeks where Dr. Tufts saw Ms. Clancy more than once a week. And I will also say that when Ms. Clancy decided to go to nurse practitioner Paul and then saw Nurse Gelada, I think early December, it might have been December 1st, she then went to Dr. Tufts, and Dr. Tufts wrote a note saying that she felt uncomfortable making prescriptions while Ms. Clancy was going to another provider. But in that note, suggested that Lamictal could be helpful. So Dr. Tufts was very responsive to concerns of Ms. Clancy in terms of seeing her. Was seeing her weekly and saw her on the 23rd of January, and then had another appointment the next week and had talked about future treatments, possible treatments, esketamine, as well as TMS. So perhaps the fact that she had just left her residency meant that she could be more responsive to seeing patients quickly, and she did that.
And speaking specifically to the prescribing, prescribing which medications she's prescribed, which doses, what different options she tried. Did you have an opinion based on your training and experience of Dr. Tufts' method with prescriptions?
Yes.
And what was that?
I felt that the prescribing was very reasonable.
How so?
Well, back in 2013, 2014, Ms. Clancy had taken Prozac and SSRI, and it was helpful. She also took Wellbutrin and propranolol. After Dawson was born, Ms. Clancy had some significant anxiety and actually went to a doctor and was prescribed Zoloft. So this would have been in 2019. But then decided, 2019, early 2020, but then decided not to take the Zoloft. Her anxiety symptoms resolved. It was a difficult time, particularly as she got older because of COVID. But she decided that even though she had the prescription of Zoloft, she decided not to take it. The anxiety that she experienced after Callan's birth was more significant and lasted longer. And so she went to Dr. Tufts, who got a history of Ms. Clancy having taken the Prozac and done well on it, having seriously considered Zoloft to the extent that she got a prescription for it, decided not to take it, that Zoloft at 25 milligrams, which is the lowest dose, starting that, would be a reasonable choice. Really, perhaps the most reasonable choice of an antidepressant, given Ms. Clancy's history up to that point. I believe that there were only 7 pills taken. Ms. Clancy was directed to take 25 milligrams for a week and then increased to 50 milligrams, two tablets, but had, I think maybe after 5 days, taken that increase and increased from 25 to 50 milligrams, and then had the adverse reaction of insomnia. I mean, very significant insomnia.
And in terms of after seeing the effects from the Zoloft and stopping that prescription, the various prescriptions that Dr. Tufts tried with the defendant, did you have an opinion based on your training experience about whether that trial and error process and what she prescribed and what she tried with the defendant, whether that was reasonable?
Overruled.
Yes.
And was it reasonable?
Was it reasonable?
Yes.
Yes.
And how so?
Well, Ms. Clancy, after having the insomnia, was very upset and concerned, as anyone would be. I think that was around October 21st. And so Dr. Tufts assessed her and told her to stop the Zoloft, and started her on Ativan, I understand, and Benadryl. And that medication was helpful for a while. But Ms. Clancy was concerned about Ativan, benzodiazepines being addictive, and concerned about getting hooked on these types of medications. And that is a concern over the long term. And so part of the process was to see if she could be treated effectively by decreasing the benzodiazepines, or maybe giving her a longer acting benzodiazepine. The medication buspirone, was prescribed by Dr. Tufts, but Ms. Clancy, in a note.
Excuse me, doctor, I apologize. Can I have a standing objection to the rambling answers? This is redirect. I object.
All right. We can see counsel. I just want to put something on the record. Counsel.
Okay, we're gonna put something on the record. I don't know what the judge wants to put on the record, but yeah, we're rambling. I was actually answering other emails because we're rambling here. But what have we done in redirect? I'm not sure what we've done in redirect. Okay, but I would point out, I don't know if Reddington's going to do it when he recrosses. If he recrosses, this doctor was talking about treating a couple hundred women patients over his span of his years for psychosis, but he only mentions 2 for postpartum psychosis. Isn't that what we're talking about here? We're talking about the specific issues of postpartum psychosis, its onset, what happens with regard to it, not just generic psychosis that could be endemic to both male and female people, men and women. We're talking about postpartum psychosis. Okay, I just like to point that out. I mean, I love I like learning, but I don't like. I don't know. Right now, I'm like fidgeting, probably like the jury. Let me show some of the things we have here. We have a duckling from Melissa Boyles. Thank you for that duckling. And we have a Lulubelle 10 Jewels. You're hiding. You're lurking and hiding. And then Kay Schmidt. Hi, Kay. Gifted 5 Justice Serve TV memberships. You already all have them, right? And so you have them, and they've been given out already. We have nothing to do with that. YouTube randomly does that. If you like them, please pay it forward in the future if you can. Let's see. At Brass-6073. Yeah, I saw that. I have no idea if he has resigned his position. It has nothing to do with anything at this point. We don't know first of all, we don't know if it's true, and we don't know the circumstances. That's talking about Dr. Abram Mack. But it'd be interesting if that's the case. And we'll see. Yeah, I did too. But let's wait. We'll get confirmation at some point. An Uncle Alert for 40 Jewels. I think that was talking about Kevin Reddington about the start, not Michael Bryant. But he's coming on too, I assume. Okay, here we go. I think was talking about scheduling. The judge was talking about scheduling because it's almost 1.
So,
go back.
Doctor, if you could continue your answer.
Just for a second, I just want to. So, members of the jury, we're going to go a little past the 1 o'clock, the usual time of the break here for certain scheduling reasons. Okay.
So if you could just summarize briefly what you said, that you thought that Dr. Tufts' approach was reasonable. If you could just summarize briefly why you thought her approach was reasonable.
According to the notes and also the emails, communications between Dr. Tufts and Ms. Clancy, I found Dr. Tufts to be very responsive to Ms. Clancy's symptoms and concerns in really trying to make adjustments according to how Ms. Clancy was doing.
Thank you. And you were asked by defense counsel about her visit to Women and Infants Hospital and about the defendant I believe what defense counsel asked you was that every time a doctor told the defendant to do something, she was on it immediately. Do you remember being asked that?
Yes.
And do you recall that in the women and infants records that they offered her 3 programs, an inpatient hospitalization, a partial hospitalization program, and an outpatient program, and the defendant said that she would talk to her provider for guidance about those programs?
Yes.
And do you recall reading in the notes and records of Dr. Tufts, nurse practitioner Gelada, that she never discussed those 3 programs with her doctor or her nurse practitioner, correct?
That's my recollection.
Now, in terms of the calls to Aspire, to the hotline for the suicide hotline, you were asked about where in the records you saw that. And I would just like to approach, also from Exhibit 222, the note from December 8th, 2022 of Letitia Dukes. And if you could just review this note here and then look up when you're finished.
Okay, I seem to think that Attorney Sprague, I'll call her that because I posted on Twitter that funny exchange where the attorney, Ms. Sprague, it says Attorney Sprague, and then Reddington ignores her. Then the judge says Attorney Sprague. He calls her Attorney Sprague. Then the witness calls her Miss Sprague. And he says Attorney Sprague, please.
That gave you the information about the defendant's call to the suicide hotline?
Yes.
And reading from this page from the exhibit, page 45, it states that patient contacted Aspire Crisis Support. She met with an Aspire clinician virtually and was told that she did not meet the criteria for inpatient treatment due to not having an SI plan. That's a suicidal ideation plan, correct?
Correct.
And then reading again, Aspire clinician recommended that the patient attend a day program. The clinician said he would be sending the patient resources. Clinician informed the patient that it would be beneficial to attend an IOP or a PHP to help the patient build coping skills and build community. What's an IOP and a PHP? Do you know?
PHP is partial hospitalization program, and IOP is, I believe, an inpatient program.
And so when the defendant called the suicide hotline, she told them she was having suicidal thoughts, correct?
Correct.
But she told them she did not have a plan, correct?
Correct.
And they didn't just hang up on her. They sent her resources and recommended a day program and a partial hospitalization program or an inpatient program, correct?
Correct.
Move to submit these 2 pages, 45 and 46, is the next exhibit. They're apart from exhibit 222.
All right, subject to the same objection, I'm going to, that may be admitted.
197. You were asked a lot of questions about hormone changes after pregnancy and if that can affect, and stopping breastfeeding, and if that could affect someone's mental health. Do you remember that?
Yes.
And you said something about the timing matters. Why does the timing matter?
Well, after lactation and a postpartum period, and it may be the decision for a woman to stop lactation can occur at various times, not just during a circumscribed 1-month period. But stopping lactation causes a decrease in prolactin levels and an increase in estrogen and progesterone. And it really depends on when someone decides to stop breastfeeding. Those significant hormonal changes that are tied to breastfeeding or lactation. And so that's why timing, and the time is important to see at what point did breastfeeding stop And at what point are we seeing symptoms?
And doctor, with the defendant, the breastfeeding stopped sometime in October, is that correct?
Yes,
And then looking ahead to January 24th, 2023, would you still be expecting to see hormonal problems from stopping breastfeeding in October in January, that many months later?
no,
Now, you were asked about the statements Patrick made regarding his interaction with the defendant when he found her outside in the snow. And is it correct that he told you he found her and said, "What did you do?" And she said, "I tried to kill myself."
yes,
And did he then say, "Where are the kids?" And she said, "They are in the basement."
yes.
Did he then tell you that he then called 911?
I don't recall exactly when he told me that he called 911. What I recall is his statement about what she said to him.
And that was her statements to him when he immediately found her on the ground?
Correct.
And you're aware that at some point he made a 911 call, correct?
Yes,
And during that 911 call that you listened to, you didn't hear the defendant saying any words at that point, correct?
I did not.
And as a physician, are you aware that someone who's been injured can deteriorate over time?
Yes, particularly after an overdose.
And can they be speaking in one moment and then unable to speak moments later?
Yes,
Now, you were also asked about the crushed up pills and whether there was any residue on the nightstand or anywhere in the house that the police saw, correct?
yes.
And there was no residue in the photos, correct?
Not that I saw.
But you don't know when she crushed up the pills, do you?
I don't.
If she had crushed them up earlier in the day, there wouldn't necessarily be residue, correct?
Correct.
If she had crushed them up days before and put the empty bottles in a drawer, there wouldn't necessarily be residue, correct?
It's sustained.
Yes.
There were many texts between the defendant and her mother in January, correct?
Yes,
And from January 7th until January 22nd, when Ms. Clancy's mother and father visited her at her home, the text messages clearly indicated that they were in two separate locations, correct?
yes,
And in those text messages, the defendant repeatedly told her mother that she was doing a little bit better, sleeping's a little bit better, correct?
yes,
You were asked about Dr. Resnick and how many articles and how many books he's written and how he's well known in this area, correct?
yes.
And are you familiar with Dr. Resnick's teachings about malingering and about psychosis?
Yes,
And is it fair to say that Dr. Resnick teaches others that one of the red flags to look for in malingering?
You can ask him what he's read, not tell him what she wants him to say.
No, hold on. Let me hear the question first.
Are you aware that one of the red flags that Dr. Resnick teaches to look for in malingering and faking hearing voices is that someone automatically obeys a command?
yes.
That's stricken at this time. Can I see counsel?
So here's what the judge is doing right now. How long is this going to go? How much more do you have on this? Because all you're doing is you're testifying on stuff that the jury's heard, or it's irrelevant, or you're putting the answer in your question, or going beyond whatever. So the judge is going to say, "Come on, finish it up," because we have Mr. Reddington, and the jury has to go to lunch and afterwards. So that's what's going on right now. I think even the judge has had enough at this point because he just said, "It's stricken. It's stricken." You saw Judge Sullivan is getting annoyed. All right. And I'm sure the jury, Michael Brown, will probably tell us they're twiddling their thumbs. They're going to need Hug the Pug Day with the pug in the courtroom. And I don't know. Quite frankly, I don't know what she's doing here. She's defending the case, the malpractice case. The judge is kind of over her right now, is over this, because we don't know what the powder is. I mean, I'll take my purse out right now. I carry these little toothpaste things, and it's all powder. Sometimes they kind of break open and they're all over the place. We don't know what the powder is. We have no idea what the powder is. She said she was drinking lemonade. Is it the powdered lemonade, that incredible powdered lemonade that she was mixing, or is it wine, like Patrick Clancy said? So again, he's saying that she's lying because Patrick, the husband, the patriarch, the man, is said one thing and she said another. She may not be lying. Also, if she was in psychosis, she may not remember. This is what we're talking about. Even his treatment about patients that are in psychosis, women in prison in psychosis, they're not in postpartum psychosis. He's had two patients 40 years ago dealing with postpartum psychosis. Okay, two patients 40 years ago. All right, so that to me is hoodwinking the jury. I hope Reddington comes back with two very quick questions, or maybe just that question. Those hundreds of patients you mentioned in psychosis, they were not in postpartum psychosis, sir, were they? End of, and then he'll say, "Oh, count the two were," and that's it. You made the point. The prosecution. Now again, but some people may like him. He's not an argumentative witness. I thought actually the funniest thing, and I put it right in our chat, was the whole thing with regard to Sprague, Miss Sprague, and all, and it ends with well, I can't get to it.
I think, as I said, was stricken. Okay.
Okay, the judge is
you, Your Honor.
reinforcing. The last answer was stricken. That means you did something
You were
bad,
asked
prosecutor.
about trying to do collateral interviews with the defendant's family, correct?
Yes.
And you had requested of our office to make arrangements to interview the defendant's parents and her sister, correct?
Yes.
Were you aware that an email was sent to, I'm sorry, were you aware that a phone message was left for Paula Musgrove asking if she and her husband would be willing to meet with you on June 11th, 2026, and that they did not return the call?
That's my understanding.
And are you aware that an email was sent to Allison Ozga, the defendant's sister, requesting that she meet with you, and her response to that email was, "I am awaiting a response from Kevin advising me on participating in Dr. Saftoff's assessment. I will respond once I speak to him." Were you aware of that?
That was my understanding.
And were you aware that she did not respond after that?
Correct.
I have nothing further. Thank you.
You weren't aware that Kevin was on a month-long federal trial during that period of time either, were you? That'd be me.
Is that a question?
Yeah.
Can you repeat it?
You could say, maybe get a little closer to the microphone. I had problems.
Aware, sir, that during the time that Ozga, her sister, said she's waiting to hear from Kevin, and I'm the Kevin, that I was on trial on a month-long federal case out of my office. You didn't know that, did you?
I did not know that.
Did you ever think to call me directly or at my secretary, my office manager, to ask about me reaching out to these people?
No.
That's all I have, Judge. Thank you.
Anything else?
No.
Oh,
right, thank you.
darn. He didn't ask
Thank
the
you.
question about the psychosis, which I would have asked. But he's reading the jury. He knows the jury's tired. He's looking at the jury, but he wants to end with something with regard to that. Okay.
Attorney Sprague?
Of course.
All right.
Commonwealth
Members
Press.
of the jury, the Commonwealth has now rested their rebuttal case, so you have the evidence. All right, and so at this point, what I'm going to do is excuse you till tomorrow morning. All right, and tomorrow morning, you should be ready. We're going to have closing arguments and the legal instructions in the morning, and then the jury will begin deliberating. All right, so that's tomorrow. So I would suggest go home, rest up, and be ready for tomorrow. And so now you've heard all the evidence. For the first time I can say that you've heard all the evidence, but you haven't heard the arguments from the attorneys. You haven't even heard, like I said before, the law that you're to apply. So you still have to keep an open mind. All right. So those instructions that I gave you for the last 4 or 5 weeks, they're doubled down today. All right. Don't read anything. Don't talk about this. Don't watch anything. Don't discuss this with anyone. And keep an open mind. All right. Come this far with that open mind. Bring it with you tomorrow. All right. And so get a good night's sleep. I look forward to seeing you tomorrow, and we will get as soon as we can. Sometimes there's a little delay when we get to this next section, so we'll try and get you out here as soon as we can tomorrow morning. But if there's a little bit of a delay, as you probably already know, it's probably on me, right? But we'll try and get you out here as soon as we can, get you right back into this. So again, thank you so much for all your work, all your commitment, all your dedication, and I look forward to seeing you tomorrow. Okay.
Court, all rise, please. Jury, no first case one check.
Jurors have exited the floor of this closed session.
All right. What I thought we'd do is maybe I'll hear from the defendant in regards to any motions at this point. Then we take a break, probably till about 2:30. Come back to the charge conference. Before you leave, I have that draft so you could impose on your lunch hour. You could be looking at my instructions. With that, Mr. Reddington.
Yes, Your Honor. I know it's not crafted by learned hand, but nevertheless, I did file a motion for required finding that I have to renew. So I'm renewing it and waive argument.
Okay.
We'd object to the motion.
All right. The motion at this point is denied. All right. And so we will be in recess till 2:30. And if counsel can just wait, and I'll get those copies. I should have brought them out with me. They're in my lobby. And then we'll be in recess. All right. All right. Thank you, everyone.
Court, all rise.
Okay, I'm going to put myself on a full screen. I don't think we're going to see anything else right now. The jury has left the screen. I'm going to actually take it off take the feed for the moment off the screen because we're going to keep it there because they are coming back at 2:30. All right. So I expect Michael Bryant to come out to tell me whether or not the jury was doing like I'm doing, and that redirect. Oh, I'm so tired. I don't think I can take it anymore. But what I wanted to say is, for a point of just having some fun for the moment, was that whole, shall we say, and I see I misspelled it on Twitter, just so you know. I'm going to fix it right now. It was the whole Lindsay Clancy discussion about names. And names are usually an interesting thing with me because everyone gets my name completely wrong. So, but it was when the witness Sadoff said, I contacted the district attorney and then Kevin Reddington says, which one of these two? And he's always pointing to these two. He wants to give them their due. All right. Kevin Reddington, and then Sadoff says, Miss Sprague. And Kevin Reddington, okay, you spoke to Jen Sprague, and what did you say to her? And then Jen Sprague says, Attorney Sprague. And then Kevin Reddington says, what's that? And then Jen Sprague says, Attorney Sprague. And then Kevin Reddington says, you spoke to Jen Sprague, because he's not going to be interrupted and objected to by her. And then Sprague says, objection. And the judge then gets to intervene because it's an objection and says, Attorney Sprague. And then the witness says, I spoke to Miss Sprague, and Kevin Reddington comes back and says, Attorney Sprague, please. You know, I thought that was the funniest thing. It also goes to show how Kevin Reddington is very fast on his feet. Is extremely fast on his feet, right? I mean, to think about it. Attorney Sprague, please. Like, you know, that's, of course, what you were talking about. With that, by the way, let me thank you for the 5 jewels for a treat. Thank you very much. That's really great. And we have reached out, by the way, to this professor. By the way, she's at Mount Sinai, and she does women's psychiatric health. I mean, this is the type of witness the Commonwealth needed. All right. Not I'm sorry. And I know the men have been great here. Michael Bryant's been great. And Dr. Gregoire is male, who's great. And Dr. Peter Dean was great. And the experts for Lindsay Clancy were great. But if I were the Commonwealth, okay, I would want to get the best, and I'm sorry here, and I would talk to my jury consultant about it, female experts that do this type of work, because it's very possible you could have an all-female juror. We have 12 women on the jury and 6 men, and we don't know who the alternates are going to be yet. We will know today. We're going to know at the end of the day, because they're going to go through the jury charges at 2:30. Well, actually, we're not going to know until tomorrow, because the judge let the jury go home. So he's going to bring them all back. That way they can't get infected, I guess, when they're picked as alternates. And one of the earliest things they'll do tomorrow is pick the alternates. That's a wheel you don't want to win. I mean, that's that's like the bingo you don't want to win when you've been sitting there for what will be almost 5 weeks. And then, of course, you had to come down and get you had to fill out your forms and send them back and all. And it could go into 5 weeks. I think we're into our 4th week right now, at the end of our 4th week. But anyhow, I just thought that was a funny thing, because not only it showed that that Kevin Reddington is just not listening to them, right? If they object and the judge says something, he'll listen, but he's not listening to them. And that's a message she's sending to them. Now, whether or not it offends the woman there or not, I don't know. He's the attorney in the courtroom, and he can read the room, I think. And then when the witness then says, Ms. Sprague, and Kevin Reddington says, Attorney Sprague, please. I just think it was a moment of quiet, or maybe it was loud laughter. I don't know. I wonder how the jury reacted to this drama. Okay. So I labeled today Hug the Pug Day, because as Michael Bryant points out, there is a dog, a pug Frenchie mix in the courtroom. It's Homer Achilles. It's a support animal, and is supporting the causes raised in the Lindsay Clancy trial. All right, so we'll see about that. I do want to let you know about 2 things, or one thing that happened and where did it go. All right, the formal mistrial denial has been entered by Judge Sullivan. Remember, on the other day with the mistrial, there was a denial of the mistrial. And the formal order is actually 2 pages long, and it has been well, if I have to remove it now, because I tried to enlarge it, but it has been denied. It says on the first motion for mistrial, there was an election made for a curative instruction, and the second motion, therefore, the judge wasn't going to grant the mistrial, and he's curing it by another curative instruction. So actually, the first time there wasn't even a motion made, so he said there's a curative instruction. So that's what we have going on here. So that's the last of what I see. I assume there'll be a formal motion entered by the judge denying the motion for directed verdict, which Kevin Reddington has made twice. He made it once after the prosecution's initial case. It really wasn't ripe then, because they do have the ability to rebut, and once after the rebuttal case, judges generally don't do that. They allow, even if they're going to grant it, they generally allow the case to go to the trial, and then they enter a verdict afterwards, reversing the jury, but they generally don't do that. Judge Sullivan has tried a case. He thinks he's tried a pretty clean case. We'll see if Lindsay Clancy gets convicted. So what I want to know from Michael Bryant is what is going on in that courtroom. Obviously, I can tell you this, as I put into the chat, since they're going to be doing jury charges afterwards, and I know when I'm trying a case, generally, if it's a long case, I'm doing the closing, I let somebody else sit in on the jury charges, and they can let me know what they are, and I'll modify from then, because we've already discussed what we want. Or if I'm sitting there and we already, have the jury charges and we know where we're going, it is, even for lawyers, it's the most important thing you could go to, because it's, it's what the jury is going to hear and how they can interpret the evidence. But you're so tired, and you're so, after the evidence has gone in, that it's like the last gasp of we're coming down the home stretch here. And if you think that you were stretching during the testimony of the redirect of Dr. Satoff, let me tell you, there's going to be a lot of any people in there maybe doing the same thing, including the attorneys. And I'll guarantee you, they've been going back and forth in these jury charges since last week when they first had them in court. You tend to go back and forth with the judge on email, and so what they're getting is the penultimate copy they're going to be getting after lunch is not something that generally the attorneys don't know is coming. The judge may say he'll make other changes, and then they'll come out with the final what they're going to agree to finally will be done right in open court, and the judge will then send them the final copy. It may be today or maybe even tomorrow morning before they actually close, but they have to. Yeah, they do. Massachusetts, you're right. Massachusetts is going to pick the alternates after the closing generally. So it's because they want everyone to listen, and it's like New Jersey, and they don't want anyone to be infected out there. I like the system much better than I like the California system where Michael Bryant's from, where when you pick your jury, you pick your regular jury, and then you pick the alternates. All right. And you get different amount of preemptory challenges for the alternates than you do from the regular jury. And so you have juror 1, alternate 1, 2, 3, 4, 5, 6, and they know they're alternates. If something happens, then alternate 1 moves in, then alternate 2. So alternate 6 is likely never going to get into the jury. And they're sitting there during the whole trial, wishing they could go home, or that there's a mass casualty or something that they get on the jury and get there. And I think it's better to have alternates and jurors together. Now, the difference is that if you have an alternate jury picked, you get a new set of challenges, and maybe less, but a new set of preemptory challenges, instead of having them all in the same set of preemptory challenges that you have when you first pick the jury. So let me see what you are all interested in. Let me scroll down and see what you're all interested in. How did you think Dr. Sadoff was? All right. I understand that he's probably terrific when it comes to what he does for the FBI. All right. And I understand that indeed Kevin Reddington had to take a different tack, and he did. Most of the cross-examination was more of a respectful cross-examination, but again, using his CV to either support Lindsay's case, and there was a lot of that based on that. There was a lot of it. And I also said, you never go after the expert basically on their ultimate opinion, because they're not going to change their ultimate opinion. Okay. They're just not. All right. They're not changing their ultimate opinion, but if you can get some nuggets from that alternate opinion to support your case, that's what you want from the prosecution expert, or have the jury not like them, or have the jury think they're irrelevant. Now, remember, Kevin Reddington wanted a Dahlberg hearing on his methodology of how he came to his conclusions, because I don't think he can have a methodology by using prison patients from the 1980s and 1990s and whatever he does now. The Bureau of Prisons, 2 or 3 patients, 2 or 3 to see whether or not they're dangerous, or Islamic terrorists. And I thought Reddington did a great job on that. He wasn't mocking him. He was saying, and you wrote this article on here, and you wrote this article here, and you wrote this article here, and you wrote this article here. And by spending an hour on all these issues that have nothing to do with postpartum psychosis, it showed that he's really not an expert in postpartum psychosis, right? I mean, he went through it. And then he got him to admit, first time he got him to admit that Dr. Resnick is the world-renowned expert that everyone looks to for filicide, that is by a parent killing a child. And then later in the cross, before it ends, because he couched his issue, he couched something by suggesting that Lindsay Clancy was malingering or making up her symptoms. And he got him to admit, well, that's what you were really saying, right? And he said, yes. He said, but Dr. Resnick, he's the world expert in this. Correct, he is. And he says this, and he says this, and he says this. And then he got back into this test that was administered by everybody, basically, that shows she does not malingering her symptoms. I don't know what symptoms you're malingering if you were going to all these people and taking all these drugs and not taking all these drugs and getting treatment and having a psychiatrist and having a nurse practitioner and having a psychologist and talking to your mother. Was she malingering when she told her mother that in that text? To me, that text is so important. Mom, something's not right. I don't have, it's not right. I didn't sleep all day. I'm worse. I'm worse. It's not right, Mom. And then the jury's heard that her mother came over and she asked her mother if she could sleep in the same bed with her. Who does that? Unless you want comfort and you're scared. Who does that? Okay. I don't see, and that text was read to this doctor, and he doesn't even have to ask if this is an opinion. All he had to ask is, did you know about this? So Kevin Reddington reads it again. And when we try cases, how we teach, you tell the jury what you're going to tell them, and then you tell them again what you told them. So he's told them again through that text over and over again that she was sick and she wasn't making up her symptoms, right? All right. And that and then he got him to admit this was brilliant. He didn't, you can't get one expert to comment on another expert's opinion directly. That you can't. But he just asked, would you agree with this statement? And he read a conclusion. Was it from Mack or Heilbrunn? I thought it was from Heilbrunn on the issue of she was selfish, that she wanted to kill herself, so she killed her kids first, and therefore she didn't have a psychotic break. She didn't have a psychotic episode. And he read this, and Dr. Sadoff was smart enough to know something was going on, but he couldn't agree with what was read to him, because what he just told the jury was completely opposite, right? That she did seek treatment, that she was having these symptoms. And he says, I think that statement, this is from Sadoff, minimizes what she was going through. I think that statement minimizes what she was going through. Boom. He just, through using the Commonwealth's third expert, totally destroyed the Commonwealth's second expert. Boom, boom, and more boom. So I thought that was absolutely brilliant. But you can't do that as a trial attorney till you know you've gotten the witness malleable enough. But when he got sat off to basically comment without saying it and destroying the opinion of Dr. Heilbrunn, it minimizes what she was going through. Boom, that was it, in my opinion. I mean, there was a lot that he was able to get from this, and I've talked to you about the sleep deprivations used as torture, and that she was going through it, and she's not looking to score drug prescriptions, and that she has homicidal ideation, and then when he said just voices, he rammed him into that, and that she had a suicidal ideation. And all of the admissions he got. And he did that when he had a different type of Kevin Reddington cross than when he got to the Kevin Reddington we know. But he knew that he had that witness malleable enough, and knew the witness, he must have thought the witness had enough sense and enough credentialing and enough savvy to understand that he couldn't disagree with what Reddington was saying without making himself look foolish. Michael Bryant. I can't wait.
Hey, didn't you notice me?
Well, you were still,
yeah,
you were still
it's,
futzing around. You were still futzing
well,
around
just
with your
killing time.
microphones. So,
Just
so,
killing time.
hi.
Yeah,
How's
so it
the
is.
plug?
Hey, it is a tricky thing to both discredit an expert and then flip that expert to be your own expert. That is,
very
a very tricky thing to do. And so of course,
that takes somebody who really has experience, in my opinion.
Yeah, it doesn't happen by accident. And there were things that some of Reddington's experts did not touch on that he used this guy for. So, interesting. So, who wants the real important breaking news first about the dog?
Yeah, we want to know
or
how many
about the
jurors
plan
hug
for
we want to
tomorrow?
know how many jurors hug the pug. That's the most important breaking news.
Yeah. I was the only one that interviewed the pug. But very interesting. I posted the name is Homer Achilles. It is a service dog, and the woman, very interesting woman. She's an artist. Very kind of in touch with this case. She actually had a person with her who was just carrying a massive bouquet of flowers, just tons of flowers. She was motivated to do that after seeing Sue Clancy testify and the whole mortal sin moment. She just looked at her from a TV viewer. On the television, and said, this woman she's just so miserable, and she just felt so for her that she wanted to bring, if not her flowers, anybody that happened to be here and happened to be kind of sharing in the trauma this case has either caused or reminded people of. So interesting. And they gave her. I said, so did they give you a hard time about the dog? Because she was in the little ante room there for a while. And ADA rules, you can only ask 2 questions. I think you can ask what your need is, what your condition is that needs the support animal for, and then I think the other one has to do with the animal itself, if it's trained or registered or something. That's all. You can't ask any other questions. She had shown up about a week ago without the dog, and they remembered her. And so this time when she shows up with the dog, it was like, oh, didn't have the dog last time. How come you didn't have the dog last time? Do you really need the dog? Because here's the dog, and now you want again. No, and she basically told them that, and ultimately she got in there, and the dog was, other than rooting around on the courtroom carpet floor for a little bit, very well trained, very well mannered. I mean, it was odd that she was sitting in the middle of the very last row, and there were seats that were sprinkled about near her, and when they were letting one member from the public here and they're in, they'd turn the corner and have to and like step over the dog, to get down the row.
Well, let me just tell you, these are the 2 questions you can ask. Okay, is this dog a service animal required because of disability?
Okay,
that's number 1, and number 2, what work or task has the dog been trained to perform? That's the second.
There you go.
That's the one.
There you go.
You can't ask her anymore. You can't
ask
say
what
why
the actual condition is.
Why did you bring that, or what the actual condition is? You don't have to do that.
I wonder, and I did not get the answer to tell you a lot about what the condition is, I suppose, but what would it be? I can lead you out of a room because your sight is bad. I don't. What's the dog do?
The dog's been trained. Yeah, the dog's been trained to help me in walking. That's all. You don't have to say specifically.
Okay.
The dog's been trained to help my balance. The dog's been trained to help me pick up stuff. The dog's been trained to, whatever it is.
Okay.
Tubi's trained to help my balance because of my hip replacements. Tubi's
really?
trained. Yeah.
Interesting. Okay. So I've noticed I had to use, I'm on the orange disc today.
What does that mean?
That's this thing. That's our mobile hotspot. I've been here right outside the courthouse, and it's been perfect every time. Seemed a little shaky today. I couldn't quite get in and on. So I'm now on this other for better or worse. So we'll see how it goes. Okay. So now here's the important stuff I wanted to get into, and it's not about the witnesses and all their testimony. You saw that. I'm sure you
keep freezing.
Okay. Let me do this. Let me try going back to the other one. Can you hear me now? Can you hear me?
Yeah,
Let me try.
Yes, we can hear you.
Let me see if I can go back, and I'll pop right back on. One more.
Okay, so he pops right back on. Let's continue where we left off. Vita Mama 22 hip replacements changed my life. I had them both done at the same time. I didn't want to spend any downtime. Just like get in there, get them out. And mine were actually calls I needed it because of horseback riding when I was young. I had actually hip replacements done because the hips bones were hitting on the other way that most people have from being runners and all. But you also know that service dogs are they're fabulous. They're fabulous service dogs. I mean, just fabulous.
It is getting a little odd, the service animals that you'll start to see out there. Dogs pretty common, obviously. But there are people. I got my service llama. Okay, whatever works for you. So let me think. I'll look at my notes again before we wrap it up for the day. But I was trying to
we're not going to show the charge.
Oh, we're going to show and I don't think it's going to be very long. And it's going to hinge primarily on this involuntary intoxication instruction and whether or not that leads to an involuntary manslaughter additional charge. My gut tells me it's not going to happen, but it'll have to come to fruition in that order. They'll address the instruction first, and if that's a loser, then I don't think you even have a chance to ask for the charge itself as involuntary manslaughter. But if they agree to the instruction, then I think the door is open. So here are the other things we've been hearing. Rumors about stuff. I said, these rumors are ridiculous. So I just went to the DA and I said, look, what's the deal on closings? And as we had surmised, and as you have experienced, it's an hour each side, give or take. Give or take. It's not hard and fast rule. If you slop over by 5-10 minutes, nobody's going to jump you. Nobody's going to grab the hook and pull you out of the well of the court. So we knew it was bullshit. This 30 minutes per side, we knew that was ridiculous.
Right.
I mean, that doesn't mean that somebody like Reddington who believes he can be zippy doesn't mean he has to spend an hour. No. But the issue, and the scuttlebutt, which we knew was just wrong, was that was the max 30 minutes. No,
Yeah.
come on. And it will be as we've reported. The defense will go first. Commonwealth will go second. There is no rebuttal. Commonwealth has the burden of proof, and they will instruct after the arguments, which I don't
Jersey.
like.
Well,
I
that's
don't
like
like-
Jersey.
yeah.
That's like New
Yeah, I don't-
Jersey does it, right?
Yeah, I don't like that because I think once they've heard the arguments, I think they're champing at the bit, and I think instructions are generally boring. Sorry, important, but boring. I think it's better. It's like the warm up act. You know, you go to see the big show. You don't see the headliner first. No, you see the headliner afterwards. So,
Well,
anyway.
let me tell you, it's very interesting because having experienced this in Massachusetts, if you go to close and you start saying, when the judge is going to instruct you, and let's talk about the jury charges, you will get an immediate objection from the judge. That's my purview to discuss the jury charges. They don't let you, they let you talk in general, but you can't, you don't put up those things like, you know,
the big chalks.
you know how, you know, the big chalks like you have in California, because you have that great jury charge that you could think that somebody did it, but just thinking that they did it is not burden of proof enough. And you have the mountain charge. You can't use those. There'll be an objection now out the kazoo, and the judge will say, you know, go outside with the service talk.
Yeah, and that's another reason I don't like it, because it's nice if they've already got that base of information, you can reinforce it, the stuff that works for you. So that's not what's happening. Let me see what other little tidbits did I get from the DA about the process. Oh, I asked about the alternates.
Wait a second. Wait. I'm sorry. Attorney Sprague.
Oh my
Is that
gosh,
it?
Jan, it's
Is it
Jan. I didn't.
Jen.
No, not the underlings. I'm talking to the boss.
Oh, you went to Tim Cruz.
Yeah, I'm not talking to the underlings.
Okay.
They wouldn't give me the time of day anyhow. I mean, they are just some miserable looking folks. And I'm not going up and saying, "Hey, Jen, how's it going?" I mean,
wait. Don't we have that?
We may have to get a different one. We may have to get a new one. But we only have this one for now. We only have this one right here.
Wait. Jen!
So maybe it's the name. Maybe that just makes people annoyed. So you saw, Kevin Reddington basically was quizzing the witness about his contact with the DA's office. You reach out to Jen Sprague, Attorney Sprague, and then so he says it again, of course. Well, Jen Sprague. I mean, how every time you think somebody could maybe get a clue about how inhuman and unlikable they are, they do something that makes it even worse. Does she not understand that just ignoring that would have been the way to go?
Yeah, because lawyers talk about that. I've had people, because people don't understand. You're talking to them all the time, and sometimes you do put their first names in.
Of course, if you're a normal person.
Lawyers said, "And did you talk to Linda on the other side?" And I'm just sitting there. You don't say, "Okay, you did the but the best part was at the end when the witness said, "Ms. Sprague," and Kevin Reddington says, "Attorney Sprague, please, please."
Yeah, and so that's something you might, the judge might bring up at a sidebar and say, look, let's be professional here. But you don't billboard it for the jury. Basically, why don't you just scream out, "I'm an asshole"? I mean, God. Anyway, so that happened, and we have some more folks have flown into the chicken coop today. I'm trying to think who I've seen that hasn't been there before. Oh, Court TV. Not a reporter. I think it's Ted. What's Ted's last name? I forget.
Ted Daniels? No,
that's wrong. No, he was 25.
Yeah, he's 25.
Yeah, Ted. Ted.
Yeah, the other guy. Yeah,
that guy.
How
anyway,
soon we forget?
Who Grace and I used to work with back in the day. Actually, he was at CNN before. He was at CNN before the new Court TV launched, and then they brought him in. He was a producer with CNN in Chicago. Anyway, so if you haven't seen it yet, I carved out the Grace Wong reunion we had last night, and I carved out the Dr. Allen.
Oh, great. Okay.
Well. I put them on to post. Actually, I put them on to post at about like 2 or 3 because I knew there'd be this gap of some sort, but they'll be out there if you missed last night.
I put the doctor starts about 16 minutes into it, and I put it up there on X so that people could listen to it, because I said everything that the prosecution led us to believe that wasn't possible is absolutely indicative or suggestive of postpartum psychosis. Everything that they said supported the finding that she knew what she was doing.
we didn't want him to have to deal with the evidence per se, but the concepts, like
Right.
this whole 18-minute thing, which still hasn't been addressed, better be in closing. I just think it's a big miss if you don't. But just to ask him, well, is there a time limit? Like, psychotic episode starts now. Click, you click the stopwatch, and then at 4 to 5 minutes you're done. No, he said it could go on not just for hours, it could go on for days.
Days. It can go on for days.
So anyway, it's an
And
amazing
he also said that the psychosis can come on just like that. And I thought it was interesting that Sadoff in cross-examination admitted that the psychosis incident can come on. He says just like that. He mimicked what Dr. Gregoire said, just like that.
Yeah, I've called it the light switch, but snap of a finger, even how you consider premeditation, right? Premeditation can happen just like that, and it's the same kind of concept. So, I'll tell you what, the 2 times that I saw, and I posted about this, the jury act in unison, and it was amazing. I had to kind of scooch around a little bit, scooch around to see, am I missing somebody? Everybody hands pens to pad at the exact same time, twice. And it was during the testimony when Ms. Sprague, when Jen was asking about the very specific language that we're going to see in these jury instructions. One being, was there a mental disease or defect, which even their experts have all said yes, but that's not the big points. The points after that are have the capacity to understand right and wrong, right? They're all writing that down. And did she have the ability to conform her conduct to the law? Everybody writing those things down. Now, does that mean they're sold? No, it just means that they know how important that is. And I think that's a good sign that they're taking it that seriously, and they're continuing at this point,
Right.
day 21, continuing to do their job. And I think that's encouraging. So now let's talk about the 6 who are going to be disappointed.
Mm-hmm.
So I was asking, I asked, say, Tim, are they using the drum? Are they, he said something about, he said, well, on Karen Reed, they had kind of a misfire on that. So, oh, really? He wasn't sure if they were using a drum here. I said, dude, you're the DA. He holds the door open for everybody coming and going. He doesn't come into the courtroom, but he holds the door open for everybody. I said, you're very useful. So we'll find out how they do it, but it should be done basically first thing.
Mm-hmm. Oh, so they are going to do it first. I thought it was first thing, and somebody corrected me, and I remember in Hernandez that was the issue too, that
Well,
it was done first thing as opposed to after the closing.
Yeah, that's what I'm hearing. I'm thinking it through, and I'm thinking, well, they should hear the closings, because if they have to come back in and deliberate, right? They should hear those.
They need to hear the closings. Right.
So I'm, even though my source is pretty good, my logic is telling me that maybe there's another way. Maybe it happens after the closings, but I'm gonna work on that. That's the one I wasn't too sure of, and I asked him, and he seemed sure, but doesn't make a lot of sense. Remember, it's not this way in Massachusetts. It is in some states. If you lose an original juror and an alt comes in, you have to start. I mean, everything starts over.
It's every state.
It is in Massachusetts that way. I know some states that it is not, which is that kind of subjects the alternate to being bullied.
Right.
Because if there are 11 remaining jurors and they're all in lockstep, they're just going to gather around and pummel the new person into submission. There are states that do that. I couldn't remember Massachusetts, but you're right. Yeah, they definitely do not do that. So it's back to square one. So so we've been just kind of talking about length of deliberations, thoughts about that.
Well, let me ask you one other thing before you get to that.
Mhm.
Their overall view, because on redirect here, I've been squirming ever since the redirect. Like, oh, this is so boring. Oh, this is so boring. What is the jury doing with Dr. Sadoff this morning, both doing cross-examination and direct examination and redirect and recross?
They always start off strong. I'm always impressed by how ready to go they are. A handsome woman in a lovely one piece, perhaps an A-line dress in pink. Lovely. A little more dressy. She's tends to be a little more kind of casual chic. But everybody's ready to go. And like I said, in those 2 moments, and this was again during the finish of the direct, which was the first thing in the morning. So that's always when they're going to get the most attention from any jury. And then they start to kind of, even during the cross, which is much more entertaining, you're still hitting on themes for the most part that this jury's heard before. They've heard with many of the witnesses. And I just get my read on the room is that they're ready to go, that there's not much more they can learn. There were, I mean, not that they're upset in any way. It's just like,
But they've had it.
We get it.
Yeah, we get it.
And
Right.
there were a couple of nuggets I'm sure you talked about that came in
Oh,
through
yeah.
the
Yeah, there were some great
cross-examination
nuggets. Right. Great
that were
nuggets. About 7 or 8.
new information.
Mhm.
And there were the points at which they wrote down the Commonwealth's very important notes about culpability, because they know that's where the fight's going to be in the deliberation, in the closing arguments. That's the battle. Everybody is on the same page that she had a mental disease or defect. Okay.
Well,
And then-
they weren't on the same page initially. The
Well, they
prosecution.
also thought the suicide was fake initially. So,
right. And there was a bunch of that. And suicide was fake, and then she was drug shopping too. That's been undone. That's been totally undone.
yes. And reiterated a few times that it was the opposite, really. Just trying to get off of them, or at least get something that worked. So,
Right.
anyway, I think a lot of folks believe that they're going to get the case by midday tomorrow, right?
Mhm.
If they start anywhere near 9 o'clock, and that's always an if. You got 2 hours of closing arguments, probably maybe a little water break in between, or maybe a break between that and the instructions, and you should be by noon. You should be out the door.
Right.
And whether they give them lunch and they start after that, who knows? By 1-ish, that means they got. And I will ask the court about this, what the extensions of the day might look like. It's pretty 4:30 is when the building closes.
Okay.
4 o'clock is when he ends for the day and has done so, if not a little before. So there's always that money issue. Like, will they pay for staff to stay longer, or is it going to be, hey, wrap it at 4:30? And unless you tell me that you've got a decision that's imminent. I don't think it's going to happen by the end of day tomorrow, unless no, I just don't. I don't know what the makeup's going to be of the 12 of the 18 that remain. I just can't see it happening in that short period of time, because I don't think there will be agreement. And I think hung jury is as likely with this case as any I've seen. And that would mean they're going to go on into Friday. And, depending on where the hung is it 11-1 for one particular outcome, or is it 6-6? 6-6 is tough to, pummel people into moving their position.
Yeah. And then
10-2, 11-1, it could happen. And then we'll see how quickly the court gives a dynamite charge. He doesn't seem to be in a big hurry for anything. So I could see at the end, let's assume it goes to the end of Friday. I could see him saying, you guys, you take the weekend, relax, don't talk about the case. And then when you come back on Monday, you have fresh eyes. You go back in there. I could see that.
Okay. So anyhow, let's answer this question. This is for me, but I think you're better off answering. Can you explain how including a lesser included offensive manslaughter isn't a huge risk to Lindsay? And I think that's if he's trying to get the involuntary manslaughter, not a manslaughter. Right?
Yes, we're talking involuntary. All these decisions have some risk to them. There's no doubt about it. But remember that second degree murder is already in there. And I think if I'm in Kevin Reddington's shoes, I'm thinking if there's going to be a compromise of some sort, I want a better compromise than that. And there's already one in there, second degree, and it's not great.
That's
It's
not
not great.
Right.
So I want one. If we're going to have one, let's get one that is a little more favorable. And again, that's a up to 20 years, but it's total discretion of the court. All the kind of mitigating factors like, her health, no priors. She could get 2-3 years on involuntary manslaughter.
Yeah. Interesting.
So
So this is Ruby, $35.95. It was Commonwealth opening statement. He got him to discount. Okay, that's a comment. Thank you, Ruby, for that comment. Let me just give you a couple of these, Michael. 10 jewels, East Coast Karen, gold coin. Thank you very much for that. And we have a silver star from Mima Geo 1978, and we have a Sunday. Ooh, undercover angel 11.
not
Ooh,
like a
that sounds-
Sunday.
Yeah, I know. We all at that point. And then from Linda 1974, 2 jewels, a silver star. Our viewers have been again very generous all morning today while you were in court, hugging the pug. Hugging the pug. That's what I put. Hug the
hug the pug.
pug.
And
Hug the pug.
it is a pug Frenchie mix.
Mix,
So,
okay.
but looking at it, it looks 80% pug to me.
Yeah. Yeah. So
And I know there's going to be pictures of it because Greg, who's the shooter, he's a guy with he does work for the Globe and for the local paper, but he's been the guy every day. And so he was taking a picture from floor level. You know, he put his camera down on the floor, shooting back toward the dog sitting on the floor as well. So I guarantee you, look in that'll be out there. People are
inside the
gonna put that
courtroom,
up.
did he inside the
Mhm.
courthouse? Did he get?
Well, he's the
permission?
guy. He's the pool
Okay.
king.
Oh, he's a pool
So he
camera.
can
So
do
he
that.
can
He's
do
the
it. He
pool-
can do
pool
that.
guy.
Right. He's the pool camera. He
Yeah.
can do that. Yeah.
Yeah.
All right. So
So
I
look
actually
for that.
thought
That's gonna be
thought
out
there
there.
was a lot of on Cross, a lot of things that Reddington got. You know, and I thought the whole idea that she said she didn't want her husband gone too long was actually good for her because it shows maybe she was having ideations and she wanted him come back. You
Yeah.
know, I thought that was a really good nugget for her.
I think that phone call and the timing is a very interesting little piece of information here, you know, because nobody knows for sure in the process of taking these children's lives where that call came. I think
Right.
everybody is assuming it was just before she started, but who knows?
Who
We
knows?
don't
It
know.
could not, may not be, and that may not have been right, and that's the problem.
I mean, if you believe it was right in the middle, I think the fact she was able to be calm and cool and collected helps the psychotic break.
Mhm.
Because I think if you're doing it intentionally, you're just going to be manic in a different way, not in a psychotic way. You're going to be hard to control emotions and breathing and speech. But if you're, you know, you're not in touch with reality. Oh, here, I got a phone call. Yeah, you know, I'm right in the middle of ending my child's lives. Yeah, hi. Yeah, okay. I can see that makes you look detached from
And
reality.
if it happened right after, it could be that's when the voice said, "Do it now, do it now, do it now."
Yeah, so
You know,
hangs up the phone and then bing.
Yeah, bing.
Yeah.
And I thought the fact that this doctor agreed that the PPP could happen, as I said, we said like that, and his dealing with women were just psychotic. They had nothing to do with postpartum depression or postpartum psychosis,
Oh,
unless there
no.
was 2 of them 40 and 50 years ago. They were in the sleep
Yeah.
deprivation used as torture. I thought was great.
That was good. I thought that was good. Yeah,
Right.
and you know his experiences basically with prisoners,
Right.
uh,
Except
which
for
is
the one
fine.
woman. One of the
Yeah,
two women postpartum was actually in a mental institution. And I thought, well, that's a little nugget that maybe the jury picked up on. You know, exactly in a mental, not a prison. Homicide ideation with the voices. He said just voices. And Reddington said, "What do you mean just voices? She's homicide ideation. She told her mom and her husband." And he was like, you know, it was like,
and again, this was an attempt to fix things by the Commonwealth when they talked about when they got into the 911 call. Excuse me,
wow.
having heard it, I wasn't sure this witness had heard it. He said he did. That's what he said. But he didn't. But he was truthful in saying he didn't hear the words that had been attributed
Right.
to
He
her.
was truthful on that. Right.
And that was my take as well. I couldn't tell you what
Right.
was being attempted. It was just, you know, garbled sounds
Right.
in response to very clear questions. The questions super clear. So that means he took that information from somebody, and it contradicts what the tape tells him.
Right.
The Commonwealth did a pretty good job of fixing that up by saying, didn't Patrick Clancy ask her those questions before he called 911?
Except there's no, that's his word.
That's
So again,
all it is.
that's
all
all. That's
it
what
is.
that's what he did the whole time. He said, well, all the witnesses, well, she said this, but he said this. So we take his word as opposed to what she believes happened, even if she may have been in psychosis and didn't know what happened. And all. So I mean, I thought that, and in fact, she wasn't looking to score drugs. The suicide that she had, you know, suicide ideation. I guess he admitted that you have to deal with it. That's a serious thing, and that he did say. I thought the brilliant thing was the end that you heard me talking about when he takes Heilbronn's basically opinion, but because you can't have an expert talk about another expert, but he just takes it. Tell me whether you agree or disagree with this statement. He takes part of Heilbronn's and says, I think that minimizes what she was going through. And I thought, boom, wow, I haven't seen that done before like that.
Yeah. Yep. And certainly for the Commonwealth, it ended with a thud rather than anything else. And then they did rest because once you have a rebuttal case, you're essentially resting a second time. And so Reddington brought his motion for a second time. Everybody knew it was just short shrift and get it on the record. Let's move along. There wasn't going to be any sort of, surprise. Oh, by the way, we're granting your motion. That wasn't going to happen. Hey, before I forget, thanks to, where did I put the name here? Doggone it. Well, yeah. Now I know I've even seen comments saying, "Let's."
I'm sorry. I'm sorry. That was, I just wanted to show you, and I was trying to get it ready to show you, but it's my fingernails got in the way.
No,
All right, that's the formal written denial of the mistrial motions.
Oh, okay.
Okay.
Which they're gonna make a copy of, and they'll have two of them. The viewer Zeta, Zaida, right? And I think it's Zeta's eye.
Zeta's eye.
I've been accused of mispronouncing it various ways. So, but thank you for the donation. It says for the biggest cup of coffee you can find. Yeah, it's probably going to find that's a big gulp. And also to Angela, thank you so much for that. She says, because I adore you too. Oh
wow.
Oh
Wow.
It's nice.
Wow.
And yet another repeat offender, Kathleen. As always, thank you for your commentary. So, okay, I didn't forget those. When I've been doing this thing on lunch days when you've been busy, I'll blow through our official starred questions,
right,
and then I just start surfing through the comments. I just start surfing through there because there are some amazing comments that really kind of spur discussion.
Right, I agree. But we want to get our members in there who are members. They have and our super chats who really have priority. But our members have first priority, and then the super chats.
Okay, hold on. I'm getting feedback. Hold on, I'm getting some feedback here. I was close. Nailed the first name today. What did I say though? Now I can't remember what I said. Zeta? Did I say Zeta? Okay. That's what I'm going with until somebody tells me otherwise. Okay, so Pat said he called 911 from outside with Lindsay. Then he carried the phone. Yeah, well, we know that. And having heard the call, I guarantee you that's how it plays out. What they were suggesting was that in whatever time there was from his arrival at home to his discovery of her and then calling 911, he asked those two questions. What have you done? I tried to kill myself, which is not audible on the 911 tape. And where are the kids? In the basement, not audible on the 911. What they're suggesting is he asked those two questions, then called 911, and apparently asked the questions again. That makes no sense.
Makes no sense. And all of a sudden, she went from being totally coherent and speaking after breaking her neck to being incoherent.
And that's why the Commonwealth also said, so isn't it true under those conditions with these kinds of injuries? And they're asking that of the psychiatrist who, yes,
but the psychiatrist said it's very true with drug overdoses. What did he say? His answer had to do with drug. What are we talking about?
He was talking about the Commonwealth was getting him to acknowledge that you could have these injuries that she's ultimately suffered. Now he's talking as a medical doctor, which of course psychiatrists are, but it's not like they're disciplined. So he's going back to med school thinking about it. That she could be in and out with her ability to verbalize. So that's how they were trying to explain
with drug overdoses. He said that could happen very quickly with drug overdoses, that you lose that consciousness.
Oh, that you have it, then you lose it.
Yeah. He said, he specifically said drug overdoses. That's what he said. He didn't address the issue of the broken, the C1 and the 82
crush.
degrees, and she's in 82.1 degrees or whatever she is.
Yeah, I know the net, the internet sleuths have gone crazy about that number.
Yeah.
How comparing it to John O'Keefe's body, how long out in the snow? If she had only been there a short time, how can it?
Well, I phoned.
It's a massive drop. I'll tell you that.
I phoned a friend about that. Okay, and when you get to like that number, like you get to 80 degrees, you could just go into cardiac arrest. I mean, you could
you're clinging.
That's a real low number.
Yeah, so the question was, well, how does she lose? How does she lose 16 degrees over what was apparently half an hour of time? That I think that's what everybody's focusing on. So the answer is hard ground, wet ground, snowy ground, wet clothes, thin clothes, lightweight, all of those things. And paralysis, which immediately shut off blood flow, normal blood flow.
Right.
Thanks, Lulu Bell. 5 Justice Serve TV memberships. I was refreshing my recollection
Thank
on how to
you.
give them away. Should I try and do that?
Yeah, let's try to do that right now because everyone's been with us. I mean, let's do that now. People have been with us, and I want to let you know that we're up to 39,282 subs. We
Yeah.
need to get to 40,000, but we're almost at least 32.3. So, could you all, if you're watching, because a lot of you are watching who are not subs, because we can see that, hit that subscribe. If you all who are watching, hit that subscribe button right now. It doesn't cost you anything. Guess what? You get us to 40,000. And
Then what happens?
and then what happens? We get a lot more credibility with YouTube in terms of the algorithm. So we need you to get us to 40,000 so we could get that credibility with YouTube. We really care about only having credibility with you, but the problem is YouTube wants us to have credibility with you by showing that we have 40,000 subs.
Will we still be the best kept secret in true crime?
Yes, we're going to be the best kept
We still
secret
will
as
be?
true
Okay.
crime.
All right then.
still.
Okay then. All right then. Doggone it. I was looking at this last night, fiddling about, and you can't do it except when you're actually live. So I couldn't practice.
Yeah, yeah.
So I'm going to work on it. I promise. I will. Tonight we're going to definitely do it. I don't feel comfortable enough right
Yeah.
now to think I can do it. I don't want to botch the system here, but I am going to figure it out. I am. I was just looking at. I hadn't seen this in a while. Our Justice Serve TV polls. If you guys haven't looked at the polls,
we haven't put one up in a while. Did you have?
no, I'm
one
just
up?
cycling back to the original. Remember the one I did about what should the outcome
I think I did
be?
one. I think I did one after you.
Yeah,
on
I saw
that.
you did a couple of them. You
Yeah,
did one
a couple of
about
them, yeah,
Ian
yeah.
Whiffen, and you did one about prosecutor's attitude, and you did one about Paul Zeisel, and there's also the one I did way
Thanks.
back before we started, just like the first week of trial, was what do you think the outcome should be?
Mhm.
Now it's assuming fewer charges, doesn't have the second degree on here, but it
Right.
has guilty 12%, not guilty by reason of lack of criminal responsibility 85%,
Wow. Okay.
and then a straight not guilty 3%. So anyway, that was we could put up a fresh one.
Yeah, I think
while the
I
jury's
think we need it.
deliberating.
We need a fresh one. We need.
Besides, we'll need it to
Well, I
reflect
think maybe
second
we should
degree
have
for
a.
sure.
We should have, once we know what the charges are, we should put up a fresh one tonight
Yeah,
as to what
yeah.
would you vote, and then what do you think the jury's going to vote? There's two separate issues. What would you vote, and what do
Definitely.
you think the jury's going to vote?
Yeah, and anybody who thinks they know what the jury's going to vote, good luck.
And we also, Michael, I reminded everybody that we have 18 jurors, but 12 are women and 6 are men. We could end up with an
Mhm.
all-female jury here.
Sure
Does that
could.
make a difference? Is there
Sure
a jury
could.
consultant? Does Reddington
There
have
would
a
be.
jury consultant?
I don't. Well, if he does, they've not been in the courtroom unless it's a family member. So I mentioned I met his daughter. I met Dr. Z's daughter. Dr.
Mhm.
Z has been there every day. The daughter was
Yeah,
there yesterday.
that's still-
Lovely family. And didn't surprise me. So I think Dr. Z's been as close to a consult as any, and
Yeah.
not a bad person to be a jury consultant. Somebody who's a psychologist.
How about Lindsay
Anyway,
Clancy? What's her reaction today? You were in the court
today,
watching.
today,
reaction?
more studious. I thought, yesterday some of the testimony got into some of the more graphic stuff about, the actual strangulations, and I did not see her react as she did many times earlier in the trial. Even today, when the Commonwealth was asking the witness whether she had control over, and she started itemizing those things.
Right.
Did the voice tell her when to do it? Did the voice tell her how to do it? Did the voice tell her what tool, effectively, what item to use to do it? All the answers were, of course, no, 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 no. But pretty in your face reminder about what you've done.
Right.
And I felt that she was, I don't know if getting used to it's the right way to put it. Some people say, of course, she was faking. I don't believe that, having seen it in person, but she's been far less emotional. I'll put it that way.
Well, let me put when you mentioned that, I thought how Reddington forced Sadoff to indicate that in different words he was saying that Lindsay Clancy was malingering, and then went through all the tests that she had taken to show she's not, and then got him to admit that Dr. Resnick was the leading expert in the world on malingering and wrote all the books of the tests, and he had to agree with that and said, that he's not malingering. Okay, and you just see, I thought I saw a change. Clearly Sadoff didn't want to go against Resnick. It's clear.
Yeah, and well, how could he when stack up there? I don't care if he's got a 70-page CV. A lot of stuff on terrorism. I might look to him if I'm trying to check on terrorism.
Right.
He seemed to
By
have
the
a
way,
lot of experience on that.
apparently he was submitted as an expert, and I think I sent this to you, a quick screenshot. I didn't have time to read it. Let me see if I did. Hold on, Michael Bryant, because when you're in there, I'm trying to. Yeah, apparently he's an expert in the Richard Allen case. Okay.
Oh,
To rebut Dr. Stuart Grazian, and the court ruled that he's not qualified to answer the questions about solitary confinement because it's not a medical question. So again,
they've got
he
some
must,
pending motion, some habeas
yeah,
motion.
apparently in terms of moving Allen, I guess either out of or maybe statements that he made in solitary. It says Sadoff himself acknowledged that the question of whether the conditions of solitary confinement is not a medical question. Dr. Grazian, that's for the defendant, experience sufficiently qualifies him to testify about the medical risks of prolonged isolation in general. Dr. Grazian's experience as well qualify him as a medical expert who could testify about correctional psychiatry. The court restricts Dr. Sadoff from offering expert opinion testimony concerning two principal topics. One, whether Reynolds confinement conditions constituted solitary confinement, and two, Reynolds' medical or psychological state. I'm not quite sure exactly what that's about, but here we have there. So there must be some list that all of a sudden these doctors are on, right? There must be something that they're being called to testify, for the government in cases. And as Kevin Reddington said, you're a G-man, aren't you? A government man, right?
You're basically a
Objection.
government man, right? Yeah, objection. Yeah. The Dietz connection as well, it's been hard for these experts to explain how and it's a referral service that they sign on for. They're not sharing an office anywhere.
Right.
They're basically signing on to the name, and then people will get referrals through that office. I mean, it's they've tried to draw a tighter connection, especially the defense has, because of the Dietz factor, I will call it. And then, that case with, that case back in 2004, 2005, the Andrea Yates case, they think they can get some stink off of that and put it on these experts, but they're totally disconnected from that. And they've got other things they can stink about.
Yeah. So anyhow, I just thought that was funny. Once you're an expert in these high profile cases, the internet now is basically another investigatory agency.
Sure. Sally, thank you so much. What do you think about planted memories and not guilty? This sounds like the Patrick Clancy conspiracy theory, because that's basically what people are suggesting, is that he comes back, does the deed, convinces her she did it, so she throws herself out the window, something like that, some version of that. And so
I disagree. I don't think Patrick Clancy has anything to do with it.
I would agree. And I've said before, yeah, maybe he wasn't husband of the year, but that doesn't mean he did it. And I see no evidence. I don't know. I'm just crazy about it. I want evidence, not just.
And
not
she
just a
admits
wild
it.
story.
And Kevin Reddington's not going to have her, do it. And to me, there's no doubt that explains her.
And he's been asked
her
that.
going.
He was asked yesterday too, as people were wandering
Oh,
by, and he just says, it's, I got more things to worry about than that. So.
Yeah, and it's a tough case for him. I mean, it's an emotional case, and he's doing mostly every witness himself. In the age of teens, he's really, he's decided that he needs that rapport with the jury. And I think they're going to like him. I think they're going to like him. We'll see, though.
I think there's no doubt about that. But as important as it is, it's not everything.
Right.
It's not everything, and that's why I asked him today. Because everybody asked, some of these dumb questions. How's Lindsay doing? And
what did she say to you? I love the question. What did she say to you? Yeah, that you can't. He's not going to answer. I think at one point he looked at somebody. Like, are you kidding me?
I think he did say that. That was yesterday. I think he did say that. And people, somebody yelled out, "Did you shiv Heilbrunn today?" Because it was replaying what he said the day before. Yeah, I thought he was great till he shivved me in the back.
Right.
So it was a callback to that line. But I said, I've done the deal, and I know how this is day after day after day. I said, how are you doing? You
Yeah.
know, and he's total pro, and he's like, I'm fine,
Yeah.
I'm fine. So
Yeah.
I just know it builds.
It builds. Joyco 1716 200 joules. Thank you, Sunshine. Thank you, thank you, thank you. All right, so we're going to be back in that courtroom. We'll just leave. Maybe Joy will play the interview. You cut it out already, or no? That's playing at 2 o'clock, or is it up already?
Well, let me see when I have it set to launch.
If not, we can play last night's episode starting about 16 minutes into it and start it with Dr. Gregor.
Let me see. Stand by here and take a quick
Okay.
look. It is scheduled for 2:30.
Okay, so why don't we start it now? Start from
It'll
the
start
main
in
one.
15 minutes. Or wait a minute.
What?
Wait a minute. We have, which one is his?
If you go up to
the one with, I launched the one with Grayson and us at 2. So that one has just now been launched, and then the other one's launching at 2:30. So officially, without changing them, that's where they are right now.
Yeah, no, but Joy can pull in the one from the whole episode from last night and just move it to starting at about 16 minutes in and play Gregoire. So
I feel like I just got here. I'm looking around for some more comments and stuff.
Yeah.
I know you've been hanging.
yeah, I'm
for a
gonna actually leave you for a while. Yeah, I've been sitting all morning. I've been sitting here, sitting over there working, and then rushing to get back in my seat when I hear there's a sidebar and taking notes at the same time, and having everything in my ear.
Okay, well, I'm
lucky
gonna hang out for another few before I go back up,
Okay.
and I'll scroll through the comments, and
Okay,
if anybody has any
fabulous.
last minute questions, I will be happy to answer.
All right, and then when they get back in court, we will put court back up. And Michael, I will see you.
And then
Will I see you after the
I'll probably
courtroom?
pop in after, just because it is going to be important in terms of what that means for
Okay.
the arguments tomorrow. But just a quickie, and then we'll circle back for our 6 o'clock. I've been trying to round up some folks.
Yeah, we
Do
did.
we have
By the
anybody
way,
on tonight? Do we have
no,
somebody
we
on?
have sent it. We have sent an invitation at 1:25 to, or about a little earlier than that, actually, to at 12:37 to Dr. Bergink. That's Dr. Chris. That's Dr. The doctor that Alain Gregor mentioned. She's right over here in Mount Sinai, right down the street.
No, okay.
But I'm not. That's to the generic email, so I'm
So
not sure it's going to
it
be
may
at the
happen,
right time.
but
It may
that may
happen,
not
or
happen tonight.
if it doesn't happen tonight, maybe tomorrow night. But we have sent that invitation out to her. She's
Okay.
right down the street, and it's amazing to me when you look her up. She's the expert in this whole area right here in New York at Mount Sinai. She's the expert.
Yeah.
I guess if
Yeah.
we could find her through for a referral recommendation, they could have been able to find her by just doing Google.
Yeah. Well, anyway.
Yeah.
And so I'll keep working on it. I'm trying to corral Lauren Conlon, but
Okay.
she's been traveling back and forth, not from New York, but from a relative who's much closer. So some people don't just hang out here at the courthouse. I'm
Yeah, right.
staying close enough that I just go freshen up, do some notes, then I come back and set up our little tent, our little compound. So it's easy. But most
Yeah.
people, when the day's done, they're out of here.
And
So
by the way,
we'll
we
see.
also
We'll
have
get
a
something.
we also have a 6 o'clock show tonight. Just so everyone reminds that we do have that 6 o'clock show. So, Michael, you're going to hang out. I'm
Yeah,
going to
I'll hang
leave
out
you
for a
for a
little bit.
while, and I will see you in a bit.
All right. Okay, so here's a question on the topic we were just chatting about here. Thank you, Snack Cake. So on the 911 call, you heard him say, "What did you do?" Yes. That is weird if they're implying he asked it twice. Yeah, that's why it's a valiant effort. I applauded the effort. It just makes no sense, because why would he ask twice if, in fact, he heard her answer? I can see why you would ask twice if you heard what I heard on the 911 call, but why would you be asking again if you already knew? If he asked once before, then he calls 911, why are you asking again? And believe me, that was the last thing he said, the last sound he uttered that was anywhere near human. Because after that, it got horrible when he went down to the basement and found one by one each of his children. That dog today, that was just it went better than I thought. I'll put it that way. It went better than I thought. Jules, I want to know what her reasoning to him was, why not to call Lindsay's mother. He didn't call because of Jen. He said, yeah, well, what Kevin Reddington is pointing out is that this guy's bought and paid for government dude. He's a government expert. So how much effort is he going to put in to reaching out? He has no prohibition against calling Kevin Reddington directly. But he went through the Commonwealth, who then reached out to try and set something up, and they tried to call back Kevin Reddington, who was in trial. He made a point of saying, "Did you know I was in a federal trial for an entire month?" Which is why he didn't get back to the folks that were being asked through the Commonwealth to visit with the doctor. He's their guy. So no, he's not going to take the initiative to reach out directly to Kevin Reddington or his office. You know, if he's not available, that's something that his office person, I compared her to Della Street in Perry Mason. Hey, doll. You know, she's been there like 38 years with this guy. I'm sure she handles those kinds of things commonly, easily. But nobody tried. Why? Because that, you know, they weren't trying that hard. Let's put it that way. And it just puts one more discredit on that column for those folks, because there's certain things they don't want to know, because that hurts the testimony they're going to be bringing in. I can't believe it. I just can't get past the Commonwealth not considering their feelings and insisting on prosecuting again. That's the big overwhelming issue in this case, which may become larger than life if there's a hung jury, because then you're saying, okay, will they do it again? Would they try this again? Maybe I should ask the DA that next time he's holding the door open. Yeah, I believe this is true as well. We were talking about the body temp, and everybody's freaking out about, you know, if it's 82-degree core temperature, she had to be out there for a long time. That tells you why it was Patrick. I heard someone say a serious injury could drop the body temp drastically. Yep, and when you have the kind of injury she had, where paralysis is almost immediate, I think, I'm no doctor, but I'm pretty sure when you have that severance of your spinal cord, the blood flow, it doesn't stop completely, but it slows to a virtual trickle. Yeah, I think she was the only witness on so many things that were so important for this jury to figure out. And thank you. I'm just saying. I thought Laposada did a great job explaining the body temp. I remember she also talked about the timing, which I really think Kevin Reddington has to circle back to in closing, because right now in this jury's mind, the collective minds of the jurors, it's 18-20 minutes. It's 18-20 minutes. It's 18-20 minutes, because there have been at least two experts using that time frame for the unaliving of the children, and using that to suggest no way a psychotic episode would last that long. Of course, our expert last night, Dr. Allen, who you'll get a chance to listen to here soon, he said, no, there's no time limit. Doesn't expire. The psychotic episode doesn't expire. So yeah, that's great. Even if you believe, if you're the defense, and even if you believe the 18 to 20 minutes, I'm saying you better knock that down. Remind them of Laposada, the 10 to 15, 20 seconds to lose consciousness, and the nature of the ligature, because the Commonwealth just ignored that. They made it sound like it was a manual strangulation, which has all kinds of moving parts. You know, you don't have the uniformity of the band, the ligature. And then remind them too that it was taken off by Patrick Clancy. It was tied in a half knot. It's not just looped around there like I don't remember if it was Bo Buckingham or if it was Jen Sprague. Anyway, whomever said it or tried to use that as a demonstration in the cross-examination of Dr. Laposada. Loser, it didn't play. And the image created by Patrick Clancy talking about having to take the belts off of each child, you don't just forget that and just replace it with this loose wind that was attempted by the Commonwealth. I'm trying to think of other bits and pieces that are really contradictory and need to be cleared up in closings. Let's see. Serenity. Bless you. Bless you. One of the doctors said in the testimony that because she severed her spine, her body lost ability. Yeah. And I think that was Dr. Laposada as well. she's great. I mean, that is such an amazing witness. Too bad they didn't finish with her, but that's all right. Again, she answered so many questions that nobody else did. She has really uncontroverted testimony on a number of different topics. And Piccolo, Michael, the temp deregulation, it was neurogenic shock, the massive injury, the dip. Interesting. You speak, and Piccolo, as if you had some medical expertise there, or did you ask Chat GPT? Come on. But that's the impression we're getting from the medical folks, right? Oh, well, thank you, Wendy. E329. We are the best. You forgot the rest of our thing. Justice Through TV is the best kept secret in true crime. I would hate to be a jury member in this case. Yeah, it is going to be tough, but I will tell you that I think that the 6 that become alts are going to be very frustrated and disappointed. Yeah, this is a long ride to just be kind of let out at the curb. Well, start with one, Bittersweet. I have so many questions and I can't get the answers. Michael, did the evil twin gain some ground with the inconsistent stories? To me, it's a question of whether the jury buys that as an element. Remember what that's all about. It's not as much about, I don't think it's as much about suggesting, oh, she's making stuff up. And, when you make stuff up, things are always going to be inconsistent. The truth is always the same. I think they're using it to negate a psychosis diagnosis. I rhymed that. If that apparently from what the doctors are suggesting is that if you have these inconsistencies, that negates a psychotic episode. I mean, I think I think before they get to giving that enough weight, just the fact there are inconsistent stories, I think you have to believe that it negates the psychosis, because that's really what matters most. Julianne Nelson, I'd vote for NCR, not guilty for lack of criminal responsibility, but would have liked your expert to address they wanted to free the kids. Fake offing yourself attempt. Okay, I'm trying to decipher this. I'm not too bright. Let me work on this here. So are you suggesting that it was a fake suicide attempt, or that I don't know. I'm sorry. I can't put all of it together. I don't disagree with your overall belief that it could be not guilty by reason of lack of criminal responsibility. But I'm not sure I understand the interplay there between the offing of the children and the offing of oneself. Sorry. And Piccolo. Oh, did we already do this one? No, we did. I'm going backwards. But I do think you have some medical, get some medical something there. Share more, please. Yeah, and this is where it can get kind of tricky, and I'm glad you guys are talking about this. It's important because I do think it's possible some jurors could believe she still understood right from wrong, but could not conform her behavior, and that's the two-pronged test. Do you know right from wrong? No, I didn't know right from wrong. I just, I didn't know that, offing my children was wrong. But even if you did know that, and you could not conform your actions because it's overcome by this psychotic episode, you're still looking at lack of criminal responsibility. Yeah, I would agree with this too. Dana Zuber, 856. There are just too many questions of doubt. Seems like the rebuttal witnesses made that muddiness more muddy. I will tell you, I don't think they helped. Remember, the rebuttal witnesses and the rebuttal case is designed specifically to address the defense. And I think they danced around it a lot. And I think their experts were not the proper experts because, my CV looks about as good as theirs when it comes to knowing much about psychosis. But for whatever reason, they got who they got. But I would agree that I don't think it helped clear up the Commonwealth's main case, the case in chief, or tear down the defense case. Okay. Okay, Lori Ballou. I think the odds are there will be, that's just the math, but it's possible there wouldn't be. And there is the belief that there are three, I think it's three nurses of the panel as it exists now. I think it would be helpful for everybody if they were on there. Again, sometimes it can be dangerous. Somebody with that kind of knowledge, they become relied on too much, and maybe persuade people because they do have that knowledge. Again, that's you're allowed to bring your knowledge and experience to the table, right? You can't do independent investigation, but you are allowed. If you're a locksmith, hey, you can talk about what you know about locksmithing. Either not guilty or not guilty. By a lack of criminal responsibility. Yeah. I still think a hung jury is definitely on the table. And if that happens, will they try this case again? Wow. Yeah. Hey, Scott. Good to hear from you, bud. Tough competition on the YouTubes covering these trials, but many channels have their lanes. Last night's guest here last night was excellent, for example. Thank you, Scott. Yeah. There's no doubt, and I've talked about it many times, that when somebody somewhere decided, hey, this thing's getting eyeballs, we got to jump on, that's what happened. It's for better or worse, because I'm telling you, there's we're just doing our thing, same thing we've always done, but there's some let's just say slap together shit out there. How about that? Rebuttal destroys Commonwealth fake attempt. Hi, folks. I don't know about that. Let me think about that for a second here. Obviously, Clancy folks back from their lunch. Should I ask them to give me a sandwich? Would that be wrong? Let's see. Rebuttal destroys Commonwealth fakes. Yeah. Well, the thing is, they kind of destroyed it themselves, right? They shifted gears somewhere in the middle of the trial, outside the presence of the jury, when they had an argument about an evidentiary issue, and they were saying, "Well, we're not saying that it wasn't a serious suicide attempt. It was just a bad one. Just wasn't done well." Well, yeah, obviously it wasn't done well because she's sitting there in a wheelchair, alive, moron. Yeah, this is an interesting take. Thank you, Hunting for Kitty. I agree with the person who said if Lindsay was faking, she would have kept it up longer and magnified her memory of the voice. Yeah, there's been such criticism by the Commonwealth and by all their doctors, of course, that this one-off, and we talked to Dr. Allen about it last night. Again, in fact, it's launching now, and I'm going to get out of here. That you can either watch that or get ready for the jury instructions, or both. But when you get a chance to watch him, you'll see how we talked about that. Just the fact that if it was the first time she heard a voice, and that's a little unclear as well because of all these thoughts she had. It was never cleared up by the medical experts. Well, you're talking about these thoughts. How do they manifest themselves? Is it an internal voice, an external voice? What is it? So we don't know for sure. But assuming it is, the one time she hears the voice which says, "This is your last chance. You have to kill the kids and kill yourself." Dr. Allen said, yeah, that could happen. That could happen. And so why wouldn't she just, if it were all fake, why wouldn't you just make up, oh yeah, there were 5 or 6 times I heard a voice. She had so many places she could plant that evidence, if that's what it was going to be, fake evidence. She could have shared that many times over with many different people. Yes, I know. I used that joke a couple of times. I've worn it out now. I'm going to stop. Like when he came into court, I just say, "Hey, Jeff, how you doing?" That's Dr. Z's twin brother. So I think at a certain point it's probably too much, and I think I went too far. So I'm done with that gag now. But thank you, Helen. It was a good one. It was fun. That guy's such a good guy. I know we're going to get him on at some point when the dust settles here. So we'll see how it goes. Lori, when I watched the free trial stuff, I was surprised how much she paid attention now compared to Zoom. I thought I knew what that comment was, but I don't. So I'm going to move on. Sorry. Okay. Some of these are very interesting. I don't want to open up some new proverbial cans of worms. This is always a good question. Anybody who thinks they knows the answer, come on. But here's the question from Penny Barty. I told you, Penny Barty. I'm not saying your name, Penny Barty, Penny Barty, Penny Barty, ever again, Penny Barty. Linda and Michael, if you had to guess, how many jurors do you believe already have their minds made up? I think this case may be one of the few where closing arguments has a chance of changing a mind. Because I really think that going into closing arguments, virtually all jurors in most cases have their mind made up. You may be able to shift them a little bit. Maybe the deliberation process will, but I think they get to this point with some sense of where they're going. This case, maybe a few less. And of course, since we don't know yet who the 12 are, kind of tough to pick and choose of those that I've identified by my own little descriptions. I don't think any of those have outwardly, made their decision known by body language or attention or note taking. Everybody has been very equal in terms of who they pay attention to, who they don't. When it's boring, and I'm telling you, when it's boring, they're bored too. But I think they've been very good, and the fact we still have all the alts is somewhat surprising. Okay, let me get out of here. I'll circle back after this little instruction conference, and then of course we'll have our show tonight with a surprise or two, even surprising to me because I'm not sure what the hell we're doing. Okay, see you.
I guess
Frozen.
when the
Maybe this is
prosecution,
because we're done.
you're frozen too,
Grace,
Michael.
if you unfreeze, thank you so much for being here. Now, Linda, you're good.
I'm
you're
good, but you're a
Okay.
little frozen, Michael.
Oh, there she's back. Grace,
I think we'll let Grace
thank
go.
you so
Thank
much
Grace.
for popping in, and I will see you back here tomorrow, and we'll see what happens.
See you, Michael.
Thanks. Take care. Bye.
Bye,
Oh,
Grace.
sorry, cut her off there.
That's okay.
Sorry.
You cut her off. And so let's bring Dr. Alain Gregoire in. Alan, we're going to call him Alan. Let's add Alan to this. Whoops. We try to add Alan to the stage, and Michael and I both have the controls there.
Just like that. We're battling. There we go.
We're battling with the controls. And let me also add into the stage this little thing. And then you all watched a week ago last Monday. We had Alan and Dr. Peter Dean on to talk about how European countries, England specifically, and other countries treat maternal mental health, postnatal mental health for women. Let me just read again a little bit about Dr. Allen. I'm going to call him Dr. Allen's credentials. He's honorary president of the Maternal Mental Health Alliance. He began his training in obstetrics, and then he saw that there was a need for mental health with women, he told us last week, in the perinatal area, and that most were very ill, but there was no treatment areas. So he switched and to train at the Institute of Psychiatry in Maudsley Hospital in London. And for 30 years, he has been a consultant specialist perinatal psychiatrist, something we haven't heard about the prosecution's experts, during which he has set up and led multiple specialist perinatal mental health services. He has contributed extensively to the development of policy, strategy, guidance, and clinical services in the area of parental and infant mental health in the UK and internationally. And he has worked closely with several UK ministers in success with governments and has been invited to speak to parliamentary meetings and ministers in several countries. He founded the Global Alliance for Maternal Mental Health and has informed the world about the development of successful alliances in many other countries. He's currently a visiting professor at the London School of Economics. He also has a BBC documentary, My Baby, Psychosis, and Me. And if you want me to read that back, we'll have to have Dr. I'll have to have Alan talk about it in English, French, Norwegian, for which he is fluent. And next week, he is off to a conference in Cape Town specifically on this issue. You know, the issue of, Doctor, I will just say the issue that the the prosecution experts said there is no such thing as a postpartum psychosis, okay? Because it's not in the DSM. And even if you want to recognize it as maybe a subcategory of something, it only occurs in either, if you believe the DSM, in the first 4 weeks of birth, if you believe the Cleveland Clinic, in 6 to 8 weeks, and if you believe the ICD of the World Health, it's a year. I know England has recognized this since 1938. So welcome back, Alan, to try to educate us. And Michael, I know, has some very specific questions about what the experts are trying to let this jury buy today from behalf of the Commonwealth, and to see whether these things are true or not true. So, Michael.
So first of all, quite the introduction there, and thank you for once again gracing our operation here, Doctor. Yeah, I've heard from a lot of doctors. I've heard from a ton of doctors, but finally one that I think I can trust. So let me ask you, one of the issues that has come up again and again is this nebulous kind of definition of psychosis, and then how does that relate to a postpartum condition, right? And it sounds to me like some of the experts for the Commonwealth, and of course their job is to negate the psychosis because that is the defense. And they do so by suggesting there's this inconsistency of statements made by the defendant. She made this statement here to one person or through a doctor's notes, and then to the doctor expert who has interviewed her, that statement has changed. Is there any validity to that discussion about inconsistency in statements negating psychosis?
Absolutely not. I mean, it's absolutely typical of somebody who is suffering from a psychosis, a psychotic episode, that their thinking is severely disturbed. And it's actually particularly described in postpartum psychoses. And there seems to be no doubt that this woman has had a baby within the last 12 months, so she is postpartum. And as far as I understand it, I'm not following this case closely, so I don't really want to be drawn into commenting on details of the case, but my understanding is that she's been receiving treatment, including treatment for psychotic symptoms. And if you have psychotic symptoms and you are postpartum, you have a psychosis postpartum. Or in the UK and internationally, those people who have worked in this area for years or indeed decades, be it academics or clinicians, we call this postpartum psychosis because it is such a well-recognized, well-described condition, which we know now so much about. We know something about its genetics. We know quite a lot about its risks, about the course of the condition, and about the risks both to the individual and to the individual's thinking and to their functioning. And inconsistency is one of the key characteristics that you will see in any sensible quality description of postpartum psychosis, or indeed, if you don't believe in the concept of postpartum psychosis, nobody in psychiatry disputes the concept of psychosis. It is entirely consistent with a psychotic state of mind and psychotic illnesses in general.
Okay, so let me ask you again, we'll try not to be specific for the evidence, but assume that the argument is that, you know, she heard that the command voice, if you recall, on the day of the incident. The testimony, and I just say I have to put it out there. The argument from the two doctors is if she only heard a command voice telling her on the day of the incident to kill her children and then kill herself, that is indicate that she's lying about it, because if you're going to hear voices, you're going to hear them more often than just the day that you actually take your life, try to take your life and take your children's life.
Well, individuals differ. So look, I have no axe to grind here. I'm not speaking on behalf of one side or the other. I'm speaking to you from my knowledge as both an academic, a researcher, and a clinician of 40 years standing as a senior clinician in psychiatry. And mental illness amongst British people is really no different to mental illness amongst any other people in the world when it comes to psychotic illnesses. There is huge individual variation in how people present, but it is absolutely diagnostic and typical of psychotic illnesses that you have hallucinations. And just to remind people, we've all heard the word hallucinations, but people aren't always familiar with what that actually means technically. Hallucinations is hearing, usually in mental illnesses, it's hearing things rather than seeing things, but they can be visual hallucinations. Actually, they can be in any modality. So you can have tactile hallucinations where you feel things. You may feel creepy crawlies on your skin, for example. You may see things, you may hear things. But true hallucinations are experienced as if you get them through the sensory organ. So when you have a visual true hallucination, you see it as if you are seeing it with your eyes. It's not there, but you are seeing it through your eyes. Your eyes and your brain are tricking you. When you have a true auditory hallucination, which is from what you tell me, what she was describing, you hear it as if you are genuinely hearing it through your ears. It's not, I hear a voice in my head, I hear it through my ears. So it is utterly real. You know, if you hear something, you believe you've heard it, okay? And if it is telling you to do something very strongly, very powerfully, even if you don't want to do it, it's very, very difficult if it's a very forceful voice to stop yourself reacting to it, doing something in response. And that's where risks arise. And these are well-established risks with psychosis. Usually, they lead to people harming themselves. But there are well-described cases all over the world where they lead to people harming others, sometimes strangers, in horrific incidents, which happen, again, all over the world, and sometimes to those people who they are closest to, because the brain and the mind have a way of tricking you in issues that are really important to you. So when you develop false beliefs, which we call delusions, which is not a hallucination, it's not an experience, it's something you believe, you very often believe things about people or things that are really close or important to you. And that also happens in hallucinations. And if they're very, very strong, you may act on them when the very first time you get them. Or if they're not quite so strong, it may take weeks or indeed months of experiencing them before you finally give in to them. But if you're completely overwhelmed, you may act on them the day you start getting them. And what we know about postpartum psychoses, in other words, psychoses that happen in the postpartum period, which usually start very soon postpartum, but we spoke last time about how they can start but not be detected, not be recognized at a very early stage and take ages to develop. I have seen people develop the extremes of their symptoms months after the illness first started. So to me, this is not inconsistent with psychosis. Now, of course, you know, I don't know, I haven't interviewed her. It's possible that she's making the whole thing up. But you don't usually try and end your life, because you're making things up. And you certainly don't kill children who you adore and who you've always adored, suddenly just for no reason at all, and then decide you're making the whole thing up because it was just going to be a bit of fun. I mean, that's just patently ridiculous.
You are a breath of fresh air, doctor, because that's what we're all thinking. What about this concept that if you decide you're going to take your own life because you want to end your suffering, okay, and you want to have your plan, but then you have an altruistic filicide because you're going to take your children's life because you don't want them to suffer after you take your life, that does not constitute postpartum psychosis, or if you're going to use the word postpartum psychosis, which they weren't even going to use, but that can't constitute, that your motive of killing yourself can't then, if that comes first, the altruistic filicide does not qualify for postpartum. Talk to us about that.
Well, it doesn't make any sense at all. So we have actually a very famous case that happened a number of years ago in the UK of a psychiatrist who herself developed a postpartum psychosis, and who this was in the days before we had services for detecting and treating postpartum psychosis available all over the country. She was in the East End of London. This psychiatrist had a baby, was known to be at risk of developing severe mental illness, did not get the care and follow-up she should have got, and killed her baby and then herself. And those events happened. It was very clear from all the investigations that were carried out later as saving the baby from the horrific future which her illness was telling her was going to occur to both of them. So she did it out of kindness. The outcome, of course, was absolutely horrific. And the lesson, the conclusion from that was not that if she'd survived, she would have gone to prison. The conclusion from that was that the system and the healthcare system should never have let that woman and that baby down, and that we knew she was at risk, and we knew she was developing mental illness, and we should have taken action because these risks are well described, well established, and she is not a one-off case. But the fact that she was a psychiatrist really hit home to people, and we started to take things a bit more seriously.
Let me ask you this, a hypothetical, because these are all hypotheticals. I'm just sharing some details in my hypothetical and getting your reaction as if you were my expert. Is there a time limit for a psychotic episode? If it lasts longer than 4 minutes, is that unheard of? If it lasts longer than 20 minutes, is that just not the way it works? Is there, how does the psychotic, quote, episode ebb and flow in terms of time increments?
It varies enormously. Okay, I've already said that. There's huge individual variation. But unless they're caused by some sort of very clear physical causation, like an infection or an imbalance in electrolytes or fluids or some sort of acute severe physical illness, they tend to last much longer than minutes at a time, usually even longer than hours at a time. It usually lasts days. But there is huge fluctuation in the mental state of the individual. And we certainly see that it's particularly noticeable in postpartum psychosis. It can happen in individuals with psychosis at any time, but it seems particularly to be a feature of postpartum psychosis that you get these fluctuations. And you certainly get fluctuations in the symptoms. So the person can be still very ill, very dysfunctional in their thinking for a long period of time, but they may go through half a day when they have a lot of hallucinations, and the other half of the day when they're not really very troubled by them. So you can get that sort of fluctuation. And then you can get much bigger fluctuations over weeks and months. So as I understand it, this was quite a long period of time that she'd been ill for and receiving care. You can have ups and downs that are both a feature of the illness, but also, very importantly, a feature of the treatment, both the treatment given and the treatment taken. And those are very important concepts as well, because when you're psychotic, you very often don't realize quite how ill you are, and you don't you're not fully on board with constantly, totally consistently taking your medication. It's hard enough for you and I, when we're not psychotic, to take medication every day. Okay, everybody knows that, forgetting and, running out and stuff like that. But if you're ill in a way that leaves you uncertain as to whether other doctors trustworthy, are they telling me the truth, or are they part of a conspiracy out to get me? Why should I go along with what they're saying if this is all a conspiracy? So the psychosis itself can suggest to you that you shouldn't be poisoned by the medication you're taking, for example, very common thought, or make your thinking so disturbed that you just get in a complete muddle about it. So fluctuations in the illness, but also fluctuations in the treatment given and taken. And fluctuations in the treatment given come from inconsistent care. So, if you see one doctor or one service one day, and then 2 weeks later you see a different service, or you're treated in the emergency room by somebody who hasn't got your previous records and starts something slightly different, or you're on multiple medications, and you get in a muddle with which one you're meant to be taking, those things will lead to fluctuations in your treatment. And you can be very well one week and really, really ill the next week.
Wow. So let me ask you an A and B question, because we're trying to educate everybody about this, about perinatal mental health, right? What are the risk factors so that women are aware of the risk factors? And you said they're easily identifiable. We now know so much more than we did maybe 50 years ago. What are the risk factors first about that? I guess that would be my first question to you.
Yeah. Well, for postpartum psychosis is relatively rare. Okay. It's a lot of women in the United States, but there are a lot of women giving birth. It's about 1 or 2 per 1,000 women. So 1 in 500, 1 in 1,000 women will develop a postpartum psychosis. Okay. And that is the most high risk, most complex illness that requires the most intensive level of care. And in the UK, we say that, the majority of women, even if you have very well structured community home-based care with lots of professionals looking after you very carefully, you very often need to end up in a psychiatric hospital. And in the UK, you can do that with your baby and safely be cared without forced separation from your baby, allowing you to, for example, carry on breastfeeding and so on. And we can do that safely. You don't have mother and baby units in the United States. They're considered too expensive. Keeping mothers and babies together is too costly, apparently, even though our poor little country can afford it. So that's strange. So it's relatively rare, needs high levels of complex specialist care. And the one risk factor which we know of that gives you the highest level of risk is having experienced either with a previous child, a postpartum psychosis before. That puts your risk at about 50% or so of having it given no treatment, no prevention. And also, if you've ever suffered from bipolar disorder, that puts you at very high risk. And again, if you're not on treatment or medication, the odds are probably higher than 50-50 of developing an episode of postpartum psychosis if you've ever suffered from bipolar disorder. And it does seem that those illnesses are closely linked. They're not the same thing, but they're very closely linked.
And tell us why they're closely linked, because I think that's what the American doctors we're hearing from are saying. Well, it's postpartum psychosis is really bipolar, but it's not.
It can be, but it's not quite the same thing. The acute phase looks different. It's usually, even in people who have had previous illnesses with bipolar disorder, even people who've had severe illnesses with their bipolar disorder, their postpartum episode, if they have one, and they have a very high chance of having one, tends to be much more high risk, much more severe, much faster onset, much more rapid, and utterly predictable. So we know when it's going to happen, and we know how high the risk is. That doesn't happen at any other stage of life in bipolar disorder, but it happens postpartum. And then there is a group of women who only get these episodes postpartum. They look exactly the same, so the symptom profile is the same, the risks look exactly the same, but the timing is only postpartum. They don't seem to get ill during pregnancy, and this has been studied by one of the great psychiatrists working in New York, actually, at the moment. They don't seem to get ill during the pregnancy. They only seem to get ill postpartum, and they don't seem to be at risk at other times in their lives, only in the postnatal phase.
Wow.
And who is that psychiatrist that's here in my New York right behind me?
Yeah, well, it's Professor Veerle Bagink, who's a Dutch researcher, but now working in New York. And she's done some really, really good studies looking at this distinction between the women who have this postpartum only presentations and those who have both bipolar and the postpartum presentations.
She may hate you tomorrow.
Let me ask a follow-up related question. How hereditary is bipolar? Is it if your parents have had it, you're 50% more likely? Is there a correlation there?
Yeah. So there is definitely an added genetic risk, although now, I'm not an expert in the genetics and the hereditariness of mental illnesses generally, but I think the majority of people with bipolar disorder don't have a parent with bipolar disorder. So, it happens new as well, but you're definitely at high risk if you have a first-degree relative with bipolar disorder. And it also, interestingly, if you have a first-degree relative with postpartum illnesses, that puts you at extra risk of specifically the postpartum onset of psychosis. So there does appear to be a genetic link there, which is partly related to bipolar, but also separate. And this gets too confusing for a lot of my colleagues. My interest mainly in this is clinical, and clinically, this is a very clear issue, and we can give very clear advice. We have lots of knowledge, but people who are very concerned about classification systems, like those writing manuals like DSM, this starts to get a bit too complicated to get their head around, because we have a condition that is both linked to other conditions, but also in an identical presentation appears to also carry its own individuality. And that blows their minds. And so I know that there are debates going on about what to do with DSM-6. You've had, I think, DSM-5 quoted in your court cases. There are debates going on as to what would be the best thing to do. For me as a clinician, and for women, it's very clear that the concept of postpartum psychosis, with its very typical presentations, its very rapid onsets, its predictability for certain people, its predictability in terms of its risk levels, in terms of its course, in terms of its curability. I mean, we can get people better with the right treatment. I can guarantee women that they will get better. I can't guarantee it won't come back, but I can guarantee they will get better. That's very rare. But I can also tell some women the date on which they have a 50% or more risk of becoming ill. That's incredibly rare in the whole of medicine. So this is a very useful concept for us as clinicians. But yes, those dealing with classification systems, because we know so much that makes it a complex story, it kind of blows their mind for which page to write it on.
Yeah. So we have a retired FBI agent, Jodine Weber, who's a friend of ours in here, and she says, why can't January 24th be the first time she heard a command voice? The fact she had intrusive thoughts about harming the children in December indicates to me she was on a downward spiral, right?
Well put. Well put, completely sensible. And, as I said earlier, if that was a really overwhelming voice, as it sometimes is for some people, the people are told to kill themselves and do kill themselves, very high risk. If it was very overwhelming on that day, that's the day she would have acted on it. Not 3 months before, she may well have had it for the first time that day, overwhelmed her, and she acted on it.
Let me ask. Can I ask one quick follow up before?
Yeah, go on,
I know
sorry,
we promised only to keep you, a
I
short
know,
period
half
of
an
time.
hour.
It's coming up on the witching hour. There in
We've got a
the
few more
UK.
questions.
So again, if you hear a voice, first time, 10th time, whatever it may be, and it's instructing you to do something, is it normal that it would just end when you accomplish whatever the directive was?
Not necessarily. It just then changes to something else. So it might, it might, and I have no idea what happened what was happening in her mind or in this case, or what has been said, because I haven't been following it in that detail. But I have seen situations where, analyzed situations where women have been told to kill their children. And in that one particular case, that seemed to be what was happening that I was describing to you. And then the voice just switches to, well, now it's your turn. You've got to go. And if you don't, terrible things will happen, or the devil will come and get you, or, whatever it might be. It's your only way out. So it just switches to something else. So you're not out of it. And it's the hallucination, the phenomenon that is the feature of the illness. The content is in a way separate and very often horrific and terrifying and really horrible. But the content can switch even though the phenomenon continues.
If anyone is getting treated and they're given the wrong drugs, can that delay the onset of the actual psychotic break? In other words, does the administration of different drugs delay it, or is it irrelevant?
No, I don't. I think it's very unlikely that drugs would delay the onset. But what very often happens, this is just a common situation, is that you might have effective treatment, and that is somehow changed, dose altered in either direction, actually, interestingly, or a switch in treatment or a different combination that doesn't work as effectively. And then you get a return of the illness or a different feature of the illness. But it does also happen that you start an effective treatment and it just doesn't keep working. And that can happen for a variety of different reasons, the most common being that the person doesn't carry on taking it. And you can't blame them for that. It may be that symptoms start creeping in, voices telling them, don't take this poison, it's going to kill you, or whatever. Or they forget once, and then the symptoms start, and then the symptoms tell them to carry on not taking it, and so on. So variation in medication can do that, but the medication itself is unlikely to delay the onset. It'll be it may make treatment effective, and then for some reason or other, it becomes ineffective at a later stage. But the course of the illnesses varies, as I said earlier, as well. So for no reason that we can explain as clinicians, we quite often see people who seem to get really better, and they're off home and everything's going lovely, and suddenly, bang, for no reason that you can explain, suddenly they start getting ill again.
And I think you said that, it can happen just like a snap, like a light switch going off, right?
Very
fine.
So it's a key characteristic of postpartum psychoses is that the onsets of the symptoms is incredibly rapid, much more so than at any other time.
We have one really good question. I want to ask the doctor one more really good question. Can bipolar be brought on because of pregnancy or trauma associated with it?
Yeah, so not trauma in the sense of a traumatic experience of pregnancy or delivery, that doesn't appear, or indeed past traumas don't appear to be strongly associated with the onset or the occurrence or the risk of developing bipolar disorder. But the postpartum period is the highest risk time in humans that we know of, male or female, for developing an episode of bipolar disorder. So it's not unusual that postpartum psychoses are the first ever episode of what subsequently proves to be a bipolar disorder, subsequently because the woman then goes on to experience non-postpartum episodes. So the first time she ever gets ill with her bipolar is postnatally, because that, for reasons we don't yet understand, is the time of highest risk in human beings, male or female, for developing an episode of bipolar. She's relatively young. There's not been another time when she's been at such high risk, so she gets her first episode of bipolar disorder. So you can, so for women who have their first episode of being ill as a postpartum psychosis, you don't say, well, this means you have bipolar disorder, because there are these women who only have postpartum episodes. But one should say as a clinician, it's possible that you might get other episodes, not just when having your next child, but at other times. And if that happens, you need to get in touch with us as soon as possible. And if that happens, that might mean that actually what you have here is your first episode of a bipolar disorder. But we can't know at this stage whether that's the case or not. So it's the most powerful trigger that we know of, is having a baby for a bipolar episode.
Wow. Well, I mean, this is what we're trying to do, is educate everybody out there who may be getting misinformation from what they're hearing. And Doctor, you are just amazing.
And remember,
Michael?
it's treated, just to interrupt you,
Treated.
I must emphasize this is treatable. So don't let this case fill you with horror and fear so that you don't go and get help. If you think things are not right, or if you think in somebody you love who's just had a baby, things are looking really not right, get help, because these are absolutely treatable conditions.
No, that is a great message to leave everybody with as we continue to follow this case. Doctor, we got you out pretty much on time, so I hope that means you'll come back again.
Everybody get a chance. I know you just got them about an hour ago. So in regards to the draft that I gave, I know I got one set of proposed instructions from the defendant. Does Commonwealth have anything you wish to offer?
We don't have a written motion, but we just do have a few comments.
Sure, well, that's kind of what I expected. I know everybody's been on trial, so I thought that's kind of why I thought I'd give you the draft, and we could just kind of walk through it. So my thought would be to first go through the Commonwealth's position, and then I'll hear from the defendant. Attorney Buckingham.
Thank you, Your Honor. In relation to your proposed your draft instructions, I think that Your Honor's instruction regarding criminal responsibility is pretty much the cut and paste of the model instruction. So overall, there's no objection to it. However, the Commonwealth would just like to put on the record that we don't think that voluntary intoxication, the 3 points that were added in to Your Honor's draft, are necessary. And I'll just cite to the Commonwealth versus Brown, 449 Mass 747, 2007 case, where it says that an instruction on voluntary intoxication is not required absent evidence of debilitating intoxication. Such evidence must support the inference that at the time of the killing, intoxication impaired the defendant's ability to form any requisite criminal intent. And so in this case, I understand counsel is going to argue, medications, and he's free to argue that to the jury. But as far as instruction goes, we're talking about criminal responsibility. We're talking about mental status at the time of the event, on the day in question, January 24th, 2023. There is no evidence to support that there was intoxication to a debilitating effect, as the Brown case indicates. I think what the best evidence the court has is that the defendant in her journals and in some statements that she made to the experts indicated that at the time of the offense, she was taking amitriptyline and one other medication that she had been on for quite some time. And Your Honor now has evidence that it was a very low dose of amitriptyline. And there is nothing about the observed behavior of her on that day suggesting that there was any debilitating effects of the consumption of prescription medications on that day. So we would ask that those sections not be included in the instruction. If Your Honor is inclined to include them in the instruction, we are asking that you add a qualifier into it's what's listed as paragraph 3, where it starts to talk about.
Is that on page 3, kind of Roman numeral 3?
Yes.
Okay,
Roman
all right.
numeral 3.
Yeah, go ahead.
It says the defendant who lost a substantial capacity I have just described involuntarily intoxicated by prescription drugs. We would just ask that you add on the day of the offense to, again, just be clear to the jury that we're talking about her consumption or the consumption of the medication on that day. I did notice a quick typo on page 4 under Roman numeral 4 in that first full paragraph where it's the consequences of a finding. It says in the maybe 5th line, it starts, if the court concludes the defendant is mentally ill and that her discharge would create a substantial likelihood of serious harm to himself.
Oh, gotcha.
It's just a pronoun.
Right. Okay, no, I appreciate that.
As far as the remaining charges, instructions on the charges of first degree with deliberate premeditation and extreme atrocity or cruelty, the Commonwealth has no objection to that. I would just note another typo on page 7. Your Honor lists out the Castillo factors. On the third factor, C and D appear to be on the same line, and there are just some numbers in there that I don't think make sense. This is the manner and degree of severity of the force used.
Oh, I got you. Yep.
And as far as the instruction on involuntary manslaughter, the Commonwealth would object to the involuntary manslaughter, and I would cite to the case of Commonwealth versus Garabedian, which is an older case, 399 Mass 304. It's from 1987, and it says that the defendant, in that case, the defendant argued that involuntary manslaughter was required because of evidence of involuntary chemical intoxication. That was a case where the guy was he sprayed chemicals on lawns, and he had an interaction with a homeowner and ended up getting into a physical altercation with her, strangling her, falling off a ledge, hitting with a rock, and then strangling her with a shoelace. So in that particular case, the court held that an unlawful battery was quite likely to endanger life and hence could not be classified as involuntary manslaughter. So where it's a wanton and reckless conduct theory, I think that Garabedian is right on point to say that in situations like this, where we have the strangling of the individuals, of the babies, of the kids, unlawful battery is quite likely to endanger life, but that it shouldn't be an instruction for involuntary manslaughter. So I'd rely on that case to argue that that is should not be included in the instructions. And one more point. Your Honor, at one point when we were arguing about particular pieces of evidence and duplicative evidence,
Yeah.
Your Honor did indicate giving some sort of instruction about the jury shouldn't consider the fact that there might be duplicative evidence as being, giving any more weight or importance. And I know you do have a small line in that where it says in the what is evidence section about the strength or proof is not determined by the volume. But I do think, again, based on the particular way in which the evidence came in and how the parties chose to display the evidence, and the fact that we have text messages in several different forms that are presented, some of them the full records, some of them condensed records, that some instruction to them that indicates that they're to give no more weight to any one than the other, even if it does appear duplicative in the record. I'd ask that something to that effect be added.
I think it says that on page 11. Because I do remember that request. If you look at under what is evidence, in this case, there may be certain documents or photographs that are entered multiple times. This does not mean that that evidence is any more or less important than any other evidence. So, so I put that in there, and I understand the request to maybe put that in a separate paragraph, but I have addressed it that way. I'll consider not whether I give it a separate paragraph. I do understand the request, but at least that's why I put that in there. All right. Anything else? Okay. All right. Mr. Reddington.
Okay, here we go.
Thank you for the time to review this stuff, Judge. If I may, just going through your proposed instructions, Roman numeral 1, introduction is fine. Criminal responsibility, paragraph 1 is fine. Going down on page 2, criminal responsibility, you indicate is a legal term. Not criminally responsible with a mental disease or defect, and then you make reference to lacking substantial capacity either to appreciate criminality or wrongfulness of the conduct or conform the conduct. That's fine. And then you define you don't define it, but you talk about mental disease and defect. I understand that the law is pretty clear that the court does not have to define mental disease or defect, but you've given them a framework within which to make that decision, which is acceptable to the defendant. There is one reference in there where, if I may, does not include abnormality, only by computer crew. So you say in that sentence, the phrase mental disease or defect is a
Hold on, let me find that.
I'm sorry, it's page 2.
Yeah.
Second paragraph down after that first sentence.
I got
Okay.
the phrase. Go ahead.
Yep, mental disease or defect, in quotes, is a legal term, not a medical term. That's fine. It need not fit into a formal medical diagnosis. Fine. The phrase, quote, mental disease or defect does not include abnormality. This is what I'm just looking at. Characterized only by repeated criminal conduct. So number one, I just would suggest, I don't think we have repeated criminal conduct here. I'm just wondering if it might just be a little confusing. It is for you to determine, in light of all the evidence, whether defendant has a mental disease or defect. If the Commonwealth has proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect, Commonwealth has satisfied its burden of proving that defendant was criminally responsible. So I understand and have no problem with, I would think, all the way from it is for you to determine. My only question is in reference to that where you put in the phrase about mental disease or defect does not include an abnormality characterized only by repeated criminal conduct. I don't think that that's based on the evidence, so it might be hypothetical, but I just will not have that in. Next paragraph, if the Commonwealth has not proved to you beyond a reasonable doubt defendant was not suffering from a mental disease or defect, then you must consider whether, as a result of mental disease or defect, the defendant lacked substantial capacity either to appreciate or the wrongfulness of conduct or conform. That's a fair statement of the law. To establish that the defendant had substantial capacity to conform her conduct, the Commonwealth must prove beyond a reasonable doubt that any disease or defect that may have existed did not deprive defendant of her ability to behave as the law requires, that is, to obey the law. And then you do indicate that that would relate to the word appreciate, understand, more than merely to know, and then criminality, and then you do get into means the legal significance of conduct, and wrongfulness means the moral significance, which is fine. I would ask that on the next paragraph you add in before wrong in the second sentence, Commonwealth must prove that the defendant knew and understood that her conduct was illegal or it was, and I would ask that you put in there morally wrong in front of wrong. And then the rest of that paragraph is fine from my point of view. Last sentence, the court notes, defendant must have been able to realize in some meaningful way that her conduct was illegal or wrong. And again, I would just ask that you would insert the word morally wrong. That paragraph is fine. Roman numeral 2. A defendant's lack of criminal responsibility must be because of a mental disease or defect. That's fine, but then the court says all that you need to determine, and I just would ask respectfully that you delete the all that you need to determine. It seems to kind of, and I know that's in some of the instructions, but I think it kind of dilutes the gravity of the issue for the jury. It's almost minimizing the burden for the government, and it's unnecessary, so I would ask that that go out. And then you could say the jury has to determine the issue and then go into the rest of the instruction as you put it, rather than saying all you need to determine. Further in that paragraph, where defendant lacks substantial capacity to appreciate. Again, that's appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the law solely as, okay, voluntary intoxication. Believe it or not, after 5 weeks, I think we agree. I would ask that the court not instruct on voluntary intoxication. I appreciate the fact that looking at the model charge, and I know when Your Honor is using that as a guide, they do make reference to voluntary intoxication. I just don't see that there's any evidence here of voluntary intoxication that would trigger a pre-existing mental disease or defect. I don't see that there's any issue, such as a lot of the cases, as you well know, when you're dealing with a defendant who's
This is going to be an all or nothing now.
Or smoking weed. I know the case, the recent case of Commonwealth versus Aldo Dunphy, D-U-N-P-H-E, is a guy that had a marijuana psychosis, dependency, and we don't have any of that here. We just have prescription medications that were provided to the defendant. So I would ask that the court not reference voluntary intoxication. I would ask, going down to Roman numeral.
So would you ask, so Roman numeral 2 on page 2, not give?
Yes.
And Commonwealth, that you would be in agreement with that?
Yes, but I think like 2 also follows with Roman numeral 3.
We got to 3. So I want to make sure that, I just kind of want to make sure as I'm going through this, it's kind of dense, you know, as am I sometimes.
Yeah, it is.
So I just wanted to make sure. So Roman numeral 2, both parties are of the position not to give based on the evidence as it's developed.
Correct.
Okay.
Yep,
All right.
thank you.
I'll consider that. I'll strongly consider that.
All right.
And then, so that takes us to paragraph 3.
In paragraph 3, if I'm not mistaken, I did skim it pretty quickly. I think it does also reference voluntary intoxication. And here you're specifying prescription drugs, and if the defendant knew or had reason to know that her intoxication would trigger or intensify a mental disease or defect. I don't think that the evidence supports that. I agree with the Commonwealth. I would ask that Roman numeral 3.
All right. So by agreement, nobody's requesting paragraph 3, and I'm highly likely not to give that.
All right. 4 is fine, Judge. Roman numeral 5.
4 goes to the same thing. It's just a reiteration of the Carnot. So if
Yeah,
we're
so that would
saying-
go out. Yep.
4 is kind of a trailer to 3. Okay.
Roman numeral 5 is okay. Paragraph 3, 4. Okay, so again, if I may just say, without skimming them now, anytime it's referencing voluntary intoxication, maybe that could be deleted. Because I see in paragraph 4 on Roman numeral 5 on page 3, it does reference again for voluntary intoxication from prescription drugs and that type of thing. So that would go out. Paragraph 6, talking about in the event that the defendant is indeed acquitted by reason of lack of criminal responsibility. I know the court has the obligation to instruct the jury as to what potential ramifications would flow from that. I believe that's a fair statement of the law. Instructions on murder in the first degree, deliberate premeditation, cruelty and atrocity, those are all fine. Second degree, that's fine. Involuntary manslaughter, I do think certainly the facts as presented and the evidence does justify the instruction as the court.
Let me hear you. What's the argument in regards to the involuntary manslaughter?
Well, the argument regarding the involuntary manslaughter is clearly that the defendant intended the conduct that resulted in the death of the deceased, and the conduct in the event that it was not such that her conduct was as a result of her suffering from a disease or defect, intentional, premeditated, and intended to be cruel and atrocious, that would reduce it down to manslaughter, and it would most certainly be wanton or reckless. I will be addressing voluntary as well, but I think it's clear that on the evidence that if the jury determines that defendant committed an act, defendant, as a result of the act, the victims were indeed died, that there's a high degree of likelihood that substantial harm would result to the individuals as a result of the defendant's conduct, but yet we're not talking about a disease, a defect that rises to the level of not guilty by reason of lack of criminal responsibility. You would then revert to, or default, if you will, to the standard of wanton and reckless conduct. And we know that wanton and reckless conduct under the Lansky case, basically if a defendant does an intentional act that is not just negligent, it would have to rise to the criminal standard or the criminal level of being wanton or reckless. So I think that that would, in fact, justify an instruction on involuntary manslaughter. If you want, I can continue with the voluntary manslaughter that I would ask the court to instruct. And that would relate to the issue of diminished capacity. I know the court is very familiar with Commonwealth versus Gould. I believe it's 300 Mass 672. Supreme Court decision, Patterson versus New York, that talks about evidence of a defendant's emotional or intellectual or mental state of mind that does not rise to the level of lack of criminal responsibility, but it could certainly rise to the level of extreme emotional disturbance, that would be manslaughter, not murder. And that would be under and consistent with the United States Constitution as well as the Massachusetts Constitution, because in addition to Commonwealth versus Gould, we have case law, as I'm sure I know your Honor is aware, that talks about diminished capacity. It talks about mental disease or defect. If in fact there's evidence of a mental disease or defect, mental impairment, but it does not rise to the level of lack of criminal responsibility, then under all of those cases I just cited, plus Garabedian at 399 Mass 34, as well as my old case of Thomas Toolin, 490 Mass 698, you can have evidence of mental disease or defect that does not rise to the level of lack of criminal responsibility, but it would mitigate or reduce from the ability of the person to know that what they're doing is in fact cruel and atrocious, to know what they're doing does constitute premeditated malice, a forethought. We all know what the concept of malice is. You get the three prongs of malice. There's no doubt that mens rea is important on the concept of malice. And if a jury says, well, look, the evidence is that she was going to these doctors, that she was getting prescribed medication, she was taking the medication, she was in a postpartum depression stage. I don't buy the postpartum psychosis, but I think that clearly she was over-medicated or had medications that she was involved with, plus her postpartum depression. That would then justify them to say it reduces her ability to think, to react, to know as it relates to malice, which under those cases I cited would reduce to voluntary manslaughter. So that would be voluntary manslaughter. The willful wanton conduct would be involuntary manslaughter. Reasonable doubt obviously is fine. All the rest of the instructions that you gave or that you would give are fine. I would ask that the court consider the prospect, and by way of considering involuntary intoxication. And I did cite a couple of cases, Commonwealth versus Wallace and Darsh, Piantadozzi, as it relates to evidence of involuntary intoxication. And that would apply if in fact there's no intentional ingestion of cocaine or some type of illicit drug, but in fact it's a prescription drug that she was ingesting consistent with the drug instructions, if you will. You know, the drug laboratories and the pharmaceutical companies, they market these products. Some of them have black box warnings on them. We've talked about that a little bit in this trial, talked about the age cutoff, but nevertheless, it's scary stuff. You're talking the selective serotonin uptake inhibitors, you're talking about tricyclics, you're talking about antipsychotics. So if in fact this young lady did not have a disease or defect that rose to the level of lack of criminal responsibility, but as a result of the drugs that she was prescribed, not abusing, not mixing with illegal or illicit drugs, that would allow a jury to determine that it would be manslaughter based upon the involuntary intoxication. And finally, I would ask that the court entertain giving a Baden charge in this case. We know that the case law under Commonwealth versus Baden allows the court, upon evidence presented to a jury, of inadequate police investigation. Because if you recall, way back in the day on this case, I did move for a bifurcation, and my argument to the court was that defendants in lack of criminal responsibility cases are really hogtied, if you will, because to have the lack of criminal responsibility, you have to admit involvement in the crime, but yet when you're trying the case with lack of criminal responsibility, the government still has the burden to prove to a jury beyond a reasonable doubt that the defendant is guilty of, based on the evidence, that particular crime. And if there's evidence of a police investigation that is deficient, a jury does have a right to consider that as a basis of an acquittal. They can consider that for purposes of finding reasonable doubt based upon the lousy investigation. In this case, it wasn't just a lousy investigation. It wasn't even an atrocious investigation. It was no investigation. In this case, Judge, the police, I think we all would agree, even the government, they basically accepted the fact that she strangled the kids are in the basement, she's guilty, and we move on. They didn't investigate anything. They didn't test the screen. They didn't even take a picture of the screen. They didn't see if there's any blood on the screen. There's no crushers for the alleged crushing of the medications. There's no indication that there's powder that she was crushing the medication to ingest the medication. There's all sorts of questions regarding the blood spatter, the blood. The police never investigated. They come into the court, they talk about their investigation through the crime scene laboratory and state police. And every question that I would ask about the door, about the blood drop on the door, about the siding, they come 6 months later or whatever, they take the siding, it's degraded, they can't even test it. I could go on and on and on with the horrific investigation in this case. So I think it would be fair for the court to instruct them on Baden. That's it.
All right. Commonwealth, I know there was one, well, there were two requests I think there were, you may not have been aware of, but I wanted to give you an opportunity to be heard. One is the Baden instruction. Also, one is the voluntary manslaughter. Before I let you do that, if I'm looking at the instruction that I have as a possible instruction regarding involuntary manslaughter, Mr. Rankin, if we took the word involuntary out of there, doesn't that instruction there apply to the argument that you're making, considering the last paragraph?
I'm sorry, which paragraph?
Yeah, up on page 8.
Okay.
We're talking about the manslaughter instruction.
Yes, I do.
It's in the last paragraph, it talks about the ability to consider evidence from either a mental impairment or consumption of prescription drugs.
No, I agree with that, Your Honor. If we were to fashion that, I think that instruction would.
So just one instruction.
Voluntary, involuntary, it doesn't really matter.
That's what I wanted. That's kind of what I was thinking, just to go.
I agree with
If I give it, it would just be one instruction, and I wouldn't name it either involuntary or voluntary. It would just be if I give that. Okay. All right. And I think Trudy Buckingham, I don't know. I know the Commonwealth objects to that anyway, so I'm not asking for the assent on that. But what about the Baden instruction?
So, Your Honor, we would object to the Baden instruction. Again, counsel is free to argue whatever he wants about the police investigation in this case, but as far as failures of the investigation that had been identified in the course of the trial, I don't see if there is any. And everything that Attorney Reddington just said about what they didn't test, they didn't test the screen. Well, there's clear photographs of the screen and the condition of the screen, and that was very apparent. That was done on the day of the incident. It was documented. Witnesses testified about that. Witnesses gave statements about the window in and of itself. The blood on the outside of the house was observed. There's been adequate testimony about why it wasn't swabbed on that particular day, and there also has been adequate testimony about subsequent decisions to go back and get information or get the swabs from that area and what testing was done, and if there was testing done to identify that it was the defendant's blood that was on the outside. So I think that the evidence, the claims have been made, but the evidence shows that there has been an adequate police investigation. The only point of contention appears to be the drawer and the pill bottles, and there's been some claims made about things that were not done about those things. But again, I think there's been adequate testimony about why those things weren't flagged on that day of the incident. Police weren't aware of the fact that there was actually an ingestion of medications on that particular day. And when they did notify, or when they were aware, we had prescription bottles that were provided by Patrick Clancy, but those bottles in that drawer conveniently never got produced for testing or further analysis. So I think, again, he's free to argue it. I don't think it rises to the level of an instruction. And just to kind of as a side note on a comment about involuntary instruction, I don't think there is a one. So I would ask that the court not consider that, because I don't think there is an actual instruction about it. Again, counsel's free to argue that in the form of intent, in the form of whether the Commonwealth has met its burden regarding criminal responsibility. But as far as I can find, there's no particular instruction on that. And if Your Honor were to provide an instruction, then according to the case law, if it's raised to that level, then we would have the burden of proving voluntary consumption, which would put all of that back into play that we've now just agreed.
All right. Well, I am going to give a manslaughter instruction in line with basically what's on page 8. I am not going to give a Baden instruction. The defendant is free to argue that any deficiencies that he feels that are in the investigation, certainly free to argue. I will not give the voluntary intoxication instructions in regards to the criminal responsibilities. So I'll have a better draft in the morning, but I just kind of wanted to let you know what the instructions are so that you can prepare your closing arguments. In speaking of those closings, how much time do you think you may need on that?
I'm usually pretty quick. I would say half hour.
I was thinking more of an hour.
All right, I was thinking of all the testimony, all the exhibits. If the parties want an hour, you don't have to use it all. And like I said, I've seen all three of you try cases, so I know you'll be making progress. So if it gets to 1 hour and 1 minute, I'm not going to push the button. So just so we can kind of have some estimate. All right. Anything else we need to address, you think, before tomorrow?
No, thank you.
All right. Well, Counsel, again, thanks for all your efforts in regards to this. So I'll have a full copy of this first thing in the morning, and we'll do arguments in charge, hopefully as soon as we are ready tomorrow morning.
There is one other minor matter that we've talked about. There is that police report, the security sergeant from the hospital, Brigham and Women's, that we're going to redact and just reduce to like a paragraph. She's the one that I summons, but she's on maternity leave. And we could introduce that, just that one paragraph. And we're missing one exhibit, which is the Infants Hospital in Rhode Island, but we're going to look and see if the government has it.
We don't have it. I thought that, we'll double check. I thought that defense had decided not to put in anything from that report because he was going to provide a proper, not a proper, I'm sorry, a proposed stipulation for that portions of that report, and then he didn't. So I didn't think that, and then we both rested, and then I rested again. So I didn't think that was coming in, but I'm happy to look over what defense is wants to stipulate to.
All right, so why don't we do that? If there's a need to technically reopen the case so that the parties could put in what they thought they put in, if it's by agreement, if it's just in regards to some of those records, I think we could do that. So, anything else?
No.
Oh, how about redactions? That was the other thing. Was it just that one report, a couple reports we're going to have to deal with?
I believe that everything that required redaction has been
Okay,
redacted.
all right.
So, yeah, I'm not aware of anything we have.
All right, I'm just asking. All right, so thank you very much. We'll see everybody tomorrow morning. All right, thank you.
Court, all rise.
Let's watch them leave the court. Well, that's it. We're going to the seal. We're not going to get to watch them leave the court. All right, let me put myself on full screen here. Okay, so you just heard that there was a little bit of backtracking in terms of, I really think, quite frankly, that this whole idea of the drug intoxication may have been a sideshow that Kevin Reddington had the prosecutors take. Okay, it implanted everything in the minds of the jury, but it really was to try to get an involuntary manslaughter and maybe a voluntary manslaughter. And you heard him arguing that, which he's going to get apparently. All right, so there we go. And then we're going to have the not guilty and the whole not guilty. Now, what he was arguing with the not guilty was he wanted what's called a Baden charge in Massachusetts. Now, I have it pulled up. It's a charge that's been around for a while. And let me read a little bit of it to you. And he's not getting it, but he's free to argue it. So here's what the charge would have said from the court. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence when presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the tests and other actions. If you find the omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give the matter whatever weight, if any, you deem appropriate based on all the circumstances. So you heard that the judge is not going to give that. That's almost like a jury nullification charge. Why? So if they find that there were tests that would have helped them in finding what really happened and they weren't given, then they can give it whatever weight and they can use it in whatever matter they have. And, recently that focused on the crushed pills that the Commonwealth keeps saying were beside her bed. And therefore that indicated she knew what she was doing and she had a motive and, the blah, blah, blah. But we don't even know whether the crushed powder were pills. We have no idea. She said she was drinking lemonade. It was a lemonade powder from one lemonade packs. Was there other lemonade found in the house? Did they have lemonade? Patrick, in his interview, said it was wine, and therefore their experts said, well, she was lying. So he's going to argue that they didn't even take, they didn't take the screen. They didn't take pictures. They didn't take pictures of the blood. They didn't do any thing on the doorknob, and he's going to argue that all those goes to the issue of how this whole well, I shouldn't say mess, how the whole homicides happen, all 3 homicides happen, when they happen. And therefore, that police investigation would have told you she was out of her mind. And therefore, you can actually use that in mitigation, and you can actually use that in justification of giving a not guilty verdict here. So he's going to be arguing that, even though he's not going to get a jury charge on it. Michael Bryant, welcome. I just read the Baden charge, which is not going to be given, but you know you're going to hear it argued. And so I just read it. It's only a two-page, 1 paragraph page in Massachusetts. I just read it to everybody, and and you know that Kevin Reddington's going to be arguing that pretty.
Of course.
How dare they come up here and argue that those are pills there, and say that she's lying because they don't even test them.
Yeah, and we we knew that was coming, and he set that up to a degree with the very last witness. But I knew they weren't going to get that charge. No way, not in this case. There's just not enough to play with. But yeah, some good arguments. The thing is, it's not a whodunit. So to what degree does that lack of investigation relate to her condition, her knowing her actions were wrong or not, mental disease or defect, capable of conforming her conduct? It really is irrelevant. It really is. It's nice dirt. It's nice dirt.
It's nice dirt, given the fact that the prosecution walked into it. They have so prevaricated and misled this jury on a number of things. The jury could say, "Hey, they've misled me on a number of things, and why didn't they test that if that's what they were going to argue?"
Yeah, I got you. So let's talk about what we've chatted about. From the very beginning, it's kind of been ignored by virtually everybody else, and that was the importance of this involuntary manslaughter and involuntary intoxication. Well, the judge, and I got to pull this instruction up, I'll look at it tonight before we come back at 6, paragraph 8, apparently built into the manslaughter charge. And now we know there's going to be second-degree murder, and there's going to be manslaughter on the
and both involuntary and regular manslaughter.
Well, the thing is, it's one. It's all in one
charge, right?
That's why I want to pull it up and look at it. But apparently, there's a sub-paragraph that specifically relates to prescription drug use. So, as opposed to illegal drugs. So and the penalty, as I recall, the penalty or the range for involuntary versus voluntary, just manslaughter, is still total discretion of the judge. No minimum required, and it's up to 20 years max. So that's in there. It's in. So we'll see how that plays out. I'm telling you, in terms of a compromised verdict, I see that far more likely than a second degree. So and I think so does Kevin Reddington, and that's why he's wanting it in there, and that's now it's in. So that was the biggest takeaway, and that's what I was expecting was going to happen in this conference. I was surprised the judge actually just told us what's going to happen, and here's the deal. The only thing they didn't talk about was the verdict form, but we now know, just because they didn't talk about it, it's going to be 3 counts of murder or not. I mean, they're not separating out the victims. It's either or, it's all or nothing. So, and I see why they did that, but I thought there might be a discussion about it at least, but there really wasn't.
And there may have been discussion and emails back and forth, but not on the record here.
Right. And they did confirm, as we reported, the 1 hour time limit.
We've been reporting that from day one. You know why? Because we have experience trying a case in Massachusetts with a murder case, so we know what the rules are.
And we've kind of followed a couple of cases that were high profile, and so I don't know who came up with the 30 minutes. Maybe they were just thinking of what Kevin Reddington said he could do, and he said again today, I'm thinking 30 minutes.
Right. And the prosecutor said, "Oh, we're going to be an hour," which means
we're thinking more like an hour. Yeah, and even if you think about the openings, which we've gone over in some detail, and I'm telling you right now, if you got a moment, now's the time to rewatch those openings. We prefer you do it through our Justice Serve TV representation of those openings, but now's the time to go through those and see what worked, what didn't work. Kevin Reddington was the longer of the 2 openings. The Commonwealth was 21 minutes, I think, and he was about 35 minutes. So, we'll see how it shakes out when it comes to the closing. There is so much stuff to
Let me just, while you're getting here, where you're already getting to your note, just 10 joules from Leah 7899, a floating heart. Thank you very much. And then I think we even answered this question. Will raising the idea of poor police investigation help on appeal if that goes that route? probably not, probably not. And high five, 100 joules from everyone has been, Jennifer Hipsky, everyone has been interesting. And this one, Michael, we didn't answer yet before we went to lunch. Did Lindsay hear? This is from Laura G, 55174. Did Lindsay hear the voice before sending Patrick out or after he left? I believe it was after he left, right?
That's what we're presuming. Remember we talked about the call in the context of where it happened in her thought process and in her actions,
right?
Because we don't know. We are assuming that it was, normal conversation, hang up the phone, and then the light switch flipped. I still think if there was ever evidence that the switch had flipped prior, and then she was in such a weird psychotic state that she could handle a normal phone call in the midst of this chaos, that to me suggests psychotic. But nobody knows for sure when that happened, except the time, not in the course of events. We don't know when it happened.
But it happened. And then this one, what will happen if a hung jury? Will there be a retrial? Yeah, probably likely. This Commonwealth not letting go.
We're in Massachusetts. Yeah,
we're in Massachusetts. Okay, so what happened in the courtroom just now? There was a lot going on. It was like an all or nothing at some point.
Well,
right?
I will tell you that Homer Achilles was there. That's the dog. Homer Achilles was there watching it all unfold, laying out. You know how dogs will lay out, on the ground, all their paws kind of out. Not all dogs can do that. Like their rear hips kind of spread out sideways.
Right,
Not all dogs can do that.
That's right.
Well,
so I did hear something. Please explain. This happened first. He said, we agree. Kevin Redding says the Commonwealth and I finally agree. We agreed no involuntary intoxication. Talk to us about that. That was the first thing.
Yeah. And first they talked about in the context of voluntary intoxication. And then they morphed from that into involuntary intoxication. Obviously, the key difference is you generally look at these in the context of illegal drugs, alcohol, not prescription drugs, right? And the Commonwealth's position really was, well, we don't think it should be given because at the time of the incident, she had nothing in her system. And that's why they asked for that one extra. They said, if you're going to give that instruction, I think I wrote down, they wanted to add on the day of the events. They wanted to add that to the instruction. We'll see if that happens or not. I don't think they're giving that instruction based on what he said, the voluntary intoxication. The other thing that I don't think he's going to get, give me your take on this. Kevin Reddington wanted to add the word morally wrong about 3 times in the different instructions. I don't think so.
I don't think he's going to get that. Although one could argue, he could argue that why are cases reversed, Michael Bryant?
Yep. What is the number one reason?
Jury charges.
Yeah.
And he could argue that if I were him, I would argue that is almost like a curative instruction to what happened in the courtroom. So we have to make a distinction that you can find things that are morally wrong. Massachusetts has that moral certainty, by the way, in their charge. You have to find guilt beyond a moral certainty. Right. It's a kind of an interesting issue, isn't it?
It is. They do sprinkle the word in there, so it's not unheard of. I would just be surprised.
I would just be surprised.
He didn't say anything from the bench either way, but I would be surprised.
I'd love to ask Michael Del Signore, our resident Massachusetts lawyer. Yeah, and maybe we'll give him a text. Hey, Michael, what are you doing tonight?
Send him a note.
Send him a note from us.
I thought the Commonwealth's attempt. I mean, they didn't have to do much to win on the Baden issue because of the nature of this case. It's not a whodunit, but to argue that, hey, they took pictures of the screen. Hey, they had pictures of the nightstand and the drawer, which is now, the whole drawer is sitting there in court, not just the bottles from it. The whole drawer from the nightstand is sitting there. We didn't look, but eventually Pat Clancy brought us a bunch of bottles. I mean, it was just so lame that if in any other case where the investigation was more important, that would be pathetic.
All right. Well, I mean, the whole drawer was sitting there because it was that drawer that Kevin Reddington found the Apple Watch in weeks after there had been an
with
investigation.
Patrick Clancy.
Yeah,
they were both at the house.
Right.
So anyway, I think it's very interesting, the whole manslaughter issue. It changes my thought process slightly from more likely hung than anything to maybe that lesser compromise is now, in play.
Do you think that Kevin Reddington is reading the jury as they want to compromise?
I
I
don't
mean,
think so.
you and I have been, we, and our viewers, maybe we live in a different universe, that this should be a not guilty by reason of the fact that she couldn't morally conform. She couldn't, you've got me using the word morally conform her conduct, but he's got to hedge his bets. He's got to make sure she's protected, right?
Yep. That's, I
God
think,
forbid.
the only thing driving him. I don't think he's gleaning anything from just looking at this jury, and he's been doing it way too long to be dumb enough to make assumptions. I think he's just saying, I got it. This is the best way to represent my client. And obviously, I hope they don't pick that. Hope they pick the not guilty. Either of the two not guilties. They get a straight not guilty is also an option.
That's an option, right? They may decide to be so pissed off at the way, juries get pissed off. I mean, just like I was pissed off at the way the Commonwealth seemed to lie and prevaricate, not tell the whole truth. And we saw it. They changed their tune all the way through. But this is an interesting question that Amy Loves Soccer has, and goes to what you just said. Do you think the police did not investigate because
Where is that?
they
Put
were,
that up there so we
I'm
can
going
see
to put it up right now.
we
Did
go.
not investigate because of laziness or because they didn't believe it would go to trial. We heard about that huge police presence, and thank you for asking that, Amy Loves Soccer. That huge police presence, right? They had to get search warrants. They had to do this. They had to do the other thing. Maybe they didn't realize that they thought that she was going to die, and therefore why bother with anything further once she's there? Maybe that was what happened.
I think that's as good a guess as any. I also think that they felt that the case, people have made all kinds of comparisons to the Karen Reed investigation, right? That they railroaded Karen Reed. That's why they didn't do anything close to a real investigation. I don't believe that was the same situation going on here. I don't think there was any intent to railroad Lindsay Clancy. They felt that the facts as they saw them, and effectively her admission, not a straight confession, but pretty darn close, that was all they needed. So I think it was more laziness than intentional. I think in Karen Reed, it was intentional.
Right. That's maybe the difference. This is kind of an interesting, let me just put this up. It goes to show you we're making a progress here. And as soon as everything is going so quickly here in terms of people are commenting. Let me put this up. I'm really glad that people are listening to Dr. Gregoire, but she was later correctly diagnosed as bipolar. Dr. Gregoire said half will get postpartum psychosis. So you picked up on that. You're absolutely right. That if you, maybe she had a bipolar in there, and that would get the postpartum psychosis, and that it was sitting there, and that it wasn't that it just came upon her. It just came upon her, but it had been stewing, and maybe she had elements of psychosis all the way through that people ignored. Because boy, was she a candidate. When we learned just yesterday that she had been on medication in nursing school, that told me that she had issues, right? Now, of course,
she did. Anxiety, and she didn't like to speak in public or be presenting or whatever. She had 75% of all people would rather die than public speak.
Yeah, they'd rather not. They'd rather not
public.
Speak in public, right? Or public speak. But it is interesting. But the Commonwealth is using it against her, like, well, she never tells the truth to anyone, including the person she was dating. I thought that was ridiculous. It just told me that if Dr. Gregoire were evaluating her, somebody who really knew what they were doing, they would have gone through all sorts of stuff, and maybe they did. We don't know what she said to the doctors on the forms that you fill out. And remember, you have when you and I get prescriptions, right? And we go to the next doctor, they look it up at our pharmacy, and there it is, 10 years worth of prescriptions.
That's true.
Right?
Yeah.
Yeah.
And there's a national, it's a required registry. Yeah.
Right. So, maybe they did know the issues and just didn't deal with it right. But anyhow, I digress from the jury charges.
Yes. What's my read on the jurors? They're all fine, upstanding citizens doing their job. I mean, there are some that are far more inquisitive about what's going on in the courtroom. Handsome woman. Somebody asked me, why do you keep calling her handsome woman? It's actually a compliment. So yeah, it's sometimes when a person gets to a certain age, female, handsome is a descriptive term. It's very positive. What's that? No, that's true. It's you wouldn't call a teenage girl a handsome woman. I'm sorry, you wouldn't.
I wouldn't call any woman a handsome woman.
Look it up. Look it up.
I can look it up all I want, but as times change, sometimes the usage of words can change.
Is handsome a negative word?
I think that not necessarily, but also
Okay.
I wouldn't want to be called handsome. I would think that would be an insult.
Yeah, it's an endearing term. Don't make it anything
It's like
worse.
unk. It's like when you get the
Uncle
the little
alerts?
things for the uncle alerts.
Yeah, I take that in stride if that's what the intention was. I don't know. Anyway, so
The parents are arguing again.
she's by far the most inquisitive in terms of what else is going on than what's right here in the jury box. I mean, every day, no matter what's happening, she's effectively taking attendance. Who's here? What's going on? Let's see. I'm trying to think of the other. Dapper Dan is no more active or less active. I always just key in on him because it's from day one he's been dressed sharp and sharply, and it was the same today. So I find that fascinating. Is that because that's the kind of guy he is, or does he take this seriously enough that he thinks he needs to dial up his normal sartorial choices? I don't know.
It's really interesting because most of the juries that I see anymore, people are dressed, and we saw the footwear in Florida, right? People are dressed really casually. They dress in, not that jeans are a thing, because jeans are high fashion right now. But they're really dressed casually
I would
until the
say
day of verdict.
This group, that'll be an interesting comparison, because this group is dressed very nicely every day. I'm not even seeing like jeans and an untucked shirt. I mean,
How
really?
are we going to tell if they have a verdict then?
Yeah, you're right. Maybe
verdict
they'll all be wearing sweats because they know they're going home. I don't know. Yeah, no, they have on balance been very well dressed. A lot of the women wear dresses. None of the guys do, but hey, that's all right. No, I've been surprised that they've all been very well dressed and beyond what I would expect as a group. You're always going to have those that are dressed nicely in general, but all of them. So, for whatever that's worth, and we'll see what happens tomorrow when they are whittled down.
Oh boy, that's I wonder, that's always a time when you are a defense attorney. If you think you have certain jurors with you, let's remember what closing statements are, and we'll talk a little bit about it tonight. Closing closing arguments, closing statements. I'm using the word statement for a purpose, even though it's an argument. All right, because you're going to make in your argument different statements that can be used for the people that are on your side, and you've identified them. You try to identify who you think's on you. Oh, well, but we know maybe one or two. Let me tell you, and you know that too. You can always try to find one or two that you think they're following you. They get a little nod. You get a good feeling from them, and so you're giving them, even if you can't identify, you're giving them the statement that they're going to argue with. All right. That's why I was making a distinction against the other side, a person who may disagree with you. And that's what closing arguments are about, is giving little statements that people can then use to argue the other side, another juror who may be against you, to argue your client's viewpoint. And let's remember, that's all closing arguments are about, by the way, everybody. It's not about this grand scheme, because if you don't have your person by now, you're not going to get them with a closing argument. All you're going to do is give the strong people that are on your side the arguments through these statements that you're going to be making in your argument to argue for you.
And that I'm sure you've talked to your jurors from past trials, as I have, or from cases I've covered as well. Very seldom do you find somebody that says, I was just totally on the fence, 50-50, and the closing argument pushed me over. That's just rare.
It's rare because they have a certain bent. They don't have their minds made up, but most of them have, I think it's 60% at least, have a certain bent after the opening statement, which many times is really more like an opening argument.
Oh, yes. If you're good, if you sprinkle a little argument in there. Okay, Paula, thank you. Handsome seems elevated, beautiful to me. There you go. It's a good thing. Wait, we got more. Oh, wait, there's more. Great, there's more. Handsome, having a pleasing and unusually impressive or dignified appearance. See? Come on. Admit it. Admit it.
No, I'm not going to admit it, because in the vernacular,
that's clearly a
when
definition
you call
from
somebody's
somewhere.
name, you use it for a man usually, or a woman who has a very handsome
You gotta,
in terms of the clothes sartorial she's wearing. But you say handsome, that's a very handsome suit. That's a very handsome beard, Michael Bryant. That's a very handsome haircut. You don't say to me, look at my haircut, and say, Linda, that's a handsome haircut.
No, it's very specific. It's a very dignified kind of sophisticated look. and you can attribute the word to a woman, and it's a total compliment. So
Okay,
expand your
so
horizons. Come on.
we need to answer these two questions. I'm going to put them up sequentially. Can you go over the manslaughter, please? And number two, what are the charges so our viewers understand what's being given? Okay, I'm going to let you take you were in court. I was just
Well, we
watching.
know it's going to be the traditional first degree. That's a premeditated act. And then we'll have second degree, which is kind of a wanton, reckless level, one notch below. So the level of mens rea is different. Okay. And obviously the penalties are less. We haven't talked much about that. I'm trying to remember if I'd looked that one up recently or not. But with first degree, it's possible life without possibility of parole. That's the max. Yeah.
And in any other case involving the intentional death of 3 kids, we would definitely be talking about that more. But this case has an overlay to it. And I know there's people on the internet who are just like, she killed the 3 kids, she's got to pay. And we may have jurors that feel that way. You know?
You're right. You're right. So then we get to the manslaughter issue. And it is a little squishy with voluntary versus involuntary. The judge is going to give a manslaughter charge, which equates to 2 different things: wanton and reckless conduct, or extreme emotional. I'm sorry. Whoops. Let me read that again. Yeah, wanton or reckless conduct, or where did I put it here? Doggone it. I wanted to get the exact language from the instruction, and I don't have it. Doggone it. Obviously, it's a lesser number, but it's wanton and reckless conduct. The intent element doesn't exist, but it's the intent to do the act that results in the deaths.
Right.
But the important note here, and that this is going to be argued by Kevin Reddington, and that is that her emotional disturbance mitigates any of the top charges to manslaughter.
It's
So
kind of
even
like an extreme emotional disturbance in New York. It sounds like, except that the burden of disproving it, I assume the burden of disproving it is still on the prosecution, Michael.
Yes, and they talked about that in the instructions, that when they went through them quickly because nobody was disagreeing with them. And you may have noticed a rare moment where they did agree, where the parties did agree that they don't need the instruction on voluntary intoxication. They both agreed to that. That will not be coming in. So you're going to hear Kevin Reddington obviously arguing not guilty, not guilty, not guilty, either directly or as a result of inability to conform her conduct. But as a backup plan, her mental condition mitigates any of those top charges to manslaughter. He's not going to be pushing that one, but he's going to say that it's in there and it's an option, and you'll see it. And here's why. Here's how you might get there.
Wow. You know, everyone asked before whether or not Reddington has his closing statement prepared. He has his closing statement prepared before he tries this case, and he's just filling it in as we go along, because the way your theme for trying the case has to be set forth in your opening statement, so your closing argument is already done. It's already written. I mean, you may be adding to it, but he knows where he knows where he wanted to go from the time he opened his mouth in the opening statements.
Yeah, I mean, you've got the whole play, first act, second act, third act. You got it all worked out. You may have to modify along the way. People are running with this. I'm not handsome, unfortunately. Maybe homely.
Oh no, no one is
Jeannie Lynn,
homely.
that is not.
No one is
true. Come
homely, and
on.
no one was homely. Really, you're right. None of you are homely. Come on, give me a break. You're all fabulous. Okay. So Alago 1914. I hope we answered that, and also Julia Nelson, Nielsen, not Nelson 94. I hope we answered that. And Michael's going to go over more. He's going to pull the charges up for tonight.
Yeah, I'm going to do that. I'm going to run back to the hotel.
We're gonna let
pull
you
that,
go in a second. Let me just see.
I know that still, everybody's queued up out there for Reddington's departure.
Is that what it is? Okay. So are you going to go do that? So you want to go do that?
I recorded it yesterday, just as a kind of a sociological experiment, just so people could see this is what's going on here. People were listening, of course.
Yeah.
And the questions, like, those are the stupidest questions. I
Yeah.
mean, people were
Yeah, they
not
were.
impressed. They were
Well,
not impressed.
especially, yeah, and I get asked that all the time. What did your client tell you? I'm not going to tell you what my client told me, especially in the middle of a trial. Are you kidding me? Thank you for the 250 joules, a clapping seal, loose seal. We don't know what happened to her. The fact that we don't know what happened to her, I don't think is very good, by the way. They've
Yeah,
never posted on it again.
that's true. And the other reason I don't kind of follow the pack here is I talk to him as much as I want whenever I want. It's not a big
Right, I
deal.
know,
I
I
have
know.
one-on-one question and answer with the
Yeah.
guy, and we
Right.
will obviously after this is over.
Mhm.
Everybody
Yeah.
will be queuing up to talk to him. We'll get him when we get him.
Yeah.
And we'll have the time that we need to take. It won't be a quick sound bite. It'll be a conversation. So
Yeah, and since we seem to be the only streaming channel that really have had the experts on dealing with postpartum psychosis and tried to deal with it as an educational matter in this. No matter what happens with Lindsay Clancy, no matter what happens with her trying to establish that we educate people about this disease, and it really is a disease. It is a mental defect, even if it's not recognized by the DSM-5. Everyone else who is in the world seems to be dealing with this.
Yep. Again, embarrassing that we're behind the 8 ball on this, but we are. So.
We are, but not in this network. We're not.
There you go.
I did put out a bat lamp to Michael Del Signore. Are you around?
Oh, did you see if he can
It's
check in with us?
It's a little late, but he'll check in with us. I mean, he's our local Massachusetts attorney. But the problem is that these 2 weeks are really, vacation weeks. Not that I'm rubbing it in, Michael Bryant, because we're here,
those are.
and we'll see. Anything else that you see? Because we have to be on the air again at 6:00. I have put thumbnails up, by the way. I even put a thumbnail up for like Verdict Friday, just anticipating. I may change the thumbnails, but you can still go and you can still hit notify all to get notified for the time of the show. And you might, so we're thumbnailed all the way through, and we're portaled all the way through Friday morning. Just so everyone knows.
Thanks to Jody Porcius. Thank you. Sorry if you've spoken about this loads of times. I'm new to the channel this week. So glad I found you. Thank you. We do appreciate that. Yes, we do. This is interesting. I'm curious whether Lindsay even cares about the verdict. She will always be imprisoned in her mind. In an interesting way, the way guilt works. And yes, she has shown remorse. We know that now. Maybe she thinks she deserves it. And who knows?
Well, that's when the chaplain Sheila Cavanaugh testified, and there was that whole thing about she was doing well, improving on PT at Spalding, and she said, I deserve this. And we all took it like the prosecution was saying, well, you hate her because she's saying I deserve this. What Sheila Cavanaugh and what our viewers were actually saying apparently was she was saying, I deserve to be paralyzed in the position I am after what I did. I deserve this,
That's
and we also heard from even the prosecution doctor that till this day she doesn't want to be here, meaning she doesn't want to be here alive on the earth.
Yeah, and we know, and she's still 1-to-1. And what happens if she is incarcerated more traditionally? Who knows what that will even look like, or if there is such a thing. In a normal prison, even though it'll have to be a facility capable of handling her needs medically, are they going to be watching her 1-to-1 all the time to prevent suicide? I seriously doubt it.
Yeah, I doubt it too. I mean, that's and even though she does qualify as a quadriplegic because it's from the sternum down now that they classify, she still has use of her hands, and that has to be concerning in terms of her ability to as to why she has that one-on-one view.
Roosevelt Media News, probably not popular opinion, but I agree with the manslaughter charge due to her lack of candor with healthcare professionals about her thoughts of harming kids. Yeah, it's a little fuzzy as to how often she mentioned it, and certainly how often she thought it. I don't know. I don't know if I make that direct equation from her failure to talk more about it, and therefore manslaughter is appropriate. But okay.
Yeah, but you can see in our chat that people do like it in terms of Roosevelt Media News.
I was stuck until the manslaughter charge.
Good move. This could prevent a hung jury.
I do agree. That's why I said if my guess-o-meter was leaning toward hung jury, and now maybe not so much.
Well, except that I think you're going to have people that are really say she had a mental disease or defect. Why,
No doubt.
why did she kill them? And they're going to be, if I'm in that position, that jury, I'm not moving off that position. I'm just
But
not.
remember that that's a given now. Okay, you've got a mental disease or defect. That's a given. Even the Commonwealth experts.
Well,
said
they
so.
fought, but they fought it for the most of the
course,
trial.
because I think part of the reason is because they think if they cave in on that, that the rest of the dominoes will fall. That she will therefore be incapable of conforming her conduct, or she will be incapable of knowing right from wrong. And they're very separate questions. You can have a disease or defect and still know right from wrong. You can have a disease or defect and still be incapable of comporting your conduct. So now that's out there, and the jury's going to have to decide whether, in fact, her mental disease or defect did make her not criminally responsible for one of those two reasons.
All right. Is that it? Or are we ready?
No, I'm just browsing, just shopping.
You're browsing. Well, Michael, we have to be on the air.
I've done this before many times. I'm like, okay, I'll see you in an hour and a half. Let me see.
One of us is tired and has to do some other work.
Okay.
I'm not leaving you. You're gonna call everybody in our chat handsome, and a lot of people are gonna love it, and other people are gonna hate it, and we're gonna lose viewers. And by the way, speaking about viewers, could you all hit that subscribe button? Do you know you have us over 39,300? We have 700 to go. I mean, if everybody who's watching hits that subscribe button, we will make it there now.
I predict that when we get to our 2-year anniversary, we'll be at 39,999.
No, please, no, come on. You guys don't want to put us through that torture. We have to go there now, especially, to bring you all these guests. What are the first thing guests look at? They look at your channel.
This. Breaking news.
Yo, breaking news. Okay,
there you go.
Joy
Michael Dustin-Yor will be here.
Yeah, there he is. Matter of fact, breaking news is this: he just finished the trial himself. Okay?
Oh, interesting.
Could you do 6:30? Okay, you haven't had a chance. Yes, he could be on a 6:30.
Yeah,
right?
we'll shoot the stuff. Until then, I will try and grab those couple of moments. The Jen moment is classic, so I might try and grab that one. We can share that for those. Some people aren't able to sit and watch all day, and our recap, when we can, will include, some of the video moments, some of the handsome video moments. So
we're going to tell him it's murder 1, right? I don't know if it's murder 1. It's murder.
Yeah, it's
manslaughter, murder 2, manslaughter, and not guilty, and not guilty by reason of insanity charges. No Baden. I'm telling Michael, I'm giving you, this is a production meeting right now. No Baden charge. Can we have penalties too? Joy will send link. This is our production meeting, all okay.
Yeah. Well, right. At least we're having one.
Okay. Yeah. At least we're having one. Yes. And Joy, when you send it to him, tell him that it's a different link than the one he had before. We do not use the same link, as many channels do. They have the same link. That's like, I can tell you all a story, that we used to have like this call and conference calls before we had their iPhone and all, freeconference.com, right? freeconferencecall.com. And you were assigned one number. And sometimes you'd be assigned a number and all of a sudden there'll be somebody else popping into your phone call who misdialed the number, but you're in a phone call and they misdialed by one digit and then your number. Or in federal court, by the way, they give you a number. It's the same number. So you could at one point recently in a case I dialed it, and then the magistrate judge was on another case. I immediately hung up, and then when we got on, I said, Judge, I was the one who jumped in. Geez, I'm sorry, that went longer than I thought. But so I hate using the same number and the same link for that reason.
Okay, let's do this. I think, did we do? Oh, what a great channel in chat. You handle opposing views well. Yeah, we welcome all views. I like them to be supported somehow, not just
not trolling. We don't welcome trolling views.
Rant about something without support.
Yeah. Or trolling views. We don't like trolling. We don't like people come in and just nasty about it and this and that. Look, you represent a jury, and if you're able to talk about it, and we're able to talk to you about it, this is just like a jury. We're going to be talking just like the jury room.
Jeannie Lynn, if she did get the manslaughter conviction, couldn't she still stay in Tewksbury. I don't think that's a
No.
Department of Corrections official facility. I don't know how that all works.
It's not. Yeah.
But no, they do have, we know, one lockdown floor, I think it is, where she is. But no, it would have to go to Department of Corrections, and then I need to do a little research on how many Massachusetts prisons have the capability to handle her issues, because I'm sure it's a very small list.
Yeah. Yep. Look,
Okay.
she's in prison. She's in prison, in her both in her mind and
Well,
the
no doubt.
wheelchair forevermore. I mean,
But I
that's
do
why-
hear that Tewksbury is not bad as those facilities go. That's what I hear. So,
Well, they're gonna wherever they have to have her, they're gonna have to have her on. You know, the Bureau of Prisons may not want her. Quite frankly, they'll probably say, "Please
no, she's
let her
no,
be found
she's,
guilty."
she's the
but
pain
not-
in their
but not- right.
administrative asses. Yeah,
Right,
because
right.
she's high maintenance.
She has to be
It's
one on
unfortunate,
one.
but that's the
Right.
truth.
It's the truth,
And
right?
they don't look for these jobs.
Yeah, they may maybe
So-
say, "Please let her be found not guilty by reason of insanity." Please, please, please.
in their
Yeah.
selfish way, yes, having nothing to do with justice or the case. Yeah, just
No,
their
I
own.
think that would be justice served if she's found not guilty by reason of insanity. I mean,
No,
I
I
don't
think
see any
that's-
other reason why she killed those kids and tried to jump out a window and break
No.
their neck.
And people talk about that all the time. The same premise I've mentioned from day one. Moms don't do that unless there's
Yeah.
something drastically wrong.
Yep.
So,
Yep.
okay, you're gonna get
All
your
right.
wish. I'm gonna get out of here.
All right, we're gonna see you all. Hit by the way, before you go, hit subscribe, like, share, notify. Subscribe, it's very there, it's free. Like, share, notify, and then hype. And I'm turning it over to Michael to close the show.
All right.
6 o'clock.
So for the next 95 minutes, please try to do the right thing.